Morning everyone, and welcome to this UK in a Changing Europe conference on constitution and governance. Before I say a few introductory remarks, I think the venue are going to play you a quick health and safety announcement, which is very exciting.
Welcome to the QE2 Centre. Please take a moment to listen to the following safety message. There is no planned fire drill taking place today. And in the unlikely event of an evacuation, we ask that you make your way to the ground floor by the nearest available exit. We've got fire wardens on hand to assist you. If you require assistance, please do ensure your event organiser is aware of this. Please do not stop to collect personal belongings or use the lifts. You are encouraged to now take a moment to make yourself aware of the nearest exit and escape route in your area. Once on the ground floor, you are to disperse away from the centre. There is no assembly point for the centre. You should disperse away from the centre and await further information from your event organiser or on QE2 social media detailing when it's safe to return. Thank you for your attention and please enjoy your event.
Well, I can assure you that was the most seamless part of the day's proceedings. It'll all be downhill from there. But just a couple of words of introduction. Most of you have been to our events before. If you use the QR code on the screen with your phone camera, you'll be able to get onto the Slido, which is what we're going to use for posing questions to the various speakers. That way, the people who are watching virtually will have an equal shout of getting their questions in. So if you want to ask questions to any of our speakers, that's the way to do it. Secondly, just some quick words of thanks to Catherine, to Jill Rutter, who sadly couldn't be here today, and last but not least to Sarah Overton, who both put together the fantastic report that I hope you've all got at least one copy of, because I don't want to be carrying them back to the office after today, and for organising today's proceedings. As ever, if you have any thoughts about things we should be doing at UK in a Changing Europe, things we could be doing better, then please just catch me and tell me about them at any point during today. We're really keen to hear your ideas about the sort of work we should be doing. But without further ado now, I'm going to hand over to Catherine Barnard to kick us off. Catherine.
Thank you very much indeed, and welcome to everyone. It's fantastic to see so many of you here in person and also online. Now, obviously, this conference is about the Constitution and governance. And before we gathered here, Robert and I were talking about the Constitution in flux and whether there have ever been so many challenges to the Constitution, certainly since the Second World War, and some might say way beyond that. Think of all the changes that have occurred just in the last six years. Just to whet your appetite, think about the fact that we've got the Judicial Review and Courts Bill going through, we've got possibly a Bill of Rights, which I think Robert's going to talk about, the Fixed Term Parliaments Act, terminated last week. Did anyone notice? But also think about all that Brexit legislation, not just EUA and the various other permutations, but also think too about all of the big acts that went through as powers were returned to the UK. Think about the controversy around the Internal Market Act, and then just think COVID. Think about the 550 pieces of secondary legislation that were adopted in that period. And that raises a question for our institutions themselves. Think about the challenges. We know that Brexit was about taking back control to Parliament, but has Parliament really lived up to the expectations that were thrust upon it? Look at the executive. Look at the huge powers that have been given to the executive under these increasingly framework acts of Parliament that are being adopted. And then there are the courts, and we're going to hear quite a lot about that this morning. Are the courts overstepping their mark? Are the courts doing politics by another name, or are they simply doing their job? And then there's the union itself. What's going to become of our four nations in the United Kingdom? We know that Scotland and Northern Ireland voted to remain. We also know that Scotland and Wales are very concerned about the implications of the Internal Market Act. Will the Common Frameworks Programme help to ease some of those tensions? And as far as Northern Ireland is concerned, of course, we know the issues around the Northern Ireland Protocol, and also the question about whether it actually operates effectively, whether it's workable to have that border down the Irish Sea. So this raises a question, what sort of constitution do we have? Do we have a constitution of bits and pieces? Or are we seeing, in fact, an increasingly muscular unionism that you find underpinning our constitution, with Westminster very much front and centre? Is it a legal constitution where the courts have really very significant roles? Or is it, as I think Robert has argued, a more political one which still puts Parliament at the top? Now, all of these issues and more are detailed in our fantastic report. I'm biased, but it's brilliant. And if you want to know the state of affairs on the Constitution today, this is the place to go. Some of the best writers in the field have written in a truly accessible manner over these complicated issues. I'd like to thank Sarah again for helping to pull all of this together, to the SRC and UK and Changing Europe for funding it, and thank you to all our contributors for writing for that report. And this brings us now to our keynote speaker. So Robert Buckland QC, MP for Swindon since 2010, Solicitor General for England and Wales 2014 to 2019, and Secretary of State for Justice and Lord Chancellor from July 2019 to September 2021. He's been one of the most thoughtful contributors on the fate of the British Constitution and where we're at today. Robert, thank you very much for your time. The floor is yours.
Thank you very much indeed. Thank you. Well, thank you, Catherine, and it's a huge pleasure for me to be with you this morning to open up proceedings. And I think the first thing we must do is to remind ourselves that we're in the privileged position of living in a mature democracy where free and open debate, despite the navel-gazing of the culture wars, remains possible. Now, the fact that the Council of Europe no longer includes Russia is sad confirmation that the Whig theory of history is misplaced, and that the price of freedom is in fact eternal vigilance. Now, I wanted to use my time before you to further develop what was and has been in my mind ever since I worked to implement the government's 2019 manifesto commitment on the Human Rights Act, which I helped to draft. Updating the Human Rights Act was the phrase that we use. Updating, not replacing, you will note. I'm someone who's long defended the European Convention on Human Rights, but I'm also somebody who's advocated further reform and improvement. Now, my address today is the latest in a line of lectures that have been fleshing out my thinking. It's not an issue that can be dealt with in sound bites or media headlines. I believe that we've neglected the details for far too long, and the debate, frankly, has suffered for it. I've lost count of the times when the European Convention has been confused with the EU treaties, for example. Now, Brexit should at least mean that there is no longer any excuse for that. Now, in my recent Society of Conservative Lawyers lecture, I set out what I regard as a key issue with the Human Rights Convention, namely that a wide array of possible interpretations are going to be compatible but not necessarily required by the text or the surrounding preparatory work known as the travaux of the ECHR. And this, I think, is a problem, a challenge with the Convention. It does not so much set out clear rules that can easily be applied, but rather it enacts values stated at a high level of generality and then instructs states to act compatibly with those values. Now, some of those values clash, and so states are required to strike a fair balance between them. Now, when in doubt, and it is first thing in the morning, it's worth going back, I think, to Thomas Aquinas. As he outlined, there are two ways in which positive laws can be derived from natural law. The first is a simple process of logical deduction, very straightforward, and the second is what he termed determinatio. And he explained it with a very neat architectural analogy. An architect takes a general idea, such as a door, and from there constructs a specific door. Now, it cannot be said that the particular size of the door follows as a matter of logical deduction. Instead, a choice has to be made about its precise dimensions. And as Professor Finnis pointed out, that choice involves, in a benign sense, arbitrariness. Now, in his famous lecture, The Nightmare and the Noble Dream, which I've referred to previously, late Professor H.L.A. Hart argued that in many cases, judges simply apply the law, but in others, they have a discretionary field of judgment and actually have a choice to make about what the law should be. Now, given the nature of the open-ended, the nature of the Convention's text, it should come as no surprise that most of the seminal cases involve not a direct deduction from the text, but rather that process of determinatio. The court decides how to further specify the principles represented in the text. Now, sometimes this takes the form of new rules which do not follow as a matter of logical deduction. For example, the duty to investigate breaches of Article 2 and 3. And at other times, it takes the form of broad standards. But the key point is that in all of this, the court is making a choice which is not required by the text itself. The very nature of the enterprise that the court is engaged in has a legislative quality, therefore. Now, if we were starting from scratch, I, for one, would have wanted us to draft the Convention with a far greater level of specificity. And we have some examples of such specificity in international conventions. For example, the UN Convention on Torture, adopted in 1984, which provides in 16 substantive articles what the ECHR does with just one, namely Article 3. Now, while some of the obligations which the Strasbourg Court has fleshed out from Article 3 are indeed present in the UN Convention, there are differences. And it seems to me that applying the principle that a law governing a specific subject overrides a law of general principle, that's the lex specialis, and using Article 31.3c of the Vienna Convention on the Law of Treaties, which means that any relevant international law rules that are applied between the parties shall be taken into account, then the Strasbourg Court, frankly, ought not to have interpreted Article 3 as going further than the UN Convention. Now, the choice of how to specify the Convention rights is, of course, not unconstrained. A further specification cannot be made if it would contradict the text of the treaty. And not all of the articles of the Convention are equally susceptible to such wide specification. So Articles 2 to 7 are already more specified than Articles 8 to 11 and Article 14. But even that constraint gives, in my view, the court an incredibly wide margin of manoeuvre. What should it do then? At one end of the spectrum, the court could conduct the specification entirely by itself. And at the other end, the court could let the exercise of specification be conducted entirely by member states. Now, in such an instance, the court's role would then be limited to considering whether the specification given by the member state could be said to be within the limits of the meaning that the Convention could bear. Now, historically, the approach of the court appears to have been to conduct the specification itself. But following the Brighton process about 10 years ago, the court now affords greater deference to member states. And as President Spano has put it, we are now in an age of subsidiarity. However, we're not entirely at the stage where the court gives the full power of specification to member states. The scope of margin of appreciation given to states is for the court to decide. It does vary. And that variation is not explicable solely on the basis of the text of the Convention itself. In particular, the court uses the concept of European consensus to widen or to narrow the scope of the margin. So, what are the court's key characteristics? Well, I think there are three key features that we should bear in mind. First, by its very nature, the Strasbourg Court has certain limitations to its institutional competencies. This is particularly so in areas such as contentious moral or ethical issues, economic matters, national security and diplomatic relations. And Judges Petschal and Vicek put it so well, and I quote, "Judicial independence is accepted only if the judiciary refrains from interfering with political processes. If the judicial power is to be independent, the judicial and political spheres have to remain separated." And second, the Strasbourg Court is an international court with jurisdiction over now 46 countries. The diversity of legal, political, social and religious traditions between all those countries strongly militates against taking a one-size-fits-all approach. And thirdly, the prospect of amending the treaty to correct an erroneous interpretation by the court is frankly a difficult one. If the court finds that something breaches the convention, it binds all states. But if it does not, this doesn't prevent individual states from adopting this standard for themselves. So in my view, therefore, the court should continue the process it started at the Brighton Declaration and increase the scope of the margin of appreciation given to states. Furthermore, it should also seek to prune back on some of the specific determinations that it's made in the past and return greater discretion to its members. And in some areas, such as the interaction between the Convention and international humanitarian law, the court has in fact started this pruning back process. Now, sticking to the principle that the best things come in threes, the court's role, I believe, should therefore be threefold. Firstly, it should continue to adjudicate on clear breaches of the Convention, that is, acts or omissions of states that can be established as a matter of pure deductive reasoning. Second, it should give states the widest possible margin of appreciation, which is consistent with the text of the Convention, but it should ensure that states do not go beyond that margin. And thirdly, it can still find that states breach the Convention if the process they took to arrive at this decision was flawed because of a failure to consider relevant considerations or was otherwise arbitrary. And just to develop that third point, to put it in the language of English administrative law, albeit a somewhat imprecise analogy, I concede, the court should construe the text of the Convention so that it gives a very wide permitted field to nation states, the limits of which being decided on a reasonableness test. But within that permitted field, it can still find a violation because of a procedural failing. When considering parliamentary decision-making, it's important to remember the observation by Lord Reid that, and I quote, "Parliamentary methods of resolving disputes are very different from judicial methods," and that, and I quote again, "Courts have to be careful not to undermine Parliament's performance of its functions by requiring it or encouraging it to conform to a judicial model of rationality." Now, to be fair to the Strasbourg Court, there's been a shift away from the court making its own independent assessment of the Convention towards looking at whether the issues have been properly considered by the domestic decision-maker, and I welcome that. But my concern is that some of the principles which the court fleshed out during what President Spano called the substantive embedding phase can cause problems, and indeed would not have been done by the court during its current phase, in my view. Now, to be fair, a lot of these norms are perfectly fine and they're no longer contested by member states. Nonetheless, the court needs to engage in both a formal and an informal dialogue with the states to prune back some of those norms that can frankly cause difficulty. The Convention requires an assessment of whether a restriction on a qualified right is proportionate. That is, does it strike a fair balance? And as the late Sir John Laws pointed out, and I quote him, "There is real difficulty in distinguishing this from a political question to be decided by the elected arm of government." The solution to this problem, as Lord Reid has said, is a strong dose of, frankly, deference, grounded in due respect for the differing roles of the court and of Parliament. Comity is the word that I've often deployed, which is well familiar to many of you. And there are, therefore, I think, there's one first order and there's one second order question. Now, the first order question is, how should the correct balance be struck between the public interest and competing rights? And the second order question is, how wide is the decision-maker's discretion in answering that first order question? Now, since the first order question is frankly political and doesn't have a single right answer, it should be answered by the political branches of the state, or at any rate by bodies under the control of the political branches. The second order question, namely how wide is that discretion, is one for the courts, both Strasbourg and our domestic courts. However, there are some unfortunate instances where courts or other non-political bodies have been required to answer that first order question, and there are two that I will focus on. The first, frankly, arises because Parliament hasn't done its job properly and has not answered the first order question, so that other bodies are required to do so, and I've made this point on numerous occasions. The leading example is the development of the tort of breach of privacy. Under the test as developed by the courts, applying the Convention principles, a court must strike a balance between the claimant's Article 8 privacy rights and the defendant's Article 10 freedom of expression rights. Now, these are two values that do not have a common standard of measurement. How to strike the balance between them is, in my strong view, a political question. This is an area of quite a bit of controversy, to say the least, particularly at the moment. And as a result of those decisions, the courts are thrust into the limelight. It is not fair, frankly, to ask our courts to strike that balance without any guidance from Parliament. Now, of course, I concede that it would be unrealistic to have legislation that sets out rules that cover every possible permutation. There necessarily will be a certain amount of discretion. But there's a difference between court discretion that is bounded by factors identified by Parliament and an unbounded one in which the court is asked alone to strike a fair balance between two important rights. Now, I note that the government's human rights consultation wants to strengthen freedom of expression vis-à-vis privacy, but it seems to me that the best way of doing so is to legislate to say precisely in what sort of situations the privacy interests will outweigh the freedom of speech ones. And we've got a good example of Parliament legislating to provide a scheme which balances the public interest and human rights. And that's the good old Police and Criminal Evidence Act of 1984, an act which I became very familiar in my criminal practice. Take detention prior to charge, for example. Now, PACE provides that the maximum length, outside of terrorism cases, is 96 hours. It provides certain tests and safeguards that need to be made in order to continue detention up to that maximum point. Those provisions of PACE are Parliament's specification of the political issue of how to balance the liberty of the individual, which finds expression in Article 5, and the public interest. And this provides a relatively straightforward tool for lawyers, police officers, magistrates and judges to apply. It would be infinitely more complicated if police officers or magistrates were required to consider whether further detention would strike the right balance between the liberty of the subject and the public interest. And as the authors of the excellent book, Legislated Rights Securing Human Rights Through Legislation, have pointed out, since the European Convention is incompletely specified because it is too vague and open-ended, it needs further specification, and that specification needs to be done in the first instance by legislatures. And as they say, and I quote, "Human rights need positive law, not only to add security for the respect of the rights of persons, but also to realise, by specifying in law, the requirements of human rights. Legislatures should be understood as full partners in this enterprise of promoting and protecting human rights, and not as a standing threat to rights against which courts must serve as guardians," close quotes. Finally, the issue can arise where the courts make an improper use of Section 3. When Parliament has engaged in specification, the task of the court should be to apply that specified scheme, and they shouldn't seek to directly apply the rights that have been so specified, whether they be convention rights or rights under common law. To do otherwise, in my view, would be to usurp the role of the legislature. Now, the Human Rights Act gives the ability to the courts to consider whether the statutory scheme is itself compatible with convention rights. Now, such complaints can therefore be considered, but subject perhaps to Section 3, they ought to do so without disturbing or modifying the specified scheme that Parliament has created. Now, in such an instance, the question that the court could ask itself is not the first-order question of how the balance should be struck, but rather that second-order question. Does the outcome, which the parliamentary scheme gives in this particular case, go beyond the margin of appreciation which Strasbourg would grant to the UK? Now, if the answer to that question is yes, then the court must then consider what should be done. Now, it can use Section 3 to, if the defect in Parliament's legislation is a minor one, and correcting it would be possible. But what is possible has to include constitutional constraint. Now, it's one thing to make use of Section 3 so that, for example, an additional factor can be considered because new case law from Strasbourg says it ought to be, but it's quite another to use it to read in a requirement that the primary decision maker should themselves conduct the proportionality analysis. Now, doing so amounts to undoing or usurping the legislature's specification. And I was concerned that, for example, through the use of Section 3 and Section 6 of the HRA, the Supreme Court said last year that a court, when trying someone for obstruction of the highway, ought to consider for itself whether the arrest and removal of the protesters struck a fair balance between the rights and interests at stake. Similarly, in a recent case, the High Court has held that the police are obliged to conduct a proportionality assessment themselves when policing protests, even in the context of the COVID pandemic. When it comes to protest, the Public Order Act is Parliament's specification of the balancing act between the right to protest, the rights of others, and the public interest. It is that the police and courts should be applying, and not a general proportionality assessment. Now, the question of what is a fair balance between the rights of some to protest and the rights of others to use Her Majesty's highways is one which, as Lord Reid put it, involves, and I quote, weighing up incommensurable factors. And so it doesn't have a single right answer. Now, reasonable people, and that very much includes judges, by the way, can and do disagree over how such a question should be answered. In a democratic society, that decision should be made by Parliament or by ministers who are accountable to Parliament. These constitutional considerations mean that courts should strive to reach interpretations that do not require them or other public authorities not directly accountable to Parliament or to the people to answer those first-order questions. Furthermore, this sort of weighing up of factors is contrary to legal certainty, and it seems to me, on that basis, it is also contrary to the rule of law. For if the rule of law means anything at all, it must include, as the US legal academic Lon Fuller argued, governance on the basis of rules. Now, it must be recognised that it is not possible to always ensure that a public authority would never have to consider that first-order question itself. That is because it is unrealistic to expect Parliament to provide a specification for every single possible issue that might arise. But where Parliament has occupied that field, its own scheme should be applied in place of a first-order proportionality analysis by the court. And that's why I'm in total agreement with Sir Peter Gross's recommendations in the Independent Human Rights Act Review report that before going to convention rights, the domestic court should first apply UK statutes and the common law. This is because our domestic law contains the specifications that Parliament has provided, or which, within their narrow role, our courts have done in developing our common law. Secondly, the domestic courts must continue to remember the distinction between that first-order proportionality question and the second-order one. Whilst the decision in the case of Ziegler is not ideal in that regard, the judgment in SC is, in my view, preferable. There, the court recognised that the answer to the first-order question was ultimately political, and it was one which the court was not competent to answer. It therefore confined its analysis to the second-order question, that is, how much margin does Parliament have, and does that decision fall within the margin? But how then should the court approach that second-order question and its link to the Strasbourg Court jurisprudence? Now, as I said in the SCL lecture a few weeks ago, the domestic courts can frankly go wrong by gold-plating the ECHR, either by finding violation in instances where it is not clear that Strasbourg would find a violation, or by holding that they can still find a violation in matters falling within the UK's margin of appreciation. Now, fortunately, last year, the Supreme Court has corrected both of those errors in the cases of AB and Ellen Kane. Now, the role of our domestic courts is to determine what are the UK's international obligations under the ECHR without needing a trip to Strasbourg, and subject to Parliament having decided otherwise, to prevent public authorities from acting contrary to those obligations. It's not the task of the courts to decide for themselves what they would like the rights listed in Schedule 1 of the Human Rights Act to mean. Those rights do not have an autonomous domestic meaning that is for our courts to figure out. This was, and I use this word advisedly, the heresy rightly rejected by the Supreme Court in Ellen Kane. Now, this, of course, does not mean that the UK court should be bound by every decision of Strasbourg, not least because the Strasbourg court is itself not bound by its own decisions. It's important that there is space for judicial dialogue between the courts, and that dialogue must inevitably include occasional disagreement. But the framework under which such dialogue must take place is one where one asks what the UK's obligation under a particular treaty is, and the judgments of the court, given the task of interpreting that treaty, must necessarily take pride of place. Now, if our courts forget this, or if our Parliament instructs them to treat the rights in Schedule 1 as having some autonomous domestic meaning, there will be two very undesirable consequences. First, it will very likely lead to our courts going beyond Strasbourg, as we saw prior to the cases of AB and Ellen Kane. And secondly, it will upend the constitutional position of our courts because it will require them to come up with what they take the meaning of a vague, open-ended text to be. And that will inevitably put them in the position of making judgments on the merits of parliamentary action. It's not good for our constitutional balance. And it is for this reason that I am very concerned that the government is proposing to replace the Human Rights Act with a Bill of Rights, which will have the same text as the ECHR, but which, at least according to some aspects of the consultation document, which will have an autonomous domestic meaning, which should be determined without reference to the Strasbourg case law. Now, as Richard Ekins and John Larkin put it recently, prior to the recent change in jurisprudence of the Supreme Court, the domestic courts were, and I quote them, increasingly approaching the HRA on the footing that it empowers them to develop a kind of British Bill of Rights chosen by our judges themselves, which would gold-plate the ECHR, imposing further limits on government and Parliament. Yet it would appear that this is what the government is now consulting on. The proposed Bill of Rights will retain the same text as the ECHR, but, at least according to some aspects of the consultation document, it would have an autonomous domestic meaning, as I've said. This would undo all the gains that have been made in recent Supreme Court decisions. I strongly agree with the responses to the consultation from my friends at the Society of Conservative Lawyers and indeed of Policy Exchange, which advocate codification of those recent Supreme Court decisions rather than giving those rights an autonomous domestic meaning. And now, to be fair, the government did also contemplate codifying the principles laid out by the Supreme Court in AB, and Ellen Kane was a case handed down the day after the publication of the consultation document. So I very much hope that in the light of that particular development, the government opts for this course of action. To conclude, therefore, the domestic courts should do well to remember Lord Reid's observation in a number of cases that whilst the HRA might have given the courts more power, it has not removed the limitations of the court process to decide certain issues, nor has it altered the relative institutional competences of the courts, executive and parliament in relation to their composition, to their expertise, to the procedures, accountability and legitimacy. It is unfortunate that those observations were made in dissenting judgments, but it's heartening that they now seem to represent the unanimous view of the court, and long may that last. As for government and parliament, I do not think that we should seek to replace the Human Rights Act with a Bill of Rights. Doing so runs the risk of introducing an autonomous meaning doctrine, and this, frankly, would upset the constitutional balance. Instead, the starting point of the government should seek to codify the new approach of the Supreme Court. There are then other changes that might be worth doing to the HRA framework, some of which have been suggested by the Gross Review. And another worthwhile change would be to legislate to overturn the case of Ziegler unless the courts beat us to the correct course before Parliament does so. And Parliament must also be much more willing to engage in specific changes. It should do this, to start with, in areas such as privacy law and deportations under both Article 3 and Article 8. And in the course of doing so, ministers must not be afraid to make a Section 19(1)B certificate of incompatibility. At the Strasbourg level, now that Protocol 15 is in force, it ought to be full speed on the move to process-based review. And in the course of doing so, the Strasbourg Court should be willing to revisit some of the norms it developed during its substantive phase, if these pose problems for member states. And in parallel, the UK could work with other member states to identify some of those problems. This could form either the basis of a new protocol, or it could persuade the Strasbourg court to revisit its case law. In short, we should abandon the uncertainty of a Bill of Rights, make targeted and specific domestic reforms instead, and seek to work for further reform at international level. And that, I believe, would be a truly Tory approach to human rights reform. Thank you.
Thank you very much indeed, Robert, for a fascinating, insightful and thought-provoking talk. Before I proceed, can I urge you to ask questions on Slido? For those of you not familiar with the technology, you use your phones to pick up the QR code. You type your question in, whether you're in the room or you're online, and magically it should appear on the iPad that I have in front of me, which at the moment says you can be the first one to ask the question. So please, could you ask questions? Otherwise, it will be a monologue from me, which will be much less exciting. So just to pick up, Robert, from what you were saying, my understanding is that you were making the point that Parliament should be more prescriptive when talking about areas where there's an impact in the human rights field. But what we've also seen in recent years is that, dare I say it, Parliament has been surrendering power and adopting increasingly skeletal or framework bits of legislation, which puts a huge amount of power in the hands of the executive. And that seems to go against exactly what you're advocating.
Well, that's a very fair point, Catherine. I think we know some of the reasons why this has been increasingly happening. I mean, I came into Parliament 12 years ago, well into the era of the programme motion, which, of course, was a device created by the Labour government in order to really entrench the government's control over time. As you know, time is everything in the House of Commons. And the government's stranglehold over time and its ability to constrain and constrict time means that it's a self-fulfilling prophecy that because of that control, then there's an argument to say there isn't time and space to really go into the warp and woof of detail, which is, I think, one of the rather prosaic reasons why we've ended up in this position. And of course, the House of Lords rightly rail about it. I think, to be fair, certainly when I was in government, we always took great care on Henry VIII clauses, which, as you all know, are self-cleaning clauses that can amend primary. But of course, that's not the end of it. That's not the end of it by any means. And therefore, I do think that, you know, now I'm out of government, I'm able in this time of introspection and self-criticism to say we can do it better. And I think in the field of privacy, which is the one I'm referring to, I think there's been an abrogation, frankly, or an abandonment of a parliamentary involvement on the basis that it's too hard. That's the argument that I've often heard about privacy, that it's too difficult. Well, if Parliament isn't doing difficult, then why are they there at all? And therefore, I do think, you know, if we're going to, recast and consider this carefully, then it is a time for Parliament itself to revisit its mechanism, if indeed, as I think it should be asserting its authority in this particular area.
Joshua Rosenberg's asking if Dominic Raab declines to accept your advice, do you think he will get his proposals through Parliament in the next session?
Well, the consultation period is still ongoing. I do think that there is genuine debate about it. I think that I'll be frank with the notion of a Bill of Rights. It's a very 2015 response to a 2022 issue. I think that whilst it was a matter of hot debate, if you remember, during the coalition, and we had that very odd commission, if you remember, with a huge range of different views that was almost designed not to come to a conclusion with respect to everybody on it. I think that the moment for all of this has passed. What is actually the problem that is trying to be solved? Is it an attempt to fill the margin of appreciation by the UK? That might be a respectable argument for it, so that we can have a very clear rationale that we can then display to Strasbourg if a particular aspect of our procedures comes under attack. Or is it window dressing? you know, that's a criticism you could apply to it. I think the main problem with it is the one that I've identified, that it could inadvertently, I think it's inadvertent, give rise to reviving this theory that somehow this is a fresh set of rights that need to be interpreted by the courts domestically. Disaster. And you know, the old wartime analogy, is your journey really necessary? I think the answer to it is no.
I mean, obviously you're very concerned about the courts intervening too much. You've always advocated the important role for Parliament. But what happens if the courts do go down the route, in your view, and do overstep that delicate mark? I know Lord Reid has showed signs of something of a retrenchment, but of course he's not alone, and there are others who might take a different view.
Well, I think I've always held up, and it's not shroud waving, I've always held up the nightmare scenario of a political court. Our Supreme Court is not a constitutional court. It's the Court of Final Appeal for the United Kingdom that deals with the questions that are put to it, and it seeks, I think, very well to answer the question. It doesn't try and roam over the constitutional savannah or come up with general principles. It's a very focused court, and that's such an important thing. And it does mean, I think, however, a certain amount of responsibility to make sure that we can keep it that way. And I don't know about you, but I would be horrified if we ever saw the day coming that a committee of Parliament started scrutinising judges for their perceived political bias or their political view. I think that would lead to, frankly, a massive diminution in quality and in the reputation of our courts, which I certainly, when I was Lord Chancellor, felt very fiercely protective of. And I think it's the job of government to do whatever it can to protect the judiciary, to support them, to make sure that their independence and their world-leading role is maintained. So I think that is the most clear consequence if we end up with what I've characterised as an overstepping of the mark.
The questions, the most popular question that's come in is by a contributor, and forgive me, I may well mispronounce your name, Paul Odwiba. Dweeby, I apologise for the pronunciation. And this touches upon an issue that, of course, you've alluded to but not gone into, which is new areas where the courts have to go into. Miller 1 and Miller 2, of course, were examples of that. And his or her, and forgive me, I don't know, a specific question is, should the Prime Minister have resigned and failing that been sacked by the Queen when he was shown to have lied to her about his motivation for proroguing Parliament?
Well, I'm not going to get into a definition of a lie. I don't think that was the question. I think the question was a lack of a rationale for the length of the prorogation. This was going to be one of the longest prorogations since the war. There had been, I think John Major had prorogued actually for quite a while, but I think everybody understood that was coming close to an election. In the end, I think the court just wasn't persuaded. I mean, actually, when you look at Miller 2, there wasn't that much evidence before the court. I don't recall the swearing of affidavits or the giving of evidence about the rationale or the reasons. And you know, to be fair to the court, although there are aspects of that judgment I strongly disagree with, it wasn't left with much actual evidence to work on. And therefore, what it did was substitute its own principles for convention. That's in essence what happened. I've said before that although it was a tense and a tetchy time for everybody involved, it was an example of the Constitution working. It was an example of the government actually accepting the decision of the court and Parliament reassembling in accordance with its ruling within a day or so. And therefore, I never thought at any time it was a question for prime ministerial resignation. I think it was, I'm afraid, one of the aftershocks of the seismic event of Brexit. And, you know, we had a number of aftershocks with which I'd had to deal with during my 2 years or so in office.
Thank you for tackling that. The questions come in from Vijay Srao. How can you have better justice if courts are closed and sold off to property developers?
Well, I'm going to shamelessly remind everybody that, of course, the court closure programme wasn't on my watch. However, do I think that it was wholly misconceived? No, I don't. I think that whilst I think it's glib to say that we can just casually rush to digital and remote courts, though COVID has advanced that cause hugely by necessity, I do think that where we are now is striking more or less the right balance between the need for local courts and actually some more strategic and sensible management of what is a vast property portfolio. Now, the HMCTS is just an incredibly large landowner, it seems to me. I think that I think coupled with quite low maintenance budgets, we'd ended up in a position where a lot of our courts were looking very tired, and I think those working in the courts felt very, very much neglected and frankly unloved. And there have been, certainly when I took office, big strides to increase the budget, to improve the maintenance of our courts, and to maintain the network. There's no current plans to close any further courts, certainly not developed in my time in office. And now, I think, post-COVID, it's time to blend the best of remote technology, and it's developing all the time in ways that are making it much better for judges and court users to engage with, and that need where, in particular, a witness has to be assessed for their credibility for those in-person hearings. So I think the world has moved on quite considerably from that court closure programme of about 10 years ago. It's now really about quality, I think, rather than quantity. And that's why I don't think we're going to go back to a position where we'd have, for example, Eglosuru Magistrates Court, which I remember in Pembrokeshire, which was next door to a pub, and the retiring space for the magistrates was indeed the lounge bar of that wonderful pub. I mean, it's romantic stuff, isn't it? But much nostalgist that I am, I don't think we're going to go back to that.
But there are real tensions in the criminal justice system and indeed the civil justice system. We know the huge delays in both fields, and we now know that criminal barristers have decided to take industrial action because of the lack of legal aid funding. How do you feel about that, and how do you respond to the criticisms that the judicial system, the court system, has been systematically starved of funding?
Well, I mean, as somebody at the criminal bar who themselves took part in action back in the noughties to refuse to take new cases, and certainly in Cardiff we held out for many, many months as outliers in action relating to what was then, frankly, a systematic underfunding of the graduated fee system. I have a lot of sympathy for my colleagues at the criminal bar. However, I think that bearing in mind what has happened and the actually very productive report of Sir Christopher Bellamy, which has, as a minimum, recommended an injection of 135 million into the system, particularly for those criminal solicitors firms that are really on the edge and who are crucial for the survival of the market if we are going to maintain private provision, rather than a criminal defenders service, which would be, I think, a problem and not a good way forward. Then my advice would be to hold back actually from action. The Criminal Legal Aid Part 1 review, which I implemented, did increase funding for criminal fees, and that was the first increase in many, many years. And the Bellamy recommendations represent a further increase in criminal legal aid, which is hugely welcome. My view is that the government needs to get on with it. I think they want a 12-week consultation period. I think if there's unanimity about the benefit that Bellamy brings, then surely they can, I think with sense, reduce that period a bit and try and get on with implementing the statutory instruments that will bring in these much-needed increases in fees. Now, I get the frustration of the bar, I really do, and I get the fact that they feel unloved and neglected over a very long period of time, not 10 years, but 20 years. But I think that certainly in the time that I was in office, I moved heaven and earth to try and make sure that we were able to turn a corner and start to increase that funding. And that is what now happily is occurring.
Thank you very much for that. The questions are actually pouring in, and I apologise to all of you for not being able to get to them in the course of this session, but some of them will be answered in the course of today. But Sir Robert, the most popular question that's come in, and I give you, it's the last one that we can tackle now, is from Fatima Barber, who says, you've expressed your confidence in this government previously. Is this sentiment unchanged?
Oh, I have. I think I did the Oxford Union debate, the no confidence debate in October, and I put it in this way. I said, had I been asked to take part in the debate when I was still a member of Cabinet, I would have had an extremely high degree of confidence in the government. I still have confidence in the government, but inevitably it's perhaps slightly less than when I was there, shall I say.
Is that because it's missing your expertise?
I'll leave that for others to comment. But I do have confidence.
In all matters?
Well, I've outlined an area where I think we need to have a proper debate. I think that I'm concerned that the focus that I wanted to place on the Constitutional Reform Act of 2005 is being lost. I think there are opportunities, you know, if you're a Conservative Lord Chancellor, you want to do things that mean something in terms of maintaining a balance in the Constitution. I'm just worried that in the pursuit of headlines, we're not actually going to make some of the meaningful changes to the Constitution that I wanted to do. And I think rather than chasing chimeras such as trying to change retained EU law, for example, or introducing bills of rights, far better to have a look at the mess of the 2005 Act, restore the position of the Lord Chancellor, and do things that actually, you know, are A, I think, quite Tory, and B, quite sensible in terms of maintaining the balance in the Constitution.
And if the Prime Minister gets a penalty notice as a result of Partygate?
Well, the notices are coming out in part today, I say. I'm not sure whether we're going to hear much about the PM. I think, I put it in this way, I think it will depend very much upon the circumstances. And on one level, you can say that if he does get it, it is an example of equality before the law, and that actually it's an example of the rule of law working. So I think I'll reserve judgment on that until I see the full implications.
But he was keen for Mr Hevelthwaite to go over the P&O dispute for breaching the law. Perhaps he might think about his own position?
Well, I think you know, any head of government who is found to have infringed the law has got some explaining to do. Let's see what the explanation is. And as I've said, you know, be you ne'er so high, but the law is above you. And that will be the case here, I'm sure.
Thank you very much indeed, Robert, for kindly tackling all of those diverse range of questions. Thank you to you all for your questions. Please stay with us. We have the next panel is on the very specific question of the role of the courts. And so may I invite the panellists to join us on the stage. But could I invite you all to give a round of applause to Robert Buckland. Thank you very much indeed.
Thank you very much. Thank you, Catherine. Lovely. Your pleasure. Thank you. Thank you. Right.
Thank you. That was terrific. Thanks for... Close it in. Sorry, Catherine. Thanks. Well, thank you very much indeed for staying with us, and welcome to those of you who've joined. Particular welcome to the students from Batley School, with whom UK Changing Europe has a particular relationship, who are sitting at the back. This session is called Can and Should We Rein in the Judges? The Future of Judicial Review, a very live topic at the moment. With the Judicial Review Bill going through Parliament. I have with me 4 excellent panellists who I will briefly introduce. Brevity is an indication of their distinction rather than their lack of it, because you want to hear from them and not from me. I'm going to introduce them in the order that they are going to speak. So first of all, on my far left, Jonathan Jones QC, who was the head of the Government Legal Service between 2014 and 2020. It will be recalled that he resigned over his government's proposals, or over the government's proposals, I should say, to put clauses in the Internal Market Bill which were allegedly contrary to the UK's obligations under public international law. Now, I always feel for him because, of course, by definition, he's always introduced in that way, that he's famous for resigning and not famous for the good things that he's done. He is now senior consultant at Linklaters and also the enjoyer of finer things in life, including cocktails and Ely Cathedral. And probably in that order. To my immediate left is Sir Stephen Laws QC, served as first parliamentary counsel between 2006 and 2012. And for those of you who are less familiar with these things, he was responsible for drafting all legislation laid before Parliament, although presumably he had some people giving a bit of assistance. On my right is Alison Young, Sir David Williams Professor of Public Law, and it's harder to think of anyone more worthy of holding that title. And in my view, she knows more about public law than almost anyone I've ever met. She's a legal advisor to the Constitution Committee, and she is also my wonderful colleague at Cambridge. And then on my far right is Richard Ekins, Professor of Law and Constitutional Governance at Oxford and Fellow of St John's College. He's also head of the influential Policy Exchange Judicial Power Project. He's a New Zealander by birth, but we don't hold that against him. And he is also one of the nicest academics to walk the earth, and that admittedly doesn't often say very much about my colleagues in academia, but he is excellent. I'm delighted to welcome them all here. What we're going to do is each one is going to present for 5 minutes. We will then have a bit of a discussion on the panel, but again, I urge you to ask your questions on Slido as we did before. It doesn't bite, it's incredibly easy to use. Even I've managed to master trying to juggle iPad and bits of paper. So please do ask your questions. So, Sir Jonathan, the floor is yours.
Thank you very much, Catherine. Very good to be here and see real live people in front of me. Should we rein in the judges? As lawyers, there's a risk we spend half our time dissecting the question. Who are we, for a start? I think the question has been deliberately designed to be provocative, even shocking. Aren't judges supposed to be independent? Doesn't reining them in imply interfering with that independence? Certainly, Parliament can change the law, including in response to individual judgments, but surely the judges must be free to interpret and apply that law. Now, the first point is that we're here focusing on one particular aspect of the judge's role, admittedly a very important one. This is public or administrative law, judicial review, the law as it applies specifically to the acts of government and other public bodies, and that is obviously a vital element of the judge's role, but it's only one. Every day, the judges are also dispensing justice in thousands of other types of case, criminal cases, family cases, commercial, other private law disputes, employment cases, and so on, interpreting and applying statutory and common law. We trust the judges to decide those cases fairly, justly, and independently, don't we? Giving effect to the will of Parliament. Why do we think they need to be reined in when it comes to judicial review? One answer to that might be that judicial review cases are particularly likely to raise issues of policy, in inverted commas, where it's especially important for the judges to avoid rewriting the policy and stick to applying the law as enacted by Parliament. But whenever the judges apply statute law on family law or company law or whatever it may be, they are similarly giving effect to policy, invariably the policy of the government of the day, as enacted by Parliament. So why doesn't the same risk of judges straying into the policy space arise there? Now, the Independent Review of Administrative Law, or IRAL, concluded, to perhaps oversimplify, that there wasn't a major systemic problem. And to quote selectively, because I haven't got much time, it said this: while the panel understood the government's concerns about recent court defeats, the panel considers that disappointment with the outcome of a case is rarely sufficient reason to legislate more generally. In other words, Parliament can legislate to change the law in response to a particular case, but there wasn't a more general issue. Solutions to any potential problems of judicial overreach must come from the courts, and the courts should be encouraged to do what they can to address these problems. The most obvious solution to a potential problem of judicial overreach is judicial restraint. So IRAL itself made only relatively modest proposals for reform, including reversing the decision in CART, which we may come back to. And those proposals are, give or take, being taken forward in the Judicial Review and Courts Bill. But we should recognise that the IRAL report and those recommendations do not really reflect the strength of feeling on the part of government about judicial overreach. The Attorney General has been particularly critical. In her speech to the Public Law Project conference last October, she referred to a huge increase in political litigation, that's to say litigation seeking to use the court system and judicial review to achieve political ends. The Attorney General's language was quite punchy. While she said she was not intending to undermine the judges or their judgments, which are, of course, both entitled to the greatest respect, she said that the Supreme Court had wrongly stepped into matters of high policy. Its decision in Miller 2 was inapt. Its decision in Privacy International on the powers of the Investigatory Powers Tribunal, on the reviewability of the IPT, was profoundly troubling. Its reasoning in Adams, on the extent, but partly on the extent to which ministers' functions could be delegated to civil servants, was deeply strained, if not implausible. And the Lord Chancellor, Dominic Raab, has weighed in also talking about decisions of the courts harpooning major policy decisions. So some fairly punchy criticism from government. What's the response of the courts been? Are they backing off as a result of this criticism? Some have thought so, maybe. Robert Buckland, in his remark, referred to the case of SC. The Attorney General herself welcomed that decision, which seemed to her to assert a more traditional approach to judicial review. She particularly liked the passage where Lord Reid observed the need for the courts to apply the principle of proportionality in a manner which respects the boundaries between legality and the political process. We've seen a recent judgment of the Divisional Court in the Good Law Project and the Runnymede Trust case, adopting a relatively restrictive approach to the question of standing in judicial review, and that, you can see, might well help to allay the government's concerns over political litigation. So maybe there has been a change of tone. I think it's probably too soon to say that there has been a more pro-government trend. And anyway, there will always be cases going both ways, and we've certainly seen cases of the government losing and being criticised by the courts, including the other day the MA and KH case on the seizure of mobile phones from migrants arriving in small boats from France. I mean, in that case, very significant concessions of illegality were made by the Home Office. But the court found against the Home Secretary on other grounds, and there's not much sign there of the court holding back. That's the end of my time, really. In conclusion, though, I have some problems with the question, and I'm uneasy about who the us is who might be telling the judges what to do or what not to do. The government, obviously, or at least part of it, does think that the court should be reined in, although perhaps only in the area of judicial review, where the government's own conduct is in play, and that makes me a bit suspicious. The judicial review in Court's bill as it stands doesn't actually go very far to achieve that, so maybe the government would like to go further. IRAL didn't really see a significant problem. It thought the best solution to judicial overreach, if that's what we've seen, is judicial restraint, and maybe that's what we are now seeing.
Okay, thank you very much, and thank you very much for providing a model for any students as to how to answer or not answer the question in the specified period of time. I turn now to Stephen Laws.
Thank you, Catherine. Former US Supreme Court Justice Learned Hand defined the spirit of moderation as follows: the temper which does not press a partisan advantage to its bitter end, which can understand and will respect the other side, which feels a unity between all citizens, real and not the factious product of propaganda, which recognises their common fate and their common aspirations. And he said this of it: this much I think I do know, that a society so riven that the spirit of moderation is gone, no court can save, that a society where that spirit flourishes, no court need save, that in a society which evades its responsibility by thrusting upon the courts the nurture of that spirit in the end will perish. That more or less sums up what I want to say on this subject.
Stop now.
No, I'm going on. Involving the courts in issues that are more suitable for resolution in Parliament by democratic political processes has grown and is growing. Developments affecting JR proceedings have been a large part of that. Resolving political issues in the courts provides definitive winner-takes-all solutions. It's the possibility of total victory that creates an obstacle to compromise and to political consensus. That's what threatens the spirit of moderation by disrupting and displacing the operations of the mechanisms of what Robert Buckland said was our political constitution that support it. And those mechanisms, I think, work. Today's question is, I was going to say tendentious, Jonathan said provocative. I do not think that our judges are unruly horses who need to be reined in, nor do I think that they are horses who have bolted so that they cannot be reined in, that there is no point in closing the stable door. If Parliament so chooses, of course we can, as a society, can rebalance the respective influences of politics and law on our national affairs. Our judges are duty-bound to respect parliamentary sovereignty, and it would be foolish to suggest they might not, and disrespectful. But should we rebalance? I'm one of those who think we should. It's a question that is itself also a political question. It's a mistake to think the politics in it can be neutralised by legal or academic analysis. Law has different political and forensic objectives that are often in tension and compete. The correct balance between them is a political choice. Should the priority for the law be meeting the desire of the vast majority of us to be able to organise and conduct our lives in compliance with the law, but without becoming involved in legal disputes? Do we want the law to continue to be an effective tool for producing democratically legitimised social change? These are the characteristics of legislation. Or should the priority instead be a retrospective concentration on the outcome in individual cases? Should the quality of the law, including the law relating to judicial review, be tested primarily by reference to how it works forensically for resolving legal disputes as they arise, or how it impacts on society more widely? Legal disputes represent only the tip of the iceberg so far as law's practical impact on society is concerned. Litigation tends inevitably to be confined to rare, often atypical situations at the edges of what the law allows or requires. And as we all know, hard cases make bad law. I think an imbalance between these approaches has developed and requires a readjustment to protect the effectiveness of legislation as a means of influencing future conduct and implementing social change. The developments in judicial review jurisdiction have contributed to the imbalance. A very significant factor in that has involved the application by the courts to legislation of principles and remedies that are suitable for use only in dispute resolution and casework. For failing properly to respect the distinction between the different contexts of legislation on the one hand and dispute resolution and casework has resulted in the importance of legal certainty and predictability being dangerously undervalued. This manifests itself particularly, and Robert Buckland addressed this, when unequivocal legislative specifics are allowed to be qualified with vague general principles, such as those provided by the ECHR, the so-called principles of legality. I'm in favour of more specificity and granularity, as Robert Buckland was. Legal certainty and predictability are very important components for the rule of law, as Robert Buckland also said. They are needed for dispute resolution, but they are absolutely essential when legislating. No litigant should have to litigate a dispute up to the Supreme Court to find out how the law applies to it. Even more important, though, is that the law relied on by ordinary citizens for planning their future conduct is clear from the start and can be relied on without the need for litigation at all. It's more damaging still if those in government and parliament who make the law are themselves unable confidently to predict how the law they make will be applied in practice and whether the political compromises that produced it will be allowed to stick. But that, like it or not, is where we are as a result partly of developments in the judicial review jurisdiction. In too many cases, there's now a risk that a litigation stage will be needed before new law can be relied on, and the desire to mitigate that risk can have crippling effect on sensible policy formulation. If it's made impossible for you to guarantee the effect of the law you make, there is no point in taking responsibility either for producing legal certainty or for securing that the law conforms to any relevant general principles. Instead, your best option, and I've seen it done, is to make it vague enough for the courts to do what they feel they need to do with it, or maybe just not to bother with accepting the risks of initiating a change at all, even if change is vitally necessary. If the ultimate responsibility for the substance of new law and for the extent to which the legal status quo can be allowed to change belongs to the courts, not politicians, irresponsible politics is the inevitable and logical result, and so is damage to the reputation of the judiciary for political impartiality. Moreover, it's the availability of the option to make predictable changes to the law that's a large part of what mandates public sector conformity to the existing law till it's legitimately changed. We have a long-standing culture of principled legal compliance in the UK public sector, of which I'm very proud. Those who make the law conscientiously adhere to it because they, above all, can be expected to know exactly what it means. Invalidating that premise leads inexorably to the replacement of a principle-based approach to legal compliance with a risk-based approach. This is understandable, but it's not a development to be welcomed, and it is all too easy to see happening. So it is that thrusting the nurture of the spirit of moderation on the courts causes it to perish. The growth of judicial review and its extension further into politics is often justified by those who mistrust or have despaired of our political culture. They think our politics needs tighter regulation. I think our political culture is strong, and I believe their concerns are misconceived, or at best wildly exaggerated. More seriously, I think it is obvious that attempts to extend the legal regulation of politics, for which JR has become the established mechanism, only aggravates the mischief they think it can remedy.
Thank you very much indeed for those very thoughtful remarks. Can I turn now to Alison?
Thank you, Catherine, and thank you so much for your kind words and for inviting me. So, as a good academic who spends her time telling students how to answer questions, can we rein in the judges? Well, the simple answer would appear to be Parliament is sovereign, Parliament can do what it wants, so of course it can. I think that's too simplistic, and I think we have to understand that parliamentary sovereignty has to be balanced against other principles, like the rule of law and the separation of powers. And also remember that judicial review also shores up parliamentary sovereignty, doesn't necessarily undermine it. In terms of should, I think I'm concerned that there's a danger of overreacting to a series of cases taken in extraordinary times, and we forget just how much we have a general element of case law, as Jonathan has already said, beyond judicial review, and a general element of case law and judicial review that often shores up the will of Parliament. So in order to try and explain why I don't think the answer is simply Parliament can do what it wants, I want to talk a little bit about ouster clauses. So for those of you who are not used to judicial review speech, an ouster clause is a clause that says the courts cannot review a particular decision of the executive or the administration. And we have dicta in a recent case from Privacy International from Lord Carnwath that tells us that binding effect could not be given to a clause that was removing judicial review for excess or abuse of jurisdiction or error of law. Lovely legal speech, but what's he trying to get across? Well, what he's trying to say in that particular case is sometimes Parliament says, here is a tribunal or an executive body that has limited powers. But what we're going to do is say it can determine what those powers are and the courts can't check it. That's a little bit like me saying to my teenage daughter, you have a curfew, but you can tell me what the time is of your curfew and you can check whether you've met it or not. She's bright enough to realise that's not her curfew. But also I think we have to recognise if Parliament is saying on the one hand, here are bodies with restricted powers, it can't on the other hand say, oh, and by the way, they can determine the scope of their powers and no one can check to see if they've gone beyond them. And if Parliament has given them those powers, then isn't it the job of the courts to check that these bodies have not gone beyond the powers Parliament has given them? And as we can see in cases like the Dissolution and Calling of Parliament Act and the Judicial Review and Courts Bill, which is still going through Parliaments, ouster clauses can work in specific situations when they are not going to undermine parliamentary sovereignty or undermine the rule of law. The first looking at a contestable issue as to whether checking the dissolution of Parliament is a legal or political issue, and the second one giving limited judicial review over the upper tribunal when it decides not to hear cases or hear appeals from cases of a lower tribunal. What about should? Well, I think the other thing we need to think about in terms of should is sometimes it's quite tempting to play what I've decided is judicial review top trumps. Let's go away and find a series of cases that seem to conclusively prove a point for us. Now, the problem is everybody wants the Miller case, when we had to decide whether the government could trigger the process to leave the EU or whether you needed legislation, and the Miller-Cherry case on the prorogation of Parliament in their deck. Because if you think judges are going too far, you'll immediately say this is the epitome of the judiciary going too far because this was a political decision. If you think this is an example of the judges not going too far, you'll look at the case and say, but what did the courts actually do? Well, they preserved the sovereignty of Parliament, and they tried to ensure that the government was held to account by Parliament, and Parliament in turn is held to account by the people. Now, I notice that they're scribbling away, but my point I'm trying to explain to you is we can use these cases to make both points. Why? Because we're arguing about a contestable issue. What should the powers of the courts be? And my concern is if we focus too much on specific cases, then we have a problem because we have selection bias. Let's choose the cases that are most likely to make the point for us and forget the vast bulk of cases that might actually be shoring up parliamentary sovereignty. Second, I think often we misunderstand the precise context of what is going on. There are important pieces of legislation in both the Miller case and the Miller-Cherry case. We've also heard mention of Ziegler and Elan Kane, other cases we like to roll out and play. These are very specific cases with specific pieces of legislation that need to be understood in their particular context. So you can't just play them to make generalisations and general arguments. Also, when you're looking at cases like Miller and Cherry, and this is my third point, your problem you've got there is you've got a unique constitutional controversial issue. And I think we need to recognise that in a lot of these cases, when we have diversive issues, often when you're thinking about politics, you're thinking mostly about ends. And sometimes that means you don't necessarily check the means. The nice thing about the courts is they're also there to check the means. How are you doing this? Are you doing this in a way that would undermine the sovereignty of Parliament or undermine some of our constitutional fundamentals? Do I think there are easy answers to whether we can and should rein in the courts? No. Do I think we should rein in the courts? Also, no. Because I think when we take a step back and understand what the court was doing in these controversial cases and put them in their context about what courts are doing on a day-to-day basis, I think we'll find that the courts are there to shore up fundamental principles of our constitution and also, in a lot of circumstances, to shore up the sovereignty of Parliament itself.
Thank you very much indeed. And finally, may I turn now to Professor Richard Ekins.
Well, thank you, Catherine. I'm grateful to you, Catherine, and your colleagues for the opportunity to speak today. I plan to say a little bit about judicial review reform in general, and then turn to the detail of legislating about judicial review in particular. And then I'll finish by touching on a point some others have, which is the new direction the Supreme Court seems to be taking under Lord Reid's leadership. The first point to make, I think, in any discussion about the future of judicial review reform is that judicial review is an indispensable part of our Constitution and should be valued accordingly. But the question for present purposes, I think, is where the law should set the limits of judicial review. Put another way, does the law of judicial review permit or require courts to answer some questions and to consider the exercise of some powers that should not be the subject of litigation, deploying grounds of judicial review that involve taking over aspects of government or second-guessing Parliament? And does such litigation distort parliamentary government? These are perfectly fair questions to ask about the law of judicial review as it's developed over time. They're also questions routinely asked in different ways within the legal profession and the academy. They are too important, I suggest, to be left to lawyers alone. Ordinary people, so to speak, non-lawyers, and their elected representatives are entitled to think about the changing scope of judicial power and act to correct it. My own view is no secret. I think the traditional limits on judicial review need to be restated. And I do make much of some of the leading cases in the last decade or more, where one can see, I think, judicial review proceedings extending too far, addressing questions that should not be for courts, displacing the law Parliament has made, or the political dynamics that should discipline how public power is exercised. And quite apart from particular cases, as Stephen has noted, I think there are reasons to worry about the impact of overly intrusive judicial review on policy making and legislating more broadly. Like Stephen, I take parliamentary sovereignty to mean that Parliament can oust judicial review and is free to legislate to restore traditional limits on the jurisdiction of the courts. That may be Jonathan's position too. Alison's touched already on Privacy International, and I would like also to stress the fact that 3 judges out of the 7 in that case questioned the proposition that Parliament could oust judicial review. They speculated about a future case in which judges might openly refuse to give effect to legislation. Now, I very much doubt whether a future court, let alone the present Supreme Court, will ever act in that way. And if it did, it would be breaching unconstitutionally fundamental legal proposition. So I think Parliament should proceed on the basis that it has authority to change the law of judicial review. That said, there are some very good practical reasons to avoid codifying the law of judicial review. The better technique may be to make targeted changes, responding to particular problems in the law of judicial review in ways that may encourage wider judicial self-discipline. The Dissolution and Calling of Parliament Act, which Alison's just mentioned, enacted just last week, makes one such targeted change, protecting the newly restored prerogative of dissolution from judicial review. The Judicial Review and Courts Bill, back in the House of Lords on Thursday, makes 2 other changes, as noted. The bill is a limited measure, clearly, making only modest changes to the law of judicial review. In a policy exchange paper last year and in evidence to Parliament, I've suggested some other changes Parliament might usefully consider, including reversing the Supreme Court's Adams judgment and restoring the Carl Toner doctrine, which is fundamental to how our government works, legislating to overrule the Privacy International judgment and make clear the primacy of legislative intent in statutory interpretation, legislating to overrule the prospective effect of the Supreme Court's prorogation judgment, specifying that neither parliamentary accountability nor the political constitution are justiciable. Limiting judicial review of the exercise of the power to set tribunal fees, restoring the ministerial override in the Freedom of Information Act 2000, which the Supreme Court undercut in its Evans judgment, limiting judicial review in relation to ombudsmen, inquiries and devolved legislatures, imposing limits on how evidence is handled in judicial review proceedings, and limiting the judicial discretion to permit interveners in judicial review proceedings. These are not radical changes, I suggest. Each would restore the law as it stood until fairly recently. It's possible some of these ideas may be taken up in a later bill. In the meantime, the present bill is clearly modest, but I don't think it's unimportant. It confirms Parliament is willing to legislate in this domain and willing to overturn particular leading judgments. Well, the future of judicial review will turn in large part on developments in judicial culture more widely. And what will be key is how future judges and lawyers think about the capacities of courts, about the political constitution and its adequacy, and about the merits of the traditional limits. It's early days, but I think the Supreme Court, under Lord Reid's leadership, is charting a different course, or it does at least seem to be, to that which was taken under Lady Hale or Lord Neuberger. And you've heard some of these cases mentioned before, but I think in the human rights context, the AB and SC judgments are important, and Elin Kane and Ree McQuillan, both handed down just before Christmas last year, are important likewise. And in relation to ordinary judicial review, so to speak, the Supreme Court's unanimous Begum judgment, Shamima Begum, seems very important to me as well. I think it remains to be seen whether the expansion of the principle of legality that's been seen in some cases in recent years will continue under this court, and relatedly, whether the approach taken in the prorogation judgment in 2019 will be applied in other contexts. If there has been a change in disposition, the explanation may lie in the fact there's been very considerable change in the personnel of the court and the court's membership, and also in the political context in which the court's now operating. Now, I don't mean by that to echo Jolyon Morn's accusation in late 2019 that the judges were all set to be cowed by the new electoral majority. If that's the case, we have a serious problem with judicial independence, and I don't think we do. What I mean is that the 2019 election and the subsequent withdrawal from the EU lowered the political temperature, showed, I think, the political constitution working effectively, whatever you think of the decisions. The court is no doubt aware its judgments might now be overturned by legislation. I think that should encourage it to hew close to settled law and avoid making constitution-making judgments that it has no legal authority for. But the new court, I think, seems in any case to have decided that some recent case law has gone too far and is in need of correction, which is a development to welcome. Now, having said that, there are, of course, limits to the court's capacity, to any court's capacity, to correct past mistakes. But overall, I'm encouraged by the apparent new disposition of our highest court. And taken together with targeted legislation to restore traditional limits, I think the future looks promising. Thank you.
Thank you very much indeed. There's been some tremendous questions coming in, and I thought rather than the panel respond to each other straight away, I thought we'd engage with the questions, and then I'll give you a chance to comment and wrap up before the end. So just to remind you, please send your questions via Slido. And for those of you not familiar with Slido, you can vote on the most popular question. And by far the most popular question that's come in so far is from Paul Evans, who says, does Parliament need the judges' help to rein in an executive which lacks respect for the principles of moderation and parliamentary sovereignty? And I might put that, start with you, Richard.
I don't think, with respect, that the government or governments I can think of have a lack of respect for parliamentary sovereignty. And I know that the prorogation judgment, Alison mentioned it, was a sort of instance where parliamentary sovereignty needed to be protected against the government. I don't read the case that way, or the scenario, the episode, in that way. And I think parliamentary sovereignty is being, I've been defending it for my entire legal career, but I think it's being given an expansive reading in order to leverage a kind of judicial intervention that otherwise isn't justified. And I think you see that in the prorogation case, you see it in some other cases too. So I am worried about that. I think it's a weaponizing of the idea of parliamentary sovereignty, going beyond its traditional scope in order to license new interventions. Moderation, well, the government's moderation or lack thereof is entirely rightly a question of political controversy, and the court can do its bit to ensure moderate disciplined government by upholding the law when appropriate. The case Jonathan mentioned of the seizure of mobile phones, I confess to not having read yet, seeing it's important, but it's on my to-do list for later. And that may well be a case where the court has quite rightly corrected a widespread unlawful practice, and in so doing it does its job. But I don't think there's a general problem with the government having a contempt for the spirit of moderation, to echo Stephen, or for parliamentary sovereignty.
Jonathan, can I turn that question to you, given that you obviously were concerned about the use of parliamentary sovereignty over the internal market bill?
Yes, and perhaps I should always say thank you for introducing me. Going slightly beyond that, I'm the lawyer who resigned. The other thing I should always say on these occasions is that as Treasury Solicitor, I did act for the government in most of the cases we're talking about. Just standing back a bit, my answer to that question would be, the risk of us all agreeing a bit too much, this idea of weaponising has been said. I agree that's not a helpful way of looking at it. The three branches of the state, the courts, the executive and parliament, have got to find a way of muddling along together, and they do to that extent support one another. And yes, when the executive oversteps the mark, but by that I think we're all saying legally abuses its powers in an unlawful way, including the very many powers to make secondary legislation that Robert Buckland touched on, then it's the role of the courts to check that and apply the limits as set by Parliament. So this kind of symbiosis, that's a sign of the Constitution working correctly. On the internal market bill, I mean, it's quite a specific point that I've talked about ad nauseum elsewhere, that I think the executive did overstep the mark by inviting Parliament, as Parliament undoubtedly could have done in its sovereignty, to legislate in a way that breached its international law obligations. And I regretted that, and that's why I resigned. But it's to be expected that the courts would have given effect to the legislation enacted by Parliament if Parliament had passed that bill. So I don't think we could have expected the courts then to correct what I thought to be that unfortunate act contrary to international law. So maybe that's a rabbit hole we shouldn't go any further down. But my overall point is that the spirit of sort of comity that we've talked about, Robert Buckland mentioned, is, I think, at the heart of quite a lot of what we're saying.
Thank you. I just want to feed in Meg Russell's question there, which touches upon the point you've just made. And she says, as Robert Buckland hinted, might the primary fault lie with politicians? Do ministers and Parliament too often dodge difficult topics, thereby kicking them to the courts? Stephen, obviously your experience was somewhat before this government, but do you want to comment on that?
Yeah, I do, because I think there is a dynamic in politics that politicians find often that they want to pass responsibility for things they think they can't properly control to other people. And you see it with the way quangos are set up to manage various bits of government. But there's a cycle to that, because after a while, ministers find that they're being blamed anyway for what the person they've delegated it to do, so they want to bring it back in. And I think there's an element of that in this, in that some very difficult questions have been delegated to the courts. And the courts have taken on that delegation, I think sometimes more enthusiastically than they should have done, but they've taken it on board, and the cycle proceeds, and government thinks it needs to bring them back in because it's going to be held responsible for what happens anyway. So, short answer, yes.
Thank you, Meg. Alison, do you want to comment on either aspect of those questions?
I think we're constantly going back to comity, and I think that's important. I think it's also important to recognise what the different functions are of the different institutions in government. And I think, as I keep repeating, you have to think very, very carefully about context and specifics and not just draw generalisations from these big cases. And I think Richard is absolutely right to recognise that when we're talking about big cases like the prorogation case, you were talking at a very difficult constitutional situation, and I think it's one of those areas where you can blow that out of context. I don't think that was a case where they were weaponising parliamentary sovereignty. I also don't think it's a case where there's a misreading of parliamentary sovereignty. I think we have to think and ask ourselves, why do we want Parliament to be sovereign? Well, because it's a democratically elected body. And that's Parliament that is the democratically elected body. We draw a government from out of Parliament, but the government is indirectly elected, and we need both political and legal checks over a government of whatever political persuasion. When we're thinking about this idea of comity and protection, I think we have to recognise that the courts are there to look at these long-standing principles. They can recognise when legislation might have been enacted that has missed how this might have an impact on a long-standing principle. They can also recognise when general legislation might be applied to an individual in a way that undermines rights, and they can recognise when the government has gone beyond the powers set out in legislation. I think that's an important function of the court. It's not what parliamentarians are there to do, and we need the courts to go away and check those decisions.
Thank you. There's some feedback on the line which they're just trying to fix. And yeah, actually, no, come a bit further forward, because I think the issue is that we're talking too quietly rather than too loudly, and they've had to adapt. Richard, I want to just add in Trevor Taylor's question. Were Miller, I mean, obviously you focus on the Miller 1 and 2 judgments as one of the number that you think the courts got wrong. I oversimplify. But Trevor Taylor says, look, we've got to look at the context. They were extraordinary circumstances, and do they really need to be counteracted, as they didn't frustrate Parliament? Quite the contrary. They actually put power back into the hands of Parliament.
Well, extraordinary context, it's true for both of them. And I don't anticipate, especially given the parliamentary numbers have changed so sharply, that we'll see a repeat anytime soon. And the Supreme Court in the second judgment tries to say this is a used bus ticket, this judgment. It's good for one trip only. Don't come back. A court cannot control the reception of its judgment in that way. And it's a unanimous judgment of the Supreme Court that makes some bold claims about constitutional principle. I think expands them in ways that really do open up possibilities for much more sweeping litigation in the future. And the concern about weaponising parliamentary sovereignty, I have to say, is not just mine. It was shared pretty expressly by the Divisional Court, a very strong court of the Lord Chief Justice, Master of the Rolls, President of the Queen's Bench Division, in resisting the invitation to review the lawfulness of the prorogation. So, I mean, everything here turns in a way, and Alison's right, you've got to read the cases carefully, of course, and figure out what's decided, what the context is, what they stand for, what their implications are for what follows. I think I've done that work. I might be wrong, but I've suggested here are the problems, the discrete problems that arise. And here's why they warrant an answer. And the thought, I mean, I see this a lot, I think, which is, well, where's the foul, given that these just empower Parliament in some way? Well, I think they displace the balance between our institutions, which we're all concerned with. The traditional balance that's well established in law. And if you're willing as a court to modify the legal bounds that apply without acknowledging it, which they very clearly did in the second judgment. I think the first Miller judgment is much more arguable, actually. I think it's wrong, but arguable. If you do that, then you do undercut the confidence that people have in the law being applied faithfully in difficult circumstances. No question it was a hard and unpleasant political context, the crisis of a kind. And that's, I think, where you really got to have the court saying, well, we're going to stick very, very precisely to our remit. And I don't think they did in that case. I hope if it came again, they would do otherwise, but we'll see.
Stephen, you want to come in?
Well, I wanted to come in very strongly to agree with what Richard was saying about the impact of the decision, because it's very easy to discuss all these decisions on the basis, was this a good decision or was it a bad decision? But what is important is its impact on how people see the courts operating. Do they see the courts coming to a decision which more or less the whole world thought the government was going to win in Miller 2? Lord Sumption, although he subsequently supported the decision, predicted beforehand that the government was going to win. People see the law not being applied as everybody expects it to be applied, and that goes right across the board. If you don't know what the law is going to be, you don't know how to behave. And I I have to get on my hobby horse about whether Miller 2 was supporting parliamentary sovereignty or not. 4 weeks before the Miller 2 decision, Parliament had passed an Act of Parliament that set out specifically the days during the autumn of 2019 when Parliament could sit and not be prorogued. The government undertook a prorogation that conscientiously complied with those dates. The Supreme Court seemed to think that was a coincidence, but I prefer to think it wasn't a coincidence. What government was doing was complying with the Act of Parliament that set out when Parliament should sit during the autumn of 2019. And what the Supreme Court came along and said was, what Parliament decided about this is not good enough. We're going to impose extra restrictions on when Parliament can sit during the autumn of 2019. And that doesn't seem to me to be supporting parliamentary sovereignty. It seems to me to be showing contempt for it.
I have another question that's come in for you. Well, it's for the panel, but I think it touches upon particularly some of the points that you were raising. And it's from Alexander Horn, who says, organisations like the GLP, the Good Law Project, have used crowdfunding to pursue what might be seen as political litigation. Is this an area in need of reform? And I should just say, he adds as a second follow-up question, is there a risk that the use of crowdfunding promotes popular rather than meritorious litigation, or is it just a consequence of restrictions on legal aid? Do you want to start? Yeah.
Well, I think the way to reform it is to make sure that political litigation, that the law does not allow for political litigation, that the issues that are political are left to be resolved by politics. I don't think you should control how people provide funds for litigation. You should provide what remedies are available from the courts, and they shouldn't be remedies that provide political benefits rather than remedies to the people that are actually harmed by the conduct in question.
Do you want to go next, Alison, and then Jonathan?
Okay. I think we have to understand what you mean by political. Do you mean political in the sense of I was politically motivated to bring the case? Well, what does that mean? Am I politically motivated because I think this decision was wrong and I want to change it? Probably, but that means I just don't agree with the decision. And if I agreed with it, I wouldn't bring judicial review anyway. Do I mean there could be political consequences? Well, again, we're talking about judicial review. This is a lot of decisions that are controversial and will have political consequences because we're challenging decisions of governmental bodies. I think what we're getting at here is, why is there crowdfunding in the first place? Is there crowdfunding because there isn't enough money in legal aid for individuals to bring cases, in which case we need to think carefully about how we fund legal aid? The other element about crowdfunding that I think is legitimate that we need to take a thought about is, how do we decide which of these cases are the ones that get to court? And should there be some kind of filtering system and some awareness of those who are putting money forward for these cases, of which ones have a strong legal claim and which ones don't have a strong legal claim? And there could be a justification for a filter there. But I think a lot of what goes on actually goes on at the filtering stage in the courts themselves. They're looking for a legal argument. The argument, I didn't like this decision, isn't going to get you very far in a judicial review case. The argument, here is a legal error, and this is why there is a legal error, is what the courts are looking for. And I think that is a good way of trying to filter out purely politically motivated. And as Lord Reid points out in the SC case, they are aware of these aspects of two bites of the cherry cases, and they do think very, very carefully about judicial review in those cases.
Jonathan.
Well, again, boringly, I'm going to agree with much of what both Alison and Stephen have said, but I'll put it the other way around. Most people, when they bring a judicial review, don't do it purely because they think the decision is unlawful. They bring the case because they don't like the decision and its effect on them or their business or their freedoms or whatever it is. But it's right that for that case to get anywhere, they should show that the decision was wrong legally, and that's the job of the court. The job of the court, we would all agree, is not actually to assess its own view of the merits of the policy or the underlying politics, but to determine whether the decision was unlawful. But that doesn't mean that the motivation of the person bringing the challenge may be about the policy, may be about the substance of the policy or its effect on them, and that's a fact of life. But it's important to keep those two elements distinct. Like others, I'm less fussed about the basis on which cases are funded. I'm more fussed about the tests that are applied in deciding them, and indeed the test to be applied in whether they're allowed to go forward or not. And then you're into the question of what the test for permission should be, and the test for standing, which, as I mentioned, has apparently recently been tightened up in one of the cases involving the Good Law Project. So that would be a way of ensuring that cases don't get to court where they are purely political and where there isn't an arguable legal point. But final point on this, from time to time the government, any government, does complain about the volume of unmeritorious cases and the need to weed them out. But the truth is, for any organisation dealing with whingers and unmeritorious complaints and allegations is just a fact of life. And there will always be cases of that kind. And you do need some kind of fair system for deciding which ones are, in fact, unmeritorious or vexatious. And it can't just be for the government to decide that we're just not going to deal with cases from, say, a particular category of claimant or whatever. So even for weeding out the purely political, unmeritorious, groundless cases, you need some kind of threshold, and that threshold ultimately has to be a legal one. There has to be some kind of legal test.
Thank you. I'd like to move on to...
Can I
go
come on
ahead,
this one?
Richard.
'Cause
Yeah.
I will disagree and say I think, I mean, obviously what political litigation is extremely important, but I want to touch on the crowd funding point, which Alex raised in his question. And I'm not an expert in how one would reform or regulate this sort of thing, but I think there are pretty good reasons for concern. Because sums of money are being raised to pursue litigation where the attraction is pitched quite clearly as certain political objectives will be accomplished. Obviously, there are lawyers involved. They make arguments that have a legal form, of course. Some of them are more or less plausible than others. But there are reasons to worry, I think, without going into any particular claim, that exaggerated claims are being made to the public about what can be achieved by way of litigation. That once the money is raised, you're going to keep spending it, so of course you're going to pursue appeals and carry on. Even in some cases where the prospects really are extremely low and should be extremely low. And I think this is a problem in terms of the way legal profession is relating to the public and a problem in terms of the public representation of litigation. And Jonathan's touched on the standing cases recently. And if the Good Law Project has made a contribution to the law of standing, then hurrah. But it wasn't the point of the exercise, clearly. Now, as I say, I have no proposal for how one would regulate crowdfunding, but I think there are many barristers, clearly, and Alex may be one of them, who have concerns about this mode of the legal profession relating to the public. And I think you end up with a problem. You don't have the discipline of having a client. The client is a zombie. It's going to carry on regardless, and it doesn't exercise proper control over its lawyers. So I am concerned.
Thank you. The word comity has been used a lot. Actually, I'm going to start with Alison. One, could you briefly explain it for the benefit of those who are not lawyers? And secondly, there are two questions that have come in about comity, which are broadly the same. One from Pravar Petka saying, we talk about comity as a desirable account of the relationships between Parliament, courts and the executive, but does it reflect real practice? And the other one has just disappeared, but it was on the similar lines. Is it actually working practice? Can it be strengthened?
Okay, thank you. Comity, I'll try and not give you a PhD thesis on comity. What we're talking about, in a sense, is interinstitutional respect. So it's about each institution understanding its own proper constitutional role, being aware of the constitutional role of others, and trying to respect the boundaries in some sense. And the reason we refer to comity so often is because of the uncodified UK constitution. We don't have a system that says, here is Parliament, here are its precise powers, here are the courts, here are their precise powers. A lot of these are worked out through the way in which they interact with each other, and that's why comity, this idea of interinstitutional respect, is so important. And a lot of what we're talking about when we're thinking about, are the boundaries in the right place, should we rein the judges in, is about understanding whether we think these institutions are no longer respecting their particular boundaries. Do I think at the moment there's respect for the boundaries? I think for the most part, yes. we can all point to specific examples where we don't think they are working. So a recent one from the Supreme Court decision a couple of weeks ago in a case called Craig, which Sir Stephen and I, I'm sure, will disagree on to some extent, was the ins and outs of what happens if a court makes a declaratory judgment. So it declares what the law is, but it wouldn't necessarily say, and that means you then have to do something. And this was a case declaring that not commencing a piece of legislation in Scotland, so bringing it into force, was unlawful, but it didn't force the government to do so. Then a problem arose because a couple of years passed before this came into force, and there was a statement from Lord Reid that we expect in those situations that the government will respect, and that's an element of comity. It's about respecting the different institutions. We expect these institutions to act in a way that respects other areas. There are blips, but I think for the most part, institutions are aware of their limits. And I think where we get these problems at the moment is because we've just come out of a very difficult set of circumstances in the UK Constitution that were normal circumstances, and were not normal circumstances, and that's why we're constantly asking, has comity broken down in some sense?
Thank you. Does anyone else want to comment?
Well, I have long experience of politicians being very unhappy with the courts and about losing cases. And this is well documented in the IRL report that it's a very, very common thing for ministers to sound off about the fact they've lost a case, and in one sense, why wouldn't they? If their particular policy or decision's been overturned, they're not going to be happy. Sometimes that spills over into very public criticism of the judges, and sometimes that goes too far. But normally, sanity, intervenes and prevails. What we've seen more recently, slightly unusually, is some of the criticism coming from Lord Chancellors and law officers, the sort of public criticism, including perfectly polite, but quite trenchant criticism of the kind that I quoted from. That's a bit unusual, but such criticism is not unknown. If it goes too far, and I don't think it has, like others, I think there are some tensions in the air, but that's not unusual. If it goes too far, that is a bad thing, because if either the suspicion is that the courts are out of control and are making stuff up, that's not good for anybody's confidence in the independence of the judiciary or the proper functioning of the legal system. If, on the other hand, it is thought that as a result of this row between government and the courts, the judges are backing down and are being cowed, and I don't think they are, but if we were to reach that point, then that's bad too, because that suggests the judges aren't truly independent either. So that's why we keep coming back to this idea of kind of balance and a kind of, that comity is the word, and that's why it's important we try and stick to it.
Thank you. Do you want and also there's a question which is incredibly popular on here, so I'll give you a chance. There's two. There's one which you're going to love, which we'll finish with, but another one which is that essentially, are we giving in to elected dictatorship if we defang the courts? Defang. To weaken, if we weaken the courts, yeah. John Denham says the balance of power moves back towards Parliament. Does this inevitably mean weakening protections against elective dictatorship?
I've never believed in the elected dictatorship. Lord Hailsham, I mean, it's almost 50 years, I suppose, since we started hearing about the elective dictatorship, and I've never believed it. I think parliamentary democracy does actually work, and the idea of an elective dictatorship is just the, I think Jonathan used the word whinging of people who find that democracy doesn't give them the results they want.
Use it in that context,
I did want to say something, though, about this idea that, that the courts should be changing things back if they've gone too far, and that they shouldn't be cowed. I mean, I take a rather purist view of this. I think once the law has been established in the courts should stick to it. I don't think that they should regard it as their responsibility to put things right that they've done wrong. I think if you reach a situation where that's the right thing to do, and there's a lot of argument at the moment that it is the right thing to do, you get to some very nasty questions about judicial appointments. Because if the answer to getting the law right is to get the judges right, then you're in a very different sort of context than you are at the moment, where if all the judges have to do is apply the law and it's obvious what it is, then it doesn't really matter so long as they're good lawyers who is appointed.
Okay, thank you. Richard, you want to add
Yes,
something?
thank you, Catherine. So I agree with Stephen about the idea of the elected dictatorship, which is a sort of recurring trope in public discourse, but amongst lawyers in particular, who often, or at least some lawyers, have a deep lack of confidence in the political constitution. I think that does bubble up, not just through the Brexit, long Brexit saga, but before that. If you think that Parliament's simply not up to the job of controlling the government, then you might think it's your job to compensate. Now, you might not think that. You might think, well, Parliament should just pull its socks up and get on with the job. But that view about the political constitution as dysfunctional, as failing, as we're one step away from disaster at every stage. You know, thank God the courts can stop the government from doing insane things. Are there to rescue us. Saviour theory, I think, is misconceived. It misunderstands the constitution. It's not consistent with comity, I think. It misunderstands the relationship, the balance that should hold between them. Where parliamentary accountability is a real thing, electoral accountability is real. They do constrain. Now, they don't constrain in a way that means, well, we can just abolish judicial review and proceed as though it wasn't a relevant part of the constitutional machinery. Of course not. You know, the constraint on government to follow the law is a vital constraint. I may disagree with Alison on the declaratory point. I think it's not just a requirement of comity, it's a requirement of law. If the law is declared, this is what the law is, then the government should faithfully fall into line with it. I mean, it may propose legislation to change it, but that's a different matter. Now, defanging the courts. Defanging is a sort of way of framing this that makes it look like the technique of a pseudo-dictator or elected dictator, looking to crush sites of opposition. But the courts shouldn't be a site of political opposition. They should be a site where you can vindicate your legal rights and insist on legal powers being observed. And any approach, any legislative technique that stopped the courts doing their traditional role, including in the vast range of cases that don't involve judicial review, would be highly problematic, wildly controversial, and should be opposed. But to look at some of what goes on in judicial review and think some of this gives rise to a problematic type of litigation that's compensating for, or attempting to compensate for, parliamentary accountability, and that should be corrected. I think that's perfectly consistent with the constitution of a parliamentary democracy. You can argue about the details, of course, we can argue about them all day long, but it's a mistake to parody that as a proposal to abolish the law, the rule of law. It's simply not.
Thank you for that. The elephant in the room that's not been mentioned is, of course, why can't we have elected courts?
Okay, shall I start with that?
Yeah, go ahead.
Elected judges would be terrible at being judges. They wouldn't be very good at independently applying the law to the cases before them, including cases involving the parties in question. There's a reason we have independent judges and have had for centuries, and it's something to treasure, namely that they are protected and elevated and given the status and the confidence and salary and all these protections, so that when they hit a case, including a hard case with popular people or unpopular ones, they won't decide with a view to currying favour later. They will apply the law as it stands and not be distracted from it. And thank God.
Does anyone else want to say anything on that?
On elected courts, no, but on elective dictatorship, yes. If
Go
I
ahead,
may.
go ahead, and keep speaking into the microphone.
Okay, I don't necessarily think you can say elective dictatorship. I think you have to think very carefully about it. But I don't also think you can say that the political constitution is itself perfect. I think you have to think very, very carefully about how we elect governments, what our voting system is, what the internal rules of Parliament is, and how far the government can, if it wishes, control the parliamentary timetable, meaning there isn't necessarily a huge amount of time to debate issues. This means things can be missed. Should the courts go in and automatically correct outcomes? No. But should the courts be there to perform their own proper constitutional role? Yes. And I think, and maybe we should be thinking in terms of political reform if we want to deal with elected dictatorships rather than judicial reform.
Thank you. What I'm going to do, there's one last question, which I do not want you to apply your legal skills to in interring or disaggregating it, but I think the question will be pretty clear. And then I'll give you a chance if any of you want to say anything in case you feel you've not had a fair opportunity. The question's from Armina Lunat, and it says, should Parliament be granted extended sovereignty when the Tory government is currently unable to account for its own crimes, like the parties held at Number 10? In other words, should Parliament step in and sort all of this out? And this was one of the most popular questions that has come in. And because I've been sitting here, I don't know whether what's happened on Partygate this morning, but we know that 20 tickets were going to be issued today. Jonathan, do you want to go first?
Oh, thanks. Well, maybe yes and no is the answer. So we have a legal process that is now underway, and like you, I don't know where it's got to enforce the law as it stands, as enacted by Parliament and by ministers under powers conferred by Parliament, and that should be allowed to run its course. I don't think Parliament should step in and try and interfere with that, because there is a legal process and the police are onto it, and if there are fines, then they should be subject to the legal process that applies to that, and so on. So I don't think Parliament should step in and try and interfere with that. When all that is done, whatever the outcome may be, does Parliament have a role in holding the government and ultimately the Prime Minister to account for what went on in Downing Street, whatever it was? Undoubtedly, yes. And that is political accountability for the conduct of government and the conduct at the heart of government. So that's I'll stop there because I've answered the question no and yes.
Stephen.
Well, yeah, I want to give a relatively limited answer to this too, but I think I broadly agree with Jonathan. I think parliamentary accountability and the political constitution does work. I think if abstract politicians are found to have broken the law in a way that the public disapprove of, they will pay a political price for it. And that is the way that the political constitution works. And I don't think the law needs to go interfere with that end of the process. Obviously, whether or not there is a breach of the law is going to be a matter for the courts. But enforcing it against politicians or restraining the powers of Parliament because you think politicians are out of control, I think is misconceived. I found a quote I was trying to find earlier on, which is, it's from lots of people actually, but it's Machiavelli warned us almost 500 years ago not to be fooled into thinking that calmness and solemnity are the mark of a good polity and noise and conflict a symptom of political pathology. Just because there's a row doesn't mean that the answer to it is going to be decided in the wrong way.
Thank you, Alison.
Nothing much to add, really. If they've committed a criminal offence, then you use the law, and yes, they should be accountable to Parliament. I don't think that means extending the sovereignty of Parliament. That's precisely what parliamentary sovereignty is there for, to hold the government to account for its actions, as well as to enact legislation.
I agree with everything my colleagues have said, except Alison's last tiny remark. Oh, exactly. So I don't think it's a question of parliamentary sovereignty. It's a question of parliamentary accountability, political accountability. And the government will be quite rightly hauled over coals by Parliament and the public. And we'll see how that plays out.
Thank you. Does anyone else want to say anything that they've not had a chance to say? In which case, our timing is perfect. We've just brought the session to an end within the time frame allowed. I would like to remind you that the next session follows straight on from this one, which is a natural sequitur: can and should Parliament take back control from the executive? Now, I imagine some of you who've been here since 9 o'clock this morning are thinking, my God, where's the coffee break? In fact, because there is so much rich and wonderful material, there is no coffee break, but don't panic, because there's coffee downstairs, so if you want to nip out and grab yourself a cup of coffee and come back, please feel free. I suggest you do it not all at once, because otherwise we'll have a de facto coffee break and you'll lose lunch. But there is coffee ready downstairs if you are desperate. Now, before I close, I want to thank incredibly warmly the wonderful panellists for giving of their time, their expertise, and also their disagreement. As you can see, lawyers, contrary to popular belief, are not a homogenous group who have one view on all matters, that they are very different, and these are really vexed questions. Thank you so much, all of you, for giving of your time. Thank you very much indeed. Thank you hugely, that was lovely.
Well, no, lots of TV.
I thought you just refreshed. Yeah. Okay.
Thanks. Yeah.
Oh, good.
Yes, that was distinctly grubby. I didn't really want to drink from someone else's glass. I didn't want to in the best of times.
Where are you going?
Caffeinated. It's probably my fault that we do these programmes without sufficient breaks built in, because I like to get through as much as possible, so I apologise for that. But without further ado, we want to move on to this next session. Can and should Parliament take back control from the executive? And I'm delighted we've got a fantastic panel here to discuss these issues. On my far right, Mark Darcy, who's been parliamentary correspondent for the BBC for almost 20 years.
Almost 20 years. Anniversary is this Easter.
Oh, fantastic. So all but 20 years. To my immediate right, Professor Meg Russell, who, as well as being a senior fellow with the UK in a Changing Europe, is director of the Constitution Unit at UCL and is in the process of finishing up a book on Parliament during the Brexit process. I don't know if that's a sore point or not, the book. But anyway, I've mentioned it now, so you've got to do it. On my far left is Karen Bradley. Karen has been MP for Staffordshire Moorlands since 2010 and is chair of the Parliamentary Procedure Committee, which was elected in January of I'm losing track, 2 years ago, 2020. And last but not least, Nikki DaCosta, the first ever, I think, Director of Legislative Affairs within Number 10, worked for both Theresa May and Boris Johnson, brings a host of, I imagine, well, certainly expertise and I imagine memories about the interplay between government and Parliament. So just to kick us off, I mean, Mark, you've got 20 years of experience, and in terms of that sort of vast sort of experience, where do things stand in terms of relations between government and Parliament now compared to earlier times?
Well, I think the Parliament of 2019 is a pretty strange beast. One of the things to remember about it is that most of its members are still learning their trade a bit. At a time when they would, in previous parliaments, have been sort of safely bedded in and become wise in the ways of Westminster. You're talking about a period of getting on for a year and a half where they weren't really in Parliament very much, and where debate was, in any event, when they were in, pretty restricted. The virtual chamber was, I think, a pretty poor substitute for real parliamentary debate. You never had the whites of a minister's eyes rolling under pressure, the beads of sweat forming on the forehead as the crowd rounded on them, because ministers could deal with a fairly stately procession of speakers in a known order, and they'd always have a fairly good idea of where the next question was coming from. And naming no particular former education secretaries or former community secretaries, I can think of a number of people who might not have survived some goings over in the Commons during that period. So that's part of it. And then there's, if you like, the craft skills of being an MP. How to function in committee, how to function in select committee, how to get legislation sort of amended, tweaked, or whatever, are things that this generation of MPs, through no fault of their own, are late in absorbing, because those processes haven't been in play in their full sort of state for most of their parliamentary experience. And they're gathering speed now, I think. Some of them are kind of gathering round assorted gurus and sitting at their feet, you know, learning the ways of Westminster a bit, and so things are improving, but it's an odd state to be in. And the other point I make is a kind of meta point, really. We're now, which applies to earlier generations of MPs, we've now had a period of about 6 years when there has been a great overriding issue, not necessarily the same issue, but first it was Brexit, then it was COVID, and now it's Ukraine. And I think during that period, a lot of the kind of other issues that would normally be the stuff of politics, while they might have been going on, there's been a lot less steam and force and attention behind them. And I think that's beginning to show in threads of policy away from those great issues. Because, and there's a certain sense of unravelment about some of it that I think future governments will be picking up those threads for quite a while to come.
I mean, in terms of picking up threads, I want to sort of talk to you two a little bit about this, because you've got direct experience of working in or with Parliament. And that point that Mark made about parliamentarians still learning the ropes, is that true, Karen? I mean, do you feel that? How do you notice it?
Yeah, I think that's absolutely true. I mean, I wanted to pick up on one point Mark made about the hybrid parliament and it being a poor substitute. Nobody denies it was a poor substitute, but it was better than nothing.
Yeah.
And we were one of the few national parliaments that actually sat through the whole pandemic. And I absolutely agree that there was, you know, the whites of the eyes were not seen. It wasn't just a case of you pretty much knew who was coming next. You knew exactly who was speaking next, because the tech meant that there had to be a call list that was absolutely set out as to who the next speaker would be. So I think it did fail to deliver the kind of scrutiny and keeping ministers on their toes and keeping ministers from challenging their officials. I have been a minister, and I can tell you that if you know you're going to get a question on a sticky subject, a UQ or something like that, where you're going to be asked repeatedly about the same thing, you challenge the officials to make sure that you have every answer that might be needed. So I think, you know, we didn't have that. There was no doubt about it, but it did sit, and we did at least allow some scrutiny. And certainly towards the latter part of the lockdown, I think we saw MPs start to get the confidence to actually start to challenge in that forum. It's very difficult to challenge in a forum where right at the beginning we weren't even having divisions. And once we started to have divisions and people realised that they could start to challenge, I think things did improve. There were technological changes we could have brought in and could have tried, like, for example, virtual interventions, which would have meant for more dynamic debate, but that was not something Parliament chose to go down that route. We instead obviously wanted to go back as soon as we could to the traditional way of sitting. But then going to that point about the way the Parliament feels, it doesn't feel like a Parliament that is 3 years old. It feels like a Parliament that is very new. And there is still a tribalism in Parliament. I mean, one of the things that you realise very quickly, and I came in 2010, so it was coalition, but you realise very quickly that actually, you know, the line of we have more in common than divides us is absolutely true. And there's only 650 people at any one time who were going through the experience of being an MP. And it's a unique experience. Every parliament is different. Every parliament feels different. And you will have people who actually, on opposition benches, who you might disagree with on policy, but actually you have an awful lot in common with as an individual. And we've not had that coming together of cross-party groups in a physical format until very recently. And that's the thing that breaks down the barriers. That's the thing that actually helps you to get your job done. There's an awful lot as a backbencher you can only do if you work across party on issues. If you've got a campaign you want to run, you need it to be cross-party so that you can demonstrate to the Speaker it's worth calling the amendment, you can demonstrate to the government that there's a will to get things done, but you can't work cross-party if you're all very tribal. And I think it's only now that we're starting to see some of those tribal divisions break down, and Parliament will be much more effective as an institution if we have got much closer cross-party working on common issues. And
with the 2019 intake, do they still feel like new kids? Do they still act like new kids?
I don't think they act like new kids. I mean, it's very offensive to say to someone who's been an MP for 3 years that you're a new kid, but they are finding their feet in terms of the way procedures work, because they simply didn't have the chance to look at the many different ways that you can raise issues. You know, for example, a petition. So you can submit a petition, present a petition on behalf of your constituents at the close of business every single sitting day. There is an opportunity to do that. Those petitions, actually, they might seem quite minor compared to the big Downing Street petitions where you get the debate in Westminster Hall. But on a local constituency issue, presenting the petition is really important. Well, you couldn't do that in a virtual parliament. So that's just one little tool that I know can make a big difference for your constituents that MPs are still finding out about. And I think we will see, I suspect, over the course of the next 2 years, a change in the way that these kind of opportunities are used by particularly 2019 intake, when they realise that there are so many opportunities to raise their issues, and it's not just a case of turning up to every statement and putting in to speak in every debate.
Okay. I would like to think that some of them are still getting lost on the estate quite regularly, though.
Well, I was told the story that on his very last day as an MP, Tony Benn was shown a new route round Parliament. So I think it's fair to say that we all are finding our feet getting around Parliament, even those of us who've been doing it for 12 years.
And Nikki, your job's a bit like herding cats at the best of times, the job you had in Number 10. Was that made worse by the specific circumstances of a virtual Parliament?
I was on maternity leave for some of the period, so I came back in October 2020. I think just to differentiate with the bits of the system in government which manage legislation, you have the Whip's office, which will deal with the 24/7, i.e. what's the vote that's coming up in the week ahead, and how do you handle that? And they will be doing much more of the arm around the shoulders. Without a doubt, their jobs became a lot harder. Partly because the role of the whips should really be an HR function in many ways. It shouldn't be transactional. It should be about building a relationship with your particular flock, such that when you have to ask them a question about a piece of legislation or where they are on a vote, then it's not just how are you going to vote on this? You're doing it in the context of a relationship. But what you have with a virtual parliament is it becomes much more about, okay, there's this X issue, I'm going to phone them up, I'm going to ask them about that specific thing. And that breaks down the degree of information that might be exchanged, the degree to which the MP might feel comfortable expressing where they are. And then that means that the data that the Whip's office gather is going to be that much more blunt, it's going to obscure potential things that are going on. Particularly if the MPs are not necessarily feeling familiar, they may feel that the conversations are uncomfortable, they may again obscure where they are, and so therefore it becomes much harder to manage a particular division. So in terms of my job, yes, in terms of, I mean, this is the most rebellious parliament, and we everyone tracks that. It is because we've been in government an awfully long time. I think, I go back to my days in opposition Whip's office, and the only thing we had to give out was office space. And I used to remember that whenever an MP was standing down, the little notes used to come in and say, oh, so-and-so's got an awfully nice office, could you consider me? I mean, that was the extent of your patronage in opposition. And I think that government MPs, because we've been there for so long, have grown complacent about the benefits of being in government, which used to act as a restraining influence on rebellions.
Right.
There's sort of a tendency to bank, I only got a hospital and X million pounds invested in the constituency. That's not enough to bind me for the next vote. What's the next bit? Right. And so you've got all of that coming together to make it much harder to manage the parliamentary party, in addition to not having that social contact.
Go on, Karen.
Could I just add something to that? Because I'm absolutely right. But the other thing that was missing during lockdown was the Whip's interactions with departments. So the job of the Whip is not just to get the MPs to vote through the division lobby, walk through the division lobby. It's also to manage the departments, to make sure they're not bringing forward policies that MPs will automatically... don't use your political capital up on getting MPs to vote for something they hate when you don't have to. And if you've not got Whips sat in the departments every single week, and I've been a Whip as well, part of the job is sitting in the department and going through what the policy agenda is and saying, you're going to have a problem with that, that's not going to go down well, and that was missing as well. So it was twofold. It was both not being able to put your arm around people in as MPs in the tea room, but also not being in the departments to manage departments coming through with things that MPs were going to explode over.
Okay, and Meg, you've spent as much time as anyone, I think, reflecting on Parliament and its role in our system. Where do you think we are in historical terms?
I think we're not in a very happy place, to be honest. A lot of my work over the last 20 years or something has been arguing that Parliament is a more powerful actor than we think, that there's lots of subtle influences that go on behind the scenes, that this idea of executive dominance is a bit of a myth, as we were talking about in the last panel. But actually, I think we've seen a turning of the corner in recent years. you're not plugging your own report, Anna. So this report that is being published today,
I'm trying to turn the iPad on.
where I am flattered and delighted to have the first chapter in, it asked us to reflect under 3 different headings: 1, Brexit; 2, COVID; and 3, Boris Johnson. And those things have kind of, well, no, they haven't followed exactly in that sequence, but all of them have taken us in rather unhealthy directions, I think. I mean, under Brexit, it was obviously a horribly difficult situation. You had a minority government that was trying to deliver a controversial referendum result, where its own party was completely split. You know, that is very, very difficult and creates a tendency, a mindset, which I think, you know, Nikki has freely admitted to being part of this operation, which seeks quite a lot to exclude Parliament, because Parliament's kind of a dangerous place to be if you're in that situation as a government. And that builds on a general view, which always exists in the civil service, that the more we can get done without sort of parliamentary interference, the better, because we know best. Ultimately, that ended up, obviously, with the prorogation, which was kind of a huge and difficult moment, and also, I think, very important in this context, the expulsion of the 21 Conservative rebels on the 3rd, 4th of September 2019 by the brand new Prime Minister, which creates a sense of uneasiness, I think, in the parliamentary party when a Prime Minister is prepared to be as brutal as that. Well, both of those things upset the balance, I think. And then we had lots of headlines about Parliament through that period, lots and lots of negativity about Parliament in the media. We had things like the Attorney General saying that Parliament's got no right to sit, the Conservative manifesto accusing it of thwarting the will of the British people. So you've got a very clear kind of fight back against parliamentary power by the forces of the executive, I think. Then, just when we've had the general election in 2019, and we might be thinking we're going to get back to some kind of normality, because we've got a majority government again, those Brexit arguments are primarily behind us, then we get COVID. And that had the effects that other people have spoken about in terms of the sort of cultural effects inside Parliament. But what I don't think anybody yet has mentioned is the effect on the legislative process that it had, which had some emergency legislation, but then more importantly, a huge reliance on delegated powers in secondary legislation, which MPs and peers had barely any opportunity to look at, often things coming into force before they'd even been laid before Parliament, which created a real sour, it was very unhealthy, I think, on a principled basis, but also it created a real sour mood on the Conservative backbenches, and led to some major rebellions, which then did see some eventually rowing back on the part of the government. You've then got, on top of that, sort of Boris Johnson's character, which I think, you know, his premiership is shaped by those events, clearly. And I think an executive that's getting into the habit of trying to get stuff done without the usual kind of consultation with Parliament. So we've seen bills being rushed through very quickly. We've seen government amendments at very late stages of legislation in the House of Lords. We've now got worries about various kind of fast-track procedures that are being proposed. So the whole Brexit Freedoms Bill idea looks like there's a potential there to have a whole new kind of delegated legislation to make major policy changes without proper, I would say, proper reference to Parliament and proper sort of healthy levels of scrutiny. And we've got the stuff about human rights as well. And I think the thing that concerns me about this, one of the things that concerns me about it, is that adage which I worked more than 20 years ago for Robin Cook when he was leader of the House of Commons, and he used to say, good scrutiny leads to good government. And I think we've heard that already from the panel. If you dodge scrutiny, the risk is you take bad decisions and you regret it later. There are good reasons for conferring with Parliament, doing things out in the open, as Karen was saying, you know, when you're a minister and you know you've got to defend something in Parliament, you think through really, really carefully what it is you're doing and whether it is defensible. And if the government gets out of the habit of doing that, it's an unhealthy parliamentary culture, and there's a risk that it also leads fundamentally to bad policy. And I think we need to get out of this now. I think we've got a very fragile position at the moment, and we need to get back to better principles of parliamentary scrutiny and consultation.
Okay, Meg's just gone through my whole list of questions.
Sorry.
And we'll come back to SIs, we'll come back to urgency, we'll come back to parliamentary time in a minute, but I'll let you come back if you want to, Nikki. I get the sense you don't wholly agree with Meg's characterisation.
Because I think there is this default, and Meg in her characterisation does not mention the fact that we have this conflict because of the referendum between a direct command from the public, which was a majority command, and parliamentary democracy, in which the MPs are going against a command that the government has been instructed to fulfil. And in that context, it's absolutely right. That's where you get the tension, because you've gone directly to the public. And when you therefore, so this idea, and I always want to try and break this down, when people say it's Parliament versus the executive, we have an executive drawn from Parliament who gains the legitimacy through majority government. And so when people say, is Parliament stronger? Well, we need to break it down. Do you mean, is it that the government is stronger vis-a-vis the opposition? Is it the Commons versus the Lords? What relationship are we focusing on here? And then I would break further down in terms of the particular trends. You know, if we look at the amount of hours spent on legislation, if we look at the way of amendments, etc., there is a tendency, and I believe it is influenced by a political lens, and you know, and I see it with there's a subtext, and it's a little bit like a Whitehall mode of thinking, and I see it come through with the Hansa Society Institute for Government, UKIC, the document, where it is Parliament by its very nature, more is good, versus the electorate send the MPs to Parliament to deliver on the manifesto. And the government gains its authority for doing that, and the point of Parliament is scrutiny, but also to enact the legislation that the public have voted for. And therefore, executive control is not in itself a bad thing. Now, the question is about where the boundaries are. So to pick up on the issue of 21 MPs, these were not novices in rebellion. It was the end of a very long, I served both Theresa May and Boris. And one of the problems under Theresa May was we never drew the line. We always said, let's be more reasonable. We must show that we are the reasonable ones. And it got us precisely nowhere. And so you have a new Prime Minister come in, and he is coming in at the end of a game in which Parliament is already deadlocked, which is already legislated, I think, at least 3 times against the last Prime Minister. And in that situation, it's that. So where is the accountability? And the point was, we couldn't get to a general election. There was no way of breaking it because of the Fixed Term Parliament Act. And in that situation, there are very, very few levers for the executive to deliver on an instruction from the public. And so there is a theology, an ideology coming through.
1 second. I mean, we're going to talk about prorogation in a sec, I sense. But, I mean, the first thing is, wasn't Boris Johnson guilty of exactly that crime under Theresa May then? That Theresa May was fulfilling a mandate from the British people to do Brexit. She had a Brexit deal. And Boris Johnson, amongst others, were voting against it. That presumably irritated you every bit as much.
Yeah, and you'll have seen, and I was always very consistent. I will always, and from the sidelines, arguing about how we achieve it. But it's legitimate. The Parliament got to a situation where it wouldn't vote for anything. And we saw that through the indicative votes, etc. It wasn't that Parliament had an alternative plan. It just didn't want to do anything, nor would it let the public decide, nor would the opposition let the public decide. And that is not an acceptable way for Parliament to behave.
Meg, I mean, Mark and Karen, if you want to chip in, then do. I'll give Meg the next word, and then I'll come back to you.
We're in danger of taking each other's lines because you just took one of mine there. But I completely agree with Nikki that it's a bit futile to talk about Parliament versus government. And this is something which I've also echoed in my work a lot. I quote this classic piece by Anthony King, which was written in 1975, saying, when you're talking about Parliament, who is it that matters? And he said it's the government backbenchers that matter, actually. And this was not an institutional row, I don't think, between government and Parliament. It was a story, and it's somewhat obscured, I think, by the fact that we had a minority government, which is actually a fairly unimportant thing in the bigger scale of things, which was that we had a divided governing party. We had a divided government, we had a divided cabinet, but we certainly had a divided parliamentary party. So yes, I mean, if you think that action should have been taken more quickly to stamp down on that rebellion, Boris Johnson, Priti Patel, Jacob Rees-Mogg, and various others would have been thrown out of the Conservative Party
Well,
in
before
early 2019.
Yes, but you start. It's notable that you choose that rebellion to focus on, and not the rebellions that started with the EU withdrawal bill in terms of an insertion of customs amendments. And that, for me, is a political choice as to which cadre of MPs that you're choosing to focus on.
Yeah.
Mark.
Yeah.
I was going to say, I wonder if Theresa May, as she stepped across the threshold of Downing Street as Prime Minister, realised quite what a hiding to nothing she was on. As Meg was saying, her cabinet, her party were all incredibly divided. And they had an instruction, as Nikki says, from the British people, but an instruction to do what? Because that instruction did not cover whether we were in or out of the customs union. It didn't cover whether we were in or out of the single market. It didn't cover a host of questions raised by Brexit. And there's a serious problem there, because you had the interlude when David Cameron was still Prime Minister after the referendum, when it wasn't right for him to try and answer those questions. And then you had the interlude after Theresa May became Prime Minister, when she was trying to answer those questions and come up with an answer. And we had mantras like Brexit means Brexit to kind of fill the gap for a while. And during that time, you could see the splits yawning ever wider within the Conservative Party. And the real problem they had there is, what on earth was she supposed to do? Did she try and impose a vision and then see enough of her colleagues vote with the opposition to bring her down? Did she try and get everybody together in a sort of group hug and say, hey, we're all Conservatives, let's work together, we've just about got a majority and we can always ask the DUP for a bit of help, which I think was essentially what she tried to do for a while. But what she couldn't do, and which a lot of people seem to think she should have done, was to have reached across to the other parties to assemble a soft Brexit consensus, which would have shattered the Conservative Party to smithereens for about 3 generations. So no palatable and or workable options were available until such point as there was a stamp of authority. Now, Boris Johnson came in and the prorogation manoeuvre fairly rapidly followed as a way of trying to break the deadlock, but that seemed to generate a far bigger backlash than he could ever have conceived of. Then we saw the expulsions. Then we finally saw the snap election, which gave him a majority for his way out. But the idea that, you know, it's not a very pretty way of assembling a consensus around a great national question like Brexit, to put it at its gentlest. And I'm not sure that even the election manifesto on which he ran really answered all the questions raised by Brexit. I'm not sure anybody ever has now, and hell, we're, you know, best part of 5 years on from it. And here we are still sort of stuck wondering what's going to be done about certain essential questions. So it's an extraordinarily ugly situation. And blaming the weaknesses on Parliament of this, what you got was a process where the whole country was split down the middle, and it's extraordinarily difficult, therefore, to resolve any questions on it. And Theresa May was left trying to party like she was Tony Blair in 1997 without having gone through the small formality of securing a majority of that size, hence the mess.
Well, I mean, with the benefit of 2020 hindsight, could Theresa May have done this, given the situation she was in? I mean, was it hiding to nothing, as Mark puts it?
Well, I just wanted to come in to say that, I mean, there is this, we're having this discussion about Parliament and the strength of Parliament, and one of the reasons we were in the situation we were in, and it's been referred to already on Brexit, was the withdrawal agreement, the withdrawal bill, and the meaningful vote that was inserted largely by rebels from my own party, that meant that there had to be a meaningful vote in Parliament. And once that meaningful vote was passed, Parliament actually had the key. Parliament was the only body that could possibly decide whether Brexit would happen or not. And what Parliament then failed to do was to actually deliver it. So, you know, we've said this already, and I'm just making another point that this was a situation. But I would also go back to another point that has been raised in light of Ukraine, which is that vote that we had, you'll recall, on the Syrian intervention back, I think, in 2013. And their Parliament, it was a very strange situation because there was a motion that the government put forward and an amendment put forward by the opposition, which were almost identical. The only difference between the two motions was that the government amendment said it had to be on humanitarian grounds, that the intervention had to be for humanitarian grounds, and the opposition amendment didn't say that. But what you saw was an opposition party that voted for their amendment and against the government motion, and a government that voted against the amendment but for their motion. It all fell down, and it was Parliament showing that it wasn't actually that strong. And we can reflect, I'm sure, in years to come about the messages that that sent around the world about the strength of the UK Parliament and the Westminster Parliament. But there are plenty of those that are speculating today that some of those failings and failings that happened around parliaments around the rest of the world perhaps strengthened Putin to feel he could do what he has done in Ukraine. And, everything does come back to you. I always say when I bring constituents into Parliament, I always make them walk past the War Memorial. Because I say, if you don't, as an MP and a parliamentarian, look at this and remember that you have life and death in your hands in a vote that you are taking. And it might not be life and death immediately after that vote. It might be many years down the line. But there are consequences of the way Parliament behaves.
Could I fire a quick question? Forgive me, Karen. Do you think that the Syria precedent still sticks, that there still has to be a vote in the Commons?
No, because there was then an intervention that did happen, a military intervention, and the vote was a confirmatory vote, if you recall, after the action had been taken. So I think that precedent has now been broken. But that was a really difficult precedent, which goes, and it was a hangover from Iraq. It was something that actually dated back to 2003, but Parliament was still bitter about. 10 years later made the decision, and now nearly 10 years down the line, perhaps we're reaping the consequences.
And just to that specific point, explicitly, Theresa May rode away from that in 2018. The Cabinet Manual is clear, although we can debate the status of the Cabinet Manual as an explicitly political document for political ends, in which there, for urgency and the need to preserve the ability of the government to act swiftly in certain circumstances. And Theresa May both reaffirmed the movement away from the convention, which I believe was very well received by officials in FCDO who had been absolutely horrified at the emergence of the convention, and in addition that it is not necessarily a vote that follows, although more likely that there is a debate. And I think that any Prime Minister needs to consider quite considerably whether they then try and row back to the Cameron precedent that was starting to emerge, because I think there are concerns relating to that, and then your ability to project power internationally.
Well, I want to just pick up. Did you want to?
Yeah, I just, if I may, excuse me, I can rake over Brexit for at least 110,000 words, and I can show you the proof. But you both mentioned, I think, the meaningful vote. And I think there is a very interesting, we have various what-ifs in the book. There are lots of them. There are too many to fit into 110,000 words. But one of the interesting questions is, what if the meaningful vote hadn't been secured? And obviously, Nikki, I've heard you talk about this. You were doing your best to stop it. And I think it's a very valid question. But ultimately, we're forced to conclude that there always had to be a meaningful vote of some kind, and the government had conceded that right from the start, because there needed to be implementing legislation. And I think there is a danger, there's a bit of the story which hasn't yet been mentioned, that there was part of the trouble in Parliament was that there was a group of MPs who, as Theresa May got pulled into some of the sort of compromises around Brexit, especially around the Northern Ireland border, who were prepared to go all out for a no deal. And then there's a counterforce which is saying we have to stop no deal, which is where things got very, very nasty. If there had been no meaningful vote, there still would have been implementing legislation. And if the no dealers had voted down the implementing legislation, we would have crashed out without a deal. So that is the case. Isn't it? There would have been a vote in the end, and it could have been undermined by the rebels on the ERG side who wouldn't compromise.
So you're seeing it on a single level as the conversation happening in the UK versus the conversation happening in the EU. And one of the things that, Theresa May, in sitting down with the rebels, particularly going back to those meaningful votes, was, and the guidance that we had back from Tim Barrow, from across Europe in terms of all the diplomats, was that, and she was being told, if she could go to council with her hands unbound, the dynamics of the negotiation would change. And I was told that repeatedly under Theresa May for all those that are focusing on the deal. And this is relevant, and it's relevant to then what we had to do under Boris, because we needed to get to October Council on the 16th of October with just the slimmest chance. And that was why the dates are as they are, to bring Parliament back before Council, so it's sitting, so it can consider a deal, but in creating the time for negotiations in which the EU perceived the dynamic has changed, and that Parliament will not come in to block the deal or to force the Prime Minister into a different direction. She has greater ability to negotiate. And so for me, the meaningful vote, and it comes back, I remember the very, very distressing conversations that the Prime Minister had relating to that defeat in 2017, was that she said to people that she had been friends with for decades, can you not trust me to go and negotiate? I'm heading for a deal. And the answer was, no matter how long we've been friends, it's not that I don't trust you, Prime Minister. And there was always some justification, and you always hear it from rebels. Prime Minister, I'm only trying to help you by inflicting this particular defeat. You'll see, it's for your own good. And I have to tell you, for a woman Prime Minister, this is a particularly galling message. But this is the thing, it was never a single level at which this conversation was happening. And I tell you the result, when I left Theresa May over the deal, and I was on the outside, Clement Beaune asked me to come to the French embassy. And we had a conversation there in which the question was, when do we put something on the table? When do you think we should do that? There was something around, they would move, but they were asking, what is Parliament going to do? When are they going to intervene? They were watching everything the MPs did because they thought, maybe we don't have to offer something. And that shapes, therefore, the strategy we had to have under Boris Johnson. And you can't keep on looking at it through a lens of just what's happening in Parliament, but the overall strategic game.
This is where we need the EU specialist on the panel to ask whether that
Well,
was
I've
ever
got
gonna
loads of
happen.
questions about the EU side that come from that, but I'll save them for our next conference. We'll invite you back and talk about that. But, I mean, I suppose this brings us to prorogation.
Yes.
In the sense that the way you're talking about it, you still maintain it was absolutely the right thing to do, given the state of the negotiations at the time.
Yeah, so the analogy that you have to think about it is Boris wasn't sitting down to a new game of chess. So if Theresa May has sat at the table, what you've got left pretty much is he's got a king and a pawn. I'm not a chess player, but I'm just going to this is the analogy. All the pieces are gone, and you've got a lot arrayed against you. And so you've got very few, or to use an analogy in terms of the cards, you've got very few cards left. You've tried everything. The Prime Minister's shown that. She stayed at the table a very long time trying this and that. They've tried to create an alliance with Labour. They've done everything. So you're kind of looking, or to use another analogy, you're looking at the weapons cupboard and you've got a dagger and a bazooka.
I think you should use Twister.
Okay, so yes, more analogies, that's what we need. And so in the context of that, you then map out with the key objective, how do we get the Prime Minister to October 16th with the chance of changing the negotiation dynamic so that the EU come to the table? And for that to happen, they have to believe that no deal is achievable, because only if there is that room for manoeuvre does something change. And in the context of that, we know already we're dead in the water. So you have to immediately admit you're already dead. They will legislate against you. They don't trust you, Boris. They already don't trust you. You've got a couple of days before, once you're Prime Minister, before summer recess, but they will move against you in the September. That is a certainty. And Philip Hammond, it was very interesting. We got an awfully lot of good intel because everyone was very keen to tell the press of that, their clever ideas. And I remember early on in July, Philip was saying, oh, we've got a plan, and this is kind of what the legislation will do. So we know what the legislation is. We know from our own sources coming back the kind of the shape of it. So you've got to already bank in the things that are already going to happen to you. And then you think ahead. And then you have to factor in the Fixed Term Parliament Act. You have no way of breaking the deadlock. There is just no way through it. You've got to think about, the 14-day period, etc. There's no way through to going to the public. And in the context of that, what have you got left? And it's essentially about controlling time. How do you create an interval in which the Prime Minister can go and negotiate without the EU saying, well, we don't need to do business with you because you can't deliver? And so in that, you've not got many choices, and prorogation is an executive matter, not subject to a vote. And you look at the precedent, and one of my personal bugbears with John Major is he prorogued for 21 days over a recess, which is a direct parallel. And in addition, despite the protestations of the likes of Reeve, etc., the prorogation period both satisfies the Northern Ireland Executive Formation Act, where they stitch these moments to take control in Parliament, and it gets people back before October Council, and it's over the conference recess. So there is no period of time, and we come back following the summer recess. So there's no period in time in which Parliament is actually blocked, and we're not doing any legislation in that time. So it's not that we lost time to doing legislation that we needed to do. So it satisfies all these criteria, and it's a wing and a prayer, but that's all we've got. And the point was to change the dynamic. And so that's why it's important to say finally to these rebels, I'm sorry, you have rebelled and rebelled, and you've crippled one Prime Minister, and you're not doing it to a second. And calculations on maths, if you're going to lose by 10, well, it doesn't really matter if you lose by another 20. So here is finally a penalty for your rebellion, because if you won't stay with the government on the one matter that they're elected to do, then you can't be relied upon.
The problem that I have with that story, which I've heard before because you told it on Katie Ball's podcast.
Don't promote other podcasts.
Is when I listen to you say that, I just think, on whose authority, on whose...
The people's! The people commanded it in a referendum.
In a referendum. So why didn't Boris Johnson vote for Theresa May's deal? Wasn't she acting on behalf of the people?
Yeah, but this is... The deal did not pass, and it's not just by one that it didn't pass. By the biggest loss ever.
Yes, but the third time round, if the Spartans had voted for it, it would have gone through.
Yes.
So it was actually the hardliners in the Conservative Party that prevented Brexit happening. And then Boris Johnson became Prime Minister. He was Prime Minister for one day of parliamentary scrutiny. You seem to have just admitted that he faced a prospective vote of no confidence if Parliament had been allowed to come back. How is there a democratic mandate for shutting down Parliament?
Where's your conclusion on that?
Well, you just said we were dead. They would have gone for us,
legislated
etc.,
against us,
etc.
is my phrasing.
Yeah.
Mark, do you want to... Oh, Karen?
and these rebels, these serial rebels that he threw out, they included Philip Hammond, they included David Gauke, they included Rory Stewart. They were sitting in the cabinet. They voted for the deal 3 times. Ken Clarke voted for the deal 3 times. These were the people who got thrown out. It just doesn't add up to me in terms of accepting that you have accountability to Parliament and you are only the government because you are acting on the authority of Parliament. And yes, a referendum, but Theresa May was trying to do that too.
But to take that point, these are MPs that were Conservative MPs who had a problem with what the government were trying to do, were legislating with the opposition, taking control of the order book, and basically crippling the government. And you'll see that right now there is a running thing on opposition days that if a motion tries to take control of the order paper, that is a no-go, whatever the subject. And this is the point. If you are a Conservative MP and you vote to cripple the government, but you won't have the balls to vote no confidence, then I'm sorry, the whip should be removed.
Mark, do you want to dip your toe in these choppy waters?
Gosh, I've been enjoying this. This is absolutely fascinating to get a bit of a behind-the-scenes view. And one thing that I suspect that people like Nikki don't entirely get about the hacks is that we don't see much of what's going on under the bonnet. So it's fascinating to see how these calculations are laid bare. I mean, dangerous ground here, attempting to venture an opinion on the right. But I don't think anybody emerges from this wearing a sort of robe of purest white, because everybody was playing hard politics and everybody was playing the most bare-knuckle game they could, not excluding the opposition. And yeah, I think Nick Brown was playing this for all he was worth to try and bring the government down and shatter the Conservative Party in the process. And that's his job, and it's not remotely a criticism of him. That's what he's there to do. So you're operating in an intricate, tough and increasingly nasty political environment. And the people who got the whip withdrawn surely can't have been that surprised at the end of it all. I talked to Dominic Grieve quite a lot during that period, and it was hard for any journalist in Westminster not to talk to Dominic Grieve quite a lot in that period, and very interesting he was too. But I certainly didn't get the impression that he felt he had a long-term future in Conservative politics at the end of this, and he was in the happy position as leading counsel. You go off and make twice the money for half the hours, so or probably rather more than that. But I think you also got a situation where a lot of people felt this was so nasty they were quite happy to walk away. And most of the people who lost the whip probably did not weep bitter salt tears at being out of it in the end. They were just trying to do one last thing with a kind of scorpion sting before they went. Where it leaves us now, though, is that we have a feeling in the Conservative Party that the whip will be cracked and that if people go too far off-piste. And so you watch, for example, the phalanx of distinguished ex-cabinet ministers who are in various positions on the committee corridor and elsewhere. And they're some of the most interesting people in Parliament, because I think quite a lot of them, and I don't know what Karen's position is on this, quite a lot of them do not feel that they are permanently beyond the pearly gates. They could go back through those pearly gates into office again sometime, and they conduct themselves accordingly. which is why, take Robert Buckland's current demi-rebellion over a small aspect of the Nationality and Borders Bill. I think this is an exercise in showing your claws, but not quite sinking them into the flesh. We shall see.
Claws, flesh and pearly gates, Karen.
Well, I was just going to make the point that I think one of the things that happened during that very, very difficult period was that Parliament actually lost touch with the public. And there was a view that the public were less enthusiastic about leaving the European Union than they had been during the referendum. And that simply wasn't the case. Mm-hmm. The public were more enthusiastic for it. There was lots of people who said if we had a second referendum, the public would vote differently. No, they'd have been so cross, they'd have voted more in line with Brexit than changing their vote, because they didn't want to be told what to do, and they didn't want Parliament to tell them what to do. And I mean, I honestly think that the big mistake that Labour made, and we talk about Nick Brown being a doughty warrior, and he certainly is, but actually, if Labour had abstained on any of those votes, it would have gone through on a split Conservative Party, and the Conservative Party would have torn itself apart. Totally torn itself apart. We'd have left the European Union, but there would have been no Conservative Party left to speak of. And that, I think, was a tactical mistake that was made, and that was because somehow Parliament and MPs had convinced themselves that the public mood had switched. And I think what we saw in the election, when it finally came in 2019, was it absolutely hadn't. The public just wanted to get Brexit done. They just wanted it to happen, and they were going to vote, and as they did. And this is what I think Theresa May thought she was going to see in 2017, was the same kind of figures for her, because that was what was coming up on the doorstep. What wasn't anticipated was that sort of the anti-Brexit vote coalescing around one candidate in each constituency, largely the Labour candidate. And going back to two-party politics in 2017, whereas in 2019, the public just said, we've had enough.
Could I just say one thing about Labour? Totally different, well, not a totally different subject, but nothing about Theresa May, really, but about Labour, because Mark mentioned earlier, and it's another what-if in our book, should she have done a cross-party deal? And you said it would have broken the Conservative Party. I think it would have broken the Labour Party as well. Mm-hmm. And in terms of, I said at the beginning that we'd seen, well, maybe I didn't actually say at the beginning. I said that I've written quite a lot about there's more power in Parliament than you think, but also another thing is that Parliament has strengthened itself. There's been a trend towards parliamentary strengthening with greater rebelliousness, with more powerful and better resourced select committees, etc., in the run-up to the Brexit period. But one of the ways in which Parliament has been disempowered is in the way that we choose party leaders. And a huge problem in this period was Corbyn, because you had a Labour Party leader who didn't even enjoy the confidence of his own parliamentary party. And I think that in that period that you were talking about, Nikki, whether or not I misinterpreted what you were saying, there were definitely plots over the summer as to whether an alternative government could be formed. And the primary reason that it couldn't was because of Jeremy Corbyn. So actually there were huge problems on the Labour side as well. And I just think it is untenable to think that you can give party members the power to pick a leader who is then expected to lead in Parliament. The Conservatives are much more sensible on this. You can vote no confidence in your parliamentary leader and they're gone like that, and they cannot be re-elected. And if Labour had had that rule and had chosen somebody else in 2016, I think the things that you were talking about, Mark, would have been at least a bit more feasible. And in the end game, you might have ended up with, I don't know, would it have been Keir Starmer or Hilary Benn or Yvette Cooper or somebody able to lead a government that might have been able to do some sort of a different deal or whatever. It would have ended differently, I think.
You can see an entire new volume of those Ian Dale alternative politics stories coming out of this. But it's a perfectly fair point. And one of the things about the 2019 election was that both Labour and the Lib Dems had their leadership problems, in the sense that Jeremy Corbyn was hugely targeted and I think rather wilted under it, but so did Jo Swinson, which meant that the senior opposition leader who seemed to sail above all this wasn't even in Westminster in the shape of Nicola Sturgeon. And she could just sit back and bide her time.
Right, I'm going to take back control. I could sit here and reminisce all day. I think this is fascinating, but we ought to sort of
it's
try
very
and tackle...
cathartic.
Yes, we'll end this therapy session for the moment.
Buy my book. You can,
You've said 110,000 words now. I mean, you've lost your audience. Just to pick up on one thing that Meg said, which was the link between good scrutiny and good policy. Do we all think that holds? I mean, one thing that crosses my mind is I wonder if we'd be having the fights over the protocol we're having now if there had been more time for scrutiny, because that was rushed through quite quickly, wasn't it? I mean, do we think Parliament gets enough time to scrutinise legislation?
So, as chair of the Procedure Committee, I would say absolutely not. I think Parliament does need more time to scrutinise. I also think Parliament, we don't use Parliament for general debates enough and for time for MPs to vent their views and make their point. Sometimes people just want to be able to say their piece. And you know, during the virtual Parliament, when we had these everyone participating on Zoom and 3-minute time limits. I mean, there was no scrutiny, there was no debate. It was simply everyone reading out their piece so they've got something that they can put in their local paper and on YouTube. And you know, the debate should be a proper debate, and there should be proper scrutiny, and there should be time for things to you know, to be looked at line by line. And it does make for better policy, because it does mean that the policy that is developed in Whitehall, which is usually utterly brilliant, and the underpinning underneath it is utterly brilliant, and there's a reason why we have right rounds and we have this long way of doing things, which is incredibly frustrating, I know, for anyone who comes into government and says, why can't I just do it like this? But collective responsibility means we have very strong governments who are able to deliver, because every member of the government has signed up to the policy, even if they didn't have a chance to look at it. Actually, both making the point that I think during the pandemic, when we went to more Cobra government, so it wasn't government by right round with detailed scrutiny, it was just ministers in a room making a decision on the hoof, I think we did see that actually there wasn't the underpinning behind some of the policies, and some of the policies did fall down because of that lack of underpinning that the scrutiny and the right round and everything else gives us. But it's then, how do you translate that scrutiny that's already happened in Whitehall into scrutiny in Parliament so that MPs can understand it? And Meg made the point that it's the government backbenches that perhaps are the most powerful. I think that's, you know, we've seen more of that, particularly during COVID, that it was rebellions, and I was one of them at one point, several times, rebellions by backbenchers, where it, when, on my case, it was always because I just went, this hasn't been thought through. This is not a policy that has any proper underpinning behind it, and it will collapse and fall down, and I'm not voting for bad law. And I think, so we saw both policy made on the hoof, but then Parliament scrutinising things in insufficient time. You know, I think we had one debate that was a 3-hour debate. We had something like 90 speakers in the 3 hours. I mean, it was just impossible to get all the points across. And that meant that things went through that arguably could have been an awful lot better if there had been more time devoted by Parliament to unpick those problems, with whips also, that we've said, whips at the beginning of the process, saying, you know, can we just challenge this? Can we check this is okay? Scrutiny does make for better policy. However much, as a minister, you hate the call that says a UQ has gone in this morning and you're answering it, Minister, that is not a pleasant place to be, but you've got to be able to go out there and defend that policy, and that means that you challenge.
Mark, if you've got on scrutiny.
Completely agree with pretty much all of that, and even in normal times, if you like, in inverted commas, I think that a lot of, I mean, things like report stage in the House of Commons can often be absolutely farcical. The wacky grouping of amendments, the selection, and really quite substantial propositions that probably don't cut too much across government policy but have cross-party support, just sort of disappear with a flip of the chairman of Ways and Means hands. And it's worth noting that there is one section of the legislative process that the government doesn't control, and that's report stage in the House of Lords. And that's where many of the, in fact, all of the troubles on current bills actually emanate from. So, yeah, was it Nationality and Borders Bill, 19 amendments, Police Crime Sentencing and Courts Bill, similar sort of number, big amendments to the Health and Care Bill, and just watch for the election bill as it comes through report stage in the House of Lords next week, because the solids are really going to hit the air conditioning over that one. But in the meantime, you have the situation where a lot of these issues are fired back to the House of Commons, and the any impertinent changes their lordships might have made are just rapidly dismissed rather than debated. Incidentally, one small footnote here is during the Police Crime Sentencing and Courts Bill, the government at report stage in the House of Lords attempted to introduce a vast suite of swinging new public order offences. You can be in favour of them, you can be against them, but they're big. And they would have made a great deal of difference to the conduct of protest in this country. And they were being introduced in the House of Lords, the bill already having gone through the Commons, and had they been fired back to the Commons, would have had a pretty minimal debate, if any at all, at that stage. Their lordships rejected them out of hand, so they won't be seen then, but will probably rematerialise after the next Queen's speech. So you've got that part of it. One other bit of scrutiny that's well worth flagging up as well is just legislative consent motions from the devolved assemblies. Now, these are treated as if there's like, it's kind of like clicking accept all cookies or I accept the terms and conditions, and they deeply, deeply resent when their concerns are simply ignored. That's quite a problem, and it's going to be a bigger one.
Karen, do you just want to come in quickly on something?
Yes, so just 2 points on that. First of all, I mean, we shouldn't forget that what's said in Parliament does have implications in the real world. I know it's sometimes difficult to believe. Now, my background is I'm a tax accountant. I used to work on doing tax returns for business and individuals. And you can, of course, look at Hansard to look at what the intent of ministers is behind a piece of legislation. And so I'm talking about here sort of the 90s and the 2000s when I was looking at things. So let's think that scrutiny has suddenly got worse, because you would look at something and what does the general anti-avoidance measure mean in the 2006 debt instruments bill? And it would be anti-avoidance is that businesses pay their fair share of tax. Well, what does that mean in the real world? What is the fair share of tax? How do you define that? So, and second reading debates, effectively, what you get is often at committee stage, that someone will stand up and say the same overarching debate rather than a specific debate about the clause we're speaking about that's being scrutinised at the time is not helpful in the real world when you're trying to get things done. The second point I'd just make is about LCMs. My committee is carrying out a piece of work at the moment looking at the way that the 4 legislatures of the United Kingdom work together. And the evidence we have received from the 3 devolved parliaments around the way LCMs work is just, well, it's brutal. And it's overwhelmingly unanimous that LCMs are just an appalling situation at the moment, including, talk about rubber stamping, having to sign off an LCM after a bill has got royal assent. I mean, if we really are serious about making devolution work, about making all parts of the United Kingdom feel that they're part of this process, you can't turn around with 3 minutes notice and say, oh, by the way, can you sign this LCM off because it's already had royal assent, but we just need it as a nice to have. It's not acceptable.
I suspect quite a few of these issues will be touched on in the next session, but Nikki, on this question of scrutiny.
So I'll pick up a couple of things. Again, there's the creating conditions for additional scrutiny, and then there's the actually taking up that opportunity. So when bills are programmed, so programming happens a lot in the Commons, and at root is at the pace at which a bill moves, that is negotiated in usual channels. The opposition always get the business in advance, and there's a discussion. How many days do you want to report? What feels right for you, etc. And so, in as much as people might complain publicly, or Labour might say, "Oh, there's not enough time for this bill," behind the scenes, they signed up to it and said, "Yeah, that feels about right. And if you don't mind, we're planning a big parliamentary event, and it'd be quite nice if you could let our MP, can we get rid of the votes on that day?" So we can. So that's kind of there's the presenting of the issue, and then there's some of what actually happens behind the scenes, which is important. So there are abilities to negotiate for more time for bills, both in usual channels and also backbenchers. So if a group of backbenchers are concerned about a particular bill, and they go and speak to the whips, particularly if they're getting, if there's 25 of them, 30, you're getting into defeat territory, the threshold being around 40. If that number of MPs go and say, we really want this to slow down, then the whips are more likely than not to give that time. They will bend over backwards. And so there's a degree to which a sort of forced helplessness that can be challenged a little bit. I do think there is a trend towards greater use of statutory instruments. I was on maternity leave when it happened, although actually the vast majority of COVID legislation actually did not go through under the Coronavirus Act. The secondary legislation was largely under the earlier Public Health Act. I do have a concern about the use of secondary legislation. Whitehall is addicted in my view. It's the nature of it. If you're looking for an easy path and you haven't got your policy ready and, they go, oh, and can we just take a power and come back to it later? I think there is a default in that. I think, the more you can have on the face of the bill, the more constraints you can have around a power. I think that's important. We've all seen that the numbers of pages of legislation secondary go like this and the primary is like this. We've got to tackle that. But I would also say it also needs to take into account the need to do business as a government. And that is, and so you have to balance the two things. So when people come forward with very complicated natures of an additional scrutiny measure, I would just say, well, just put more to affirmative, look at that. I think it's right to, we'll go too much into the detail, but you can look at how debates are granted, etc. On LCMs, I would like to know the example because coming back to Mark's point of behind the scenes, sometimes, for example, there was an LCM in which a lot of notice was given, there was a bit of a mess up at the Scottish end. The officials didn't get it to the minister in time. Then there was a lot of public declaring and wailing and gnashing of teeth, but actually what was basically some administrative errors. So again, the problem is, and maybe it is because not much is seen from behind the scenes, is that sometimes political point scoring can be made, particularly in the region of LCMs, which doesn't necessarily take into account both sides of the particular.
I can assure you it wasn't Scotland in this
case.
Okay,
all right, in that case.
And what do you make then of the suggestion that with all that body of retained EU law, there's going to be some sort of special procedure to hasten our ability to change it? Because there's an awful lot of law within. Yeah,
there's about 1,500, I believe, is the element of. I mean, part of this is going to be pragmatism. I mean, if you just look at the large legislation, a government has to get on with its programme. You have a limit of about 25 to 27 decent bills in a year-long session. Mm-hmm. You're going to probably want to do a lot of that that's politically salient, and you try and reduce the amount of legislation that's tidying. So where you have changes which are largely tidying, or basically, there was always a default by some departments of saying, oh, let's just copy and lift the EU stuff, rather than well, do we think it's any good? And so if you are going to get through that 1,500, then you probably need to do some sort of bucketing of how do you look at this. And that's probably what I would imagine the Brexit Freedoms Bill is much like the EU Withdrawal Bill. It creates the framework in which things look at it with different classes of sort of, and you probably look at, what kind of things do these particular bits of law affect? There's ways of doing it in a way that addresses the concerns and creates a framework for you revisiting that. So, no, do I think the 1,500 bits of retained EU law should be done by negative SI? No, but I probably don't think that a blanket rule is the most appropriate rule, nor do I think it would be appropriate to have 1,500 bills in primary legislation, because you just, Parliament, people will be going, well, what have you been doing 15 years later as you gradually churn through this? I mean, that's to basically calcify our legislative system because we've inherited so much from the EU, and that's not pragmatic either.
Okay. So, Meg, so on this question of scrutiny, but also I think to a related issue, which is the issue of who controls parliamentary time. And I'm keen to ask that partly because it means I've finally got to a question on Slido about whether we should have a business committee that sets the Commons agenda. But I think that's quite closely linked to this issue of scrutiny, whether or not Parliament could and should have greater control over its own agenda.
Yeah, okay. Maybe I could say two brief things about things that have come from the other end of the table and then come back to that. It's interesting that we're having this conversation about programme motions because Robert Buckland mentioned programme motions earlier as a sort of a step in the wrong direction by Labour to give control of the agenda to the government. Nikki makes them sound very sort of consensual, and I accept what you say, that there is a lot of discussion behind the scenes with the whips and so on. But what there isn't is the ability on the floor of the House to amend them. And of course, one of the sort of last big rows on Brexit was over Boris Johnson's withdrawal agreement bill, where the proposal was that it should have 3 days in the programme motion. The programme motion got voted down, because that's all that MPs can do, vote it down. If they'd been able to amend it and say, well, maybe not 3 days, but 10 days or something, maybe that could have been got through. In the end, he just withdrew the bill and pushed for a general election. So personally, I would see it as a good thing if we could have a bit more control on the floor of the House of Commons, not just leave it to whips, but actually have a vote on not just whether the programme motion itself stands or falls, but whether you want to change it in any way. I think that would be a step in the right direction. On the retained EU law point, this all seems very hazy at the moment, and I think this is something that people really have to watch out for, because you're talking about the 1,500 things, and you know, that's a lot. It's not surprising it's a lot after all of the decades that we spent in the EU. And of course, for decades, there were whole areas of law where we did not have control. So environmental protection measures, consumer protection measures, employment protection measures, and so on. A great deal of that was coming from the EU. And fair enough, you say, Brexit, we're not doing that anymore. We want to send power back to the UK Parliament to make these decisions. But if that's going to happen, it really does need to happen. People in the UK Parliament really do need to take active decisions if they want to change some of these policies, because they weren't actually all imposed on us completely reluctantly. We were part of the negotiating process. A lot of that policy is pretty controversial within parties as well as between them, and I think that there is a responsibility on the government to put major changes of policy that flows from EU law to Parliament, and for MPs to actually scrutinise them and decide if they want them. Because it's one thing to say, we're bringing power back to the UK Parliament, and yes, we have a government which doesn't like some of these measures, and fair enough, it's got an 80-seat majority, let them vote to overturn them. But to dodge Parliament and just overturn them without that, I think would actually be contrary to the whole taking back control narrative, the original one from the referendum. And I mean, you called this panel Taking Back Control. We called this report Taking Back Control, which is a report the Constitution Unit published last January about Parliament getting more control of its business. Purely a coincidence that we both chose the same title, I'm sure. I think
catchy phrase.
And on the business committee point, I mean, I was a specialist advisor to the Right Committee, which the Right Committee on Reform of the House of Commons, which proposed that we should have a business committee. That never was brought into effect. To be honest, I was always sceptical about a business committee because it all depends who's on the committee and so on. I think it wouldn't be a bad thing, but it wouldn't necessarily change the terms of trade, because if it was just a meeting between whips that was formalised, you'd get more or less the same outcomes. I think what matters is the chamber. And one of the other things that the Right Committee proposed was that there should be a vote on the timetable for the week in the chamber, which gives some power to government backbenchers if they're not happy with things. And if they can side with the opposition and say we need a bit more time on X or a bit less time on Y, I think that would be a good thing. The other thing that, and I'm afraid Nikki was part of doing this, I'm sure she would defend it, but during those Brexit years, we saw the extent to which the government has control over the time that goes to the opposition. So the opposition is guaranteed a certain number of days per session, but the government can hoard them up. We had a whole 5-month period during Brexit when the opposition got no days at all. I think that was wrong. And actually, going back to some of the things that Mark was saying about, you know, we didn't really know what Brexit meant. Was it customs union? Was it single market? And so on. In my interviews for the book, actually one of the leading Brexiteers said to me that when it got to the indicative votes, that was a discussion that probably should have happened a very long time before about whether you wanted to take all of those things off the table. And if the opposition time had been used to have those discussions, if it had been made available and used, then perhaps actually that would have been good for Theresa May, because those things would have been dismissed and the support for her deal would have been greater. But by blocking the opposition days, those debates couldn't happen. So I think more power to Parliament to set its own agenda in various ways. I would also give it the power to vote on prorogation, by the way, as well as on when it adjourns for the summer recess, and power to be recalled if it is in recess and there are important things to discuss.
I'm almost tempted to say we should do a whole day on counterfactuals sometime. But Karen first again.
So just a couple of points. First of all, on programme motions, let's not forget that the programme motion on House of Lords reform is the thing that scuppered House of Lords reform. It wasn't the second reading vote, it was the programme motion. I was a big fan of indicative votes. I was very much in favour of trying to have indicative votes, because I thought it's almost like that sort of... you know, you can't have your absolute ideal because there isn't a majority for your absolute ideal, so your second choice might well have ended up being what transpired to be largely the deal that Theresa May had. And I think we should have used the indicative votes process earlier. But I would just say that trying to do it as an opposition motion or using opposition days for it, instinctively, government members do not want to vote for motions that the opposition bring forward. It is just something that feels wrong. And that is true of parliaments through the ages. It doesn't matter whether you look to 97 to 2010, when government members voted against opposition motions that were absolutely none. Look, you know, I use them politically. Here's the EDM that my opponent has signed, and look, here's the motion of the opposition day that they voted against. How can they sign an EDM and vote against a motion? It's because it's an opposition day. So I think the idea that opposition days can be used to draw these things out is in reality just doesn't happen. But if it had been time that was set aside much earlier to allow the ideas around customs union and single market access and all that kind of thing to have been tested in Parliament, even second referendum, I don't think there was ever a majority in Parliament for a second referendum, but we never had a vote to test it. And I think that if that had happened and Parliament could say, actually, there isn't a majority for this, we might have made some progress. I still suspect that ultimately that was a divided Parliament and a divided country on an issue that we hadn't fleshed out what the whole thing meant, and therefore we probably would never have got there, but at least it might have been, we'd have had slightly less fractiousness perhaps.
I mean, throughout that period, one of the things that really fascinated me was for all the talk about a new sort of Brexit divide that cuts across parties, the way that party loyalties and tribalism reasserted themselves. Because what you said about the government applies to Labour as well. Why were so many Labour MPs unwilling to vote for Theresa May's deal? Because it was Theresa May's deal.
Yeah, absolutely.
Rather than because of the subsequent. Nikki?
I was just going to pick up on opposition days. I think it's worth bearing in mind, and again, to what's happening behind the scenes, it's relevant. There were two schools of thought. You'll have guessed by now that I favour a fairly, firm approach, and, if you're going to go down, be it on your feet rather than on your knees. And essentially there were two schools of thought. There was Julian Smith as Chief Whip to Theresa May, and it emerged initially. So first of all, you have Gavin Williamson and his approach to opposition days, where he creates a situation. And I go back and forth. The difficulty is you are shaped by your parliamentary experiences, and I come from a hinterland of opposition where you value opposition days and you vote on them, because when your turn comes again to be in opposition, that may be your only, the only thing you have. And so therefore you don't break that convention. And there was some egregious abuse. So for example, we won't go too much detail, but the nurseries SI, which started to provoke the advent of the humble dress and those kind of things, and you start to have that come through. So I agree. I would, there was a philosophy. There was one of them, which is either, we should take things head on. Don't let them gather steam. If you've got a customs union amendment, it goes down. See them down. Go for it now, because it will get worse. And I will always say, the longer you leave something out there to gather amendments and signatories, the worse it gets. You may gain time, but they gain time too. They're assembling their troops at the same time as you are assembling your troops. You're unlikely to win. And so from that perspective, op days should have been stitched in. We probably should have taken some fights, because I think it has created now a situation in which sort of the strength has gone out, or the feeling that, do we have to do this op day? And it makes for a slightly weaker parliamentary party in terms of sticky votes. Although I say against that, more generally, just on prorogation, again, need to look at it in the round of a vote. The issue about the end of the prorogation date is it creates an issue for the ping pong of the final bills in each session. So you create the wiggle room. Prorogation dates are always a range of dates to create the flexibility for the Lord's business managers to avoid bills crashing. And so that's relevant, and therefore having an advance vote when actually a lot of things are going to be changing quite quickly in the Lords, it's kind of all those kind of things coming together. I think a business committee, your right to direct the business of Parliament comes from winning an election, and that belongs to the executive.
Okay, we've got a minute left, and I've ignored Slido, not because I wanted to ignore Slido, because I thought this is fascinating, but this question has come up in various guises. It won't surprise any of you, I don't suppose, but we're going to pose it, and you've got a few seconds each, or you're keeping me from food, which you shouldn't do. Should misleading the Commons be a resigning offence, and are there ways that Parliament can be better empowered to enforce this if it should? Mark.
Tam Diel once said in the chamber that truth in this place is the fulcrum of our system. Absolutely. If you can't believe what a minister's said, if a direct lie, and bear in mind that there is quite a lot between misremembered, misunderstood, slip of the tongue, and direct conscious lie. But if a direct conscious lie in the Chamber of the Commons goes unpunished, well, what then?
I wrote down in anticipation of this question the words from the Ministerial Code, page 1, Ministers who knowingly mislead Parliament will be expected to offer their resignation to the Prime Minister. That has always been the case.
Off the top of your head? Like you remember the ministerial code?
It's here, it's here.
Oh, okay, you've written it already, okay.
But it's short and snappy enough to remember, potentially. The problem in that sentence, obviously, is Prime Minister. So what if it is the Prime Minister who's in this position? That makes it somewhat tricky. And I would come back to something that we've kind of spoken about several times, that one of the things that Nikki and I seem to agree on, that in the end, the people who matter are government backbenchers. And I would say in our political constitution, we have a political, not a legal constitution, we have the principle of parliamentary sovereignty. What that means in the end is that the keepers of the constitution, the keepers of constitutional standards are MPs, which means in practice MPs on the governing party benches. So if you have somebody in that position who doesn't resign, if you want to stick to the way that things have always operated, as Mark indicates, it is the duty of MPs to do something about it, and that means the government's backbenchers.
Nikki?
I uphold the ministerial code. If somebody, I agree on the gradation. So, if somebody is sent up to the dispatch box and has a line that's been put in saying this is the statistic, and they dutifully repeat it, and then it turns out to be false, they must correct it. So, do I think, because I think you could accidentally wipe out quite a lot of the government quite quickly of all ilks, and the paralysing effect on civil servants writing those briefing papers would probably get very, very strong. But if you knowingly mislead, and particularly on matters of great political importance or things that really matter to the public, it is very, very important how our Parliament looks and how our politicians behave. And so, yeah.
Karen?
I agree with everything that's been said.
Perfect. Well, listen, I don't know about you lot, but I thought that was utterly fascinating. So I'd like to thank Mark and Meg and Nikki and Karen. Karen, you can go away knowing that you matter. One of the few things that people seem to agree on this panel. So there we go. I hope that makes you feel better. And we're now going to break for lunch, but can you join me in thanking this panel for a fascinating discussion?
Ladies and gentlemen, thank you very much for attending this first session of the afternoon part of today's proceedings. My name is Alex Massey. I'm a columnist for the Times and the Sunday Times in Scotland. And it is lovely to be with you all here today in the dark, glorious heart of the imperial capital as we discuss what the formal title of this session is Federal UK, the Way Forward. But I think as we have a distinguished panel drawn from all four parts of the realm, we will have perhaps a slightly broader discussion on the state of the Union, state of the United Kingdom, the challenges it currently faces, and we may even have time after that to explore the possibility of there being some solutions to some of those challenges. I'm going to invite each of the panellists to speak for a few minutes representing their part of the United Kingdom, so to speak, and then we'll have a general discussion. There'll be the opportunity for questions to be asked by Slido, which I trust you all know how to do. Our panel is first Carwyn Jones, former First Minister of Wales, now Honorary Professor at the University of Aberystwyth, amongst other things. Professor Katie Hayward from Queen's University Belfast, Professor Nicola McEwen from the University of Edinburgh, and Tony Travers from the London School of Economics. So, Carwyn, if I could start with you, how do things look when viewed from Wales?
Well, thank you, Alex. Things are unclear, if I can put it that way. I mean, first of all, in answer to the question, is a federal UK the way forward? The answer is maybe, but practically it's hugely difficult. And I'm going to outline some of the practical issues there. Devolution in the UK has largely been about throwing powers at various groups of Celts in order to keep them quiet. It's not been done in a way that is symmetrical, and nor has any account been taken of the situation of England, the biggest entity within the UK. And so we have a settlement where in Wales we have a lawmaking, tax-varying parliament. We have our own version of stamp duty, we control a third of income tax, for example. We have primary lawmaking powers, obviously, in those areas where we are responsible for. Scotland goes a step further. The major difference, not the only difference, but the major difference between Wales and Scotland is that Scotland has control over its justice system and police. Wales is, bizarrely, the only country in the common law world that doesn't have its own legal jurisdiction. So the Welsh Parliament has no authority to enforce its own laws. Bizarrely, it relies on Westminster to do it, in theory. And it means that the joint jurisdiction of England and Wales is the only jurisdiction anywhere where there are two legislatures within it responsible for the same policy areas. That itself is a mess. And then Northern Ireland, where there are fewer tax-varying powers, but greater lawmaking powers, control over employment law, over equality, over driver and vehicle licensing. And I know that my wife is from Belfast. There is a roaring trade in Northern Ireland car number plates being sold elsewhere in the UK as private plates, which is a great source of income, I'm sure, to dealers in Northern Ireland. But it shows the asymmetry that exists within the UK. England, of course, doesn't exist politically. It has no existence because it has no parliament. It has no legal jurisdiction of its own. And, of course, it has no political identity in that sense, which would surprise, of course, most people in England. It's that asymmetry that's the problem. If we're talking about a federal UK, we are talking, to my mind, about there being equivalent parliaments across the UK with the same powers, a symmetry of powers across the UK, as exists in the US, as exists in Germany. And so the first question is there a demand in East Anglia for a lawmaking, tax-varying parliament along the lines of what Wales has? And I don't believe that federalism can work without that symmetry. How can you have federalism where different areas have different powers and you have a federal parliament that sometimes sits as a federal parliament, sometimes sits as the Parliament of East Anglia, sometimes sits as the Parliament of England, Wales and Northern Ireland? It's just a mess. It's not clear. Every federal system in the world that is properly federal, to my mind, has that symmetry where there is a distinction between powers that sit at sub-federal level and where there is a federal parliament that has distinct powers that are clear and where there is a separation between the federal parliament and those sub-state parliaments. It's the way it works in the US, where each state is sovereign, each state has its own jurisdiction, and of course there is federal jurisdiction on top of that because there's a federal Congress that has powers that have been defined. The problem you run into then is parliamentary sovereignty, the fetish that exists within the UK. Parliamentary sovereignty, that concept that really existed only in the mind of one man in the 19th century, A.V. Dicey, didn't exist before then. There were mentions of something similar in the days when there was an English Parliament, which disappeared in 1707. Remember that the UK Parliament was not a takeover by the English Parliament of the Scottish Parliament, and so English constitutional principles did not automatically apply as a result. There's some case law that looks at that from the 1950s. So we have this scenario where parliamentary sovereignty was invented largely in the 19th century. And if you were in the House of Commons in the 19th century and somebody said to you, there is a constitutional theory that says you can do whatever you want, you would say, that sounds good to me. After all, Westminster is, oddly enough, the institution that keeps for itself the ultimate lawmaking power within the UK, but is itself subject to no laws. Without a written constitution, parliamentary sovereignty dictates that Westminster could just simply overrule any sub-UK parliament, and that, of course, drives a very large hole through the question of federalism. I don't underestimate how difficult a written constitution is. It's not something that is on the agenda, to my mind, and it's not something that would take many, many years to develop. But without a written constitution, I don't think federalism actually works. Because as long as you have one parliament over there that has the power to overrule everybody else, then it can't be federal. Federal systems rely on inherent powers that exist at sub-federal level. So that is another issue we have to deal with. Alternatives? Well, one alternative might be to say there are 4 entities within the UK. They each enjoy their own sovereignty. They choose to pool that sovereignty in certain areas, such as defence, such as border control, such as the fiscal and monetary union, such as general taxation, and you create a union parliament that deals with those areas that are agreed should be areas that are dealt with by the union parliament. So sovereignty goes upwards from the parliaments of the 4 entities of the UK up to Westminster rather than the other way around. It's a bit of a cop-out because, of course, that system would suggest that any kind of regionalisation or regional government in England is a matter for England. And it neatly sidesteps the problem of England, but I doubt practically whether it then deals with the sheer size of England and its sheer heft within the UK and how that could be dealt with. So, looking forward to the conversation. We have an esteemed panel here, of course, but the question seems to have an easy answer in theory, but it's a lot more complicated in practice.
Thank you very much, Gavin. I mean, if we want to move from things that are complicated in practice, I think we'll move to Northern Ireland. Katie, how are things in Northern Ireland? What are the particular challenges for the smooth working of the union viewed from a Northern Ireland perspective at present? Obviously, there's the additional complication of a north-south dimension as well as east-west. And to what extent has Brexit broken aspects of unionism in Northern Ireland, and can it be fixed? I mean, you have about 4 minutes.
Very good. I'm going to make some remarks that touch on what you're asking me, and I'm going to make sure that they say things that I sort of want to put on record from the beginning. Interestingly enough, almost as an aside, the possibility of Northern Ireland in a federal UK isn't really on the cards with respect to the Good Friday Agreement. As an option, it's quite interesting that the future of Northern Ireland could either be in a united Ireland or integrated into the UK. It's quite simplistic understanding, therefore, of nation statehood. But anyway, to jump into it, there are 2 international agreements centering on Northern Ireland that shape and deeply affect the UK Constitution, and in some ways this should be in such a way that it would be evolving. So the UK Constitution should change as a result of these 2 international agreements, and that's not necessarily a bad thing. One, of course, is the Good Friday Belfast Agreement, and the other is the withdrawal agreement, specifically the Protocol on Ireland, Northern Ireland. And the reason for the existence of both of those international agreements is because, to state the obvious, Northern Ireland is a very distinct part of the UK, and it is not possible to understand Northern Ireland except if you appreciate that the simplistic overlapping of territory, sovereignty, identity simply doesn't work there. You automatically have a conflict, and so therefore we have this necessity to try and think differently about borders and about governance. And in recognising that, we have the Good Friday Agreement, but we also have the Protocol, which is attempting to recognise that distinctiveness of Northern Ireland. The objections to the Protocol, the loudest ones, I should say, and there are difficulties with the Protocol, which I'd be happy to talk about, but the loudest ones, in some ways, sort of reject that distinctiveness of Northern Ireland, particularly this idea that it needs to be treated as if it was any other part of the UK, and I think that's immediately problematic as a premise. And I think a lot of the efforts to try and solve the Protocol are very much about politics and principle rather than the technicalities at the moment. And if actually we wanted to try and address some of the fundamental difficulties with the Protocol, it would be better to recognise and enhance Northern Ireland's distinctiveness, i.e. The UK government itself could bring forward more direct representation from Northern Ireland. Could have done that in the past, must do it now, not just elected representatives, but also officials and stakeholders, so that we could have better understanding at the UKU level of the experience of the Protocol on the ground. Northern Ireland is demonstrating right now the difficulties, and I don't want to say a crisis, but it's a very difficult place for unionism. It's all over the shop in Northern Ireland, and in a very even the news this morning is demonstrating quite how serious the situation is. And I don't think the UK government has necessarily helped unionism in Northern Ireland in any way in its handling of Brexit and the Protocol. You know, almost infamously now, the findings of our poll, the Queen's Lucid Talk poll, on the Protocol show that levels of trust in the UK government is at 4% when it comes to managing Northern Ireland's interest in the Protocol. And
you do wonder where they find that 4%.
Well, I can tell you, it's in very specific quarters of older DUP supporters, and the you know, the approval ratings of Boris Johnson and Brandon Lewis are very, very low. And you can understand why. First and foremost, they came into it downplaying the significance of the Protocol, and now they're emphasising the significance of the Protocol for the Union, right? So where is unionism meant to go with respect to that? And if in case you're not aware, just last week we had a very serious incident in which the UVF, or allegedly the UVF, were involved in hijacking a van and saying there was a bomb in it to threaten the Irish Minister of Foreign Affairs. And the response of the Secretary of State to that was to say, not to say the Minister for Foreign Affairs from the Irish government is welcome in Northern Ireland. This is an important part of the Good Friday Agreement. He was speaking at a cross-community event, etc. But instead he said this shows that there are a small group of people still willing to resort to violence, which sends some, it's ambiguous, worryingly, I think. And then we have Ian Paisley Jr. saying this British government only listens to on-the-street politics. And what's happening on the street today, except people who are canvassing in Shankill Road being told you're not welcome to canvass here, except we're having election posters being burnt, except we're having Doug Beattie, the UUP leaders' constituency office windows broken. So unionism is in a difficult place, and I think the British government really need to think seriously about how it's handling all of this. And just last but not least, that election that we have is going to be a critical juncture. Very significantly, the Northern Ireland Assembly has performed remarkably well just before it broke up. So pieces of legislation that people only dared hope of, and actually quite progressive ones too, with respect to paid leave for victims of domestic violence, for example. Things that really matter. We're coming into a huge crisis, cost of living crisis. Northern Ireland's standard of living is below the rest of the UK, and yet this election could well be dominated by the issues of the protocol. And the formation of an executive afterwards could be held up by issues of the protocol and the UK-EU's agreement or failure to come to an agreement. So the future of the functioning executive and assembly really is tied up with this UK-EU relationship, but most particularly how the UK sees its objectives at the moment with respect to the Union. And last but not least, I would just say, Northern Ireland is distinctive. You can't change that by imagining or wishing that it be different. There may well be a pro-union majority, but there is actually a pro or sympathetic to the protocol majority as well. So the question is, how can the UK government, in conjunction with the EU and in conjunction with the Irish, manage that fact? And that's going to be really tested after this election.
Yes, I think sometimes the protocol is perhaps the sort of Schleswig-Holstein question de nos jours, and that the UK government's attitude to Northern Irish problems perhaps, or the UK government's answer to the Irish question is to ignore the fact that there is a question. And
yes.
Nicola, is that also your view of how this place, Westminster, views Scotland and particular issues that Scotland poses for the United Kingdom?
Yeah, that's a really good question. I don't think it's so much ignoring. We talked for a long time after devolution was introduced that there was a sort of policy of devolve and forget. So devolve powers and then just sort of let Parliament get on with it and then not really do much else. And that's not what we're seeing at the moment. I think the current administration is in some ways contesting devolution. I might come back to that, but also seeing itself as government of the United Kingdom moving into areas of policy that are under the constitutional arrangements devolved, and seeing it having a legitimate role to do so. Now, we can debate whether or not it does. But that's a new approach. It's a departure. On the federal question, if I can go to that one, I think we'll have to make a distinction between federal principles or federal features and federation as a constitutional arrangement. And we do have some federal features in our constitution. Devolution is arguably a federal feature in terms of a willingness to decentralise, a willingness to share power. But we are a very long way from a federation. Federations come in all shapes and sizes, variety of different features, but they have some things in common. They have in common a commitment to balance diversity and unity. Now, we do not have consensus in all parts of the United Kingdom that unity is something to be valued and treasured. And I think I can't imagine a federal solution, if you like, appearing and being accepted until you get to the point at which you test that question of whether or not there is a commitment to unity. In the case of Scotland, that means on the issue of independence. Also, there are issues about questioning unity in Northern Ireland too. Another feature, it means balancing a commitment to political autonomy for constituent units with sharing power, genuinely sharing power. And we are, again, a very long way from that. There has, within devolution, been, as Carwyn talked about, throwing powers at the Celts, but much less interest in thinking about how those powers interact with the things that remain reserved to the UK Parliament. And they cross over a lot, even more so now, because of changes to devolution, because of Brexit in particular, in ways that they didn't in the beginning, and there's been massive challenges in the system of intergovernmental relations that are not just about machinery, they are fundamentally about culture and political culture and the willingness to share power. If you were going to move towards a federal system, you would have to have a constitutional entrenchment of the different powers and authorities of the different units. And that means, again, I'm echoing what Carbon already said, that means that you effectively have to end parliamentary sovereignty. And I see no appetite whatsoever for that to take place. And the interesting thing about federalism or a federal system, which is very different from devolution, is that federalism has to be a whole UK solution. I don't necessarily think it has to be a symmetric solution, but it is something that happens to the UK. Devolution is too easily perceived as something that happened to Scotland, Wales, and Northern Ireland. Federalism is, by definition, a whole UK constitutional reform, and that, of course, raises very big questions for the governance of England. Final point for me for now is, and it's going back to the point about federal spirit. Sometimes I think the question about is federalism the way forward, or various types of questions like that, is that people think, oh my lord, there are stresses in the UK, there are stresses in the Union, of course there are stresses in the Union, and how do we fix it? Okay, what is the solution? And my point would be, there isn't one, because having a plurinational state, having and recognising and valuing the diversity that comes with that, means that whatever the constitutional arrangement, whatever the constitutional settlement, you have to manage those relationships and negotiate those relationships on an ongoing basis. And that's where you see in federal systems a federal spirit, an idea, spirit of valuing, of working cooperatively together, not always agreeing, sometimes fighting, sometimes vehemently disagreeing, but it's part of the system. It's part of a federal system. And we don't, I don't think, have that in the UK at the moment.
Super, thank you, Nicola. It was Pierre Trudeau, wasn't it, who said of Canada and the United States that Canada's difficulty was that it was sort of in bed with an elephant, which is perhaps somewhat akin to the way Scotland, Wales and Northern Ireland sometimes view their relationship with the UK and England within that. So, Tony, can you give us the view from the elephant's perspective, if you like? Devolution, obviously, there is devolution within England, but it too is uneven and asymmetrical. If people are talking about revamped constitutional arrangements for the UK as a whole, that obviously has certain implications for the English question. But can the English be made to be interested in the English question?
A very good question. I mean, it is interesting that here we are yet again considering indirectly the need for a written constitution. I know that comes next in the programme, and it is begged by this panel as well, as has already been stated. I mean, it is curious that England, which is 55/66 in population terms of the United Kingdom, is simultaneously overpowered and underpowered. At some level, it's got all those MPs. If they wished to assert themselves, which I don't think they could as England, they could. On the other hand, inevitably there's a degree of underpowered because devolution doesn't really function in England in anything like the same way it does in Scotland, Wales and Northern Ireland. And of course, the one effort to create, as the Blair government imagined, a regional government in England, which was a pretty underpowered version of the thing, in 2004 with the referendum in the North East, went down with all hands. Because, quite understandably, people in the North East didn't see what was being offered there as anything like what had been offered in Wales and Scotland. So then we're left with England, with centuries of centralisation, one of the most centralised, largest democracies in the world. There was a brief period in the 19th century when there was, wasn't devolution, but cities, when British government was more interested in the rest of the world, the empire and all of that. There was a degree of power in big cities throughout the United Kingdom, actually, long before devolution. But since 1945, we've seen, certainly in England, the endless extension of what you might call Greater Whitehall. So what's interesting to me from an English perspective is that what happened in Scotland and Wales in particular proves that you can devolve a substantial amount of power, and indeed fiscal power, within the United Kingdom without the sky falling in. Scotland and Wales remain, you know, let's just make it neutral, it's as well run as England, let's put it that way, as the former First Minister sitting alongside me, but let's just assume it's as well, or not noticeably differently better or worse than the UK Parliament in England. But there is this challenge that to get towards the symmetry that Carmen was referring to, in a sense, we all know you couldn't really have an English Parliament and First Minister, could you? Because it would be so big that the First Minister and the Finance Minister of England would have a bigger budget than the UK federal government would. So then you're pushed back down to regions. Well, that's ruled out because of not only what happened in the North East in 2004, but actually subsequently combined authorities have come along based on city regions, and then sort of groups of counties in sort of county city regional things, combined authorities. So we've ended up with it, as ever in the United Kingdom, but this time in England, with a patchwork. You've got London's got one arrangement, Greater Manchester and the West Midlands, Birmingham area have another arrangement, and so on across the country. Many parts of England don't have devolution in this form, in the English form even. So the question is really how one might move England forward to have something which could be seen as a form of devolution, which would allow a read across and a degree of equality with Scotland and Wales and Northern Ireland. I think that's the question here. So what might it be? Well, I think you could move to a consistent version of combined authorities, either in cities or in more rural areas. They wouldn't, I think some of them would have mayors, some of them might have governors or some other word as their political leader. You could imagine doing that right across England, giving them greater powers, giving them some fiscal autonomy, and by the way, congratulations to Wales and Scotland for managing to get some fiscal autonomy, because the Treasury do not like this idea when it comes to handing their tax control to anybody other than themselves. So that was a remarkable element of what has happened in Wales and Scotland. So I think it would be possible to come up with an English solution, but it's not going to be regions, it's not going to be anything like Wales and Scotland or Northern Ireland. It will be something in England that can be described as devolution, but it won't be the same. I think that's the nearest we can hope for, given the powers that are fighting against it. And finally, what are the obstacles to this? Well, the first is that unlike devolution to Edinburgh or Cardiff or indeed Belfast, there were already civil servants and a political system there. You'd have to break up Whitehall. And that's very difficult for the civil servants and ministers who operate there to countenance. They've spent all this time getting to the top of these huge departments, and lo and behold, we're now going to break them up and give all their powers to people in cities and towns and counties out there. So that's difficult. I think you have to add to the fact that if you don't have a big break, as occurred in Scotland and Wales, you end up with the problem that in Whitehall, deep down, they don't trust subnational government. They just don't think it's up to it, that only the Rolls-Royce minds in Whitehall really know how to make these excellent decisions about procurement, all the wonderful things that the NAO reports on. And so that somehow you couldn't let all these people out there make these decisions which are going to be so much better made in this particular postcode. Nicola referred to this. I just say, even within England, there's some pulling back from devolution to London. There's definitely a sense that London government is too powerful, and separately, levelling up has empowered the UK government to start spending money in Scotland and Wales and Northern Ireland directly, and that's not a mistake. That's a reassertion of the unitary state, as we saw with the Brexit negotiations, of a kind that I think has profound implications for the Union, but as yet is much under discussed, although I'm sure UK and Changing Europe will be doing it soon. So last but not least, and this point I know is going to come up, there would have to be a different constitutional settlement to allow a federal version of the United Kingdom. Given the evolutionary tangle and change that's led to where we are, it looks to me far more likely that England, along with Scotland and Wales and Northern Ireland, will continue to evolve down a devolutionary path, but it will remain, to use a technical term, a mess. Thank you.
Yes, I mean, I think from all of that, you know, one gets a reiteration, if you like, of the fact that the United Kingdom is a deeply weird country. You know, really quite genuinely quite unlike almost anywhere else. And so it has to make it up as it goes along, in the grand old British tradition of muddle. Carmen, I was wondering, we have a Minister for the Union, who's also the Prime Minister, who is on record as saying he considers devolution to be a disaster. How do you square being Prime Minister of a devolved United Kingdom with that view, and to what extent is the current Prime Minister an impediment to the better functioning of the Union? I don't imagine you have any views on this whatsoever.
I think the ultimate lesson for anybody is to think before they open their mouth. Because that's not what Boris Johnson did, I think, on that occasion. As you can see, his views are very strongly supported by the people of Scotland, who very much support devolution. I think it's just Victorian. I think it's just out of date. If you look at, let me take Wales as an example. In 1979, the people of Wales rejected devolution 4-1. One of the reasons for that was many people worked for the British state, quite frankly. They worked for the NCB, they worked for the British Steel Corporation. They had a stake in the UK state that disappeared over the next 20 years, you know, with privatisation and with the rundown of so many industries. People in the 70s would have said, well, what is the point of having a devolved government? Won't that jeopardise our jobs in the big nationalist industries? And that actually, the privatisation undermined the case against devolution in that way. In 97, we had a referendum where it was very close, a majority of 6,721. You can see it's engraved in my head somewhere, in favour of devolution. And yet, in 2011, we had a referendum on primary powers, which basically, it was a 2-paragraph long question, which was distilled down to, do you believe that all the laws that only affect Wales should be made in Wales? We had an easy 2-1 majority. Easy. All the opinion polls show that devolution is very strongly supported by people in Wales. There was an abolish party that stood in the election last year. It got 4% of the vote, which gives you an idea of the strength of the desire to abolish devolution in Wales. We've seen opposition to devolution drop over the past 25 years. If you consider that nearly half the population were against devolution in 97, that has dropped to about 20 now, and it's mainly the older population. If you look at those in favour of independence, that's about 1/3 of the electorate, which doesn't sound much, but it's historically very high, and it's certainly increased a lot over the past 2 years. Yeah, let's not over-exaggerate here. If there was a referendum on independence in Wales tomorrow, it would fall. However, amongst younger people, there's a much more even split, 50-50 actually. And there are a lot of people out there who are interested, who are not against the idea of independence in principle, they just don't see it working practically. So that debate is still ongoing in Wales, and that's what makes it different in terms of Wales and Scotland, less so Northern Ireland for the reasons why Katie's outlined. Wales and Scotland see themselves as nations and want to be nations within the UK. It's very different to the dynamic that drives devolution in London or drives potential devolution elsewhere in the UK. And that it's not simply a question then of saying, well, let's just have federalism across the UK, because Wales and Scotland just wouldn't accept being the equal of the northwest of England. When I sat in government in Wales, our equal was England. It was much bigger, but that was it. Our equals were ministers in Whitehall and not anybody else. And that, you know, once you've developed that thinking, you can't easily get away from that. And that, again, is an obstacle to what we would regard as formal federalism.
I mean, Nicola, it's a question of status, as Carwyn says there, but also of from a devolved administration's point of view, and the sort of mentality of voters in Scotland, Wales, Northern Ireland as well, isn't it? Of trust at an intergovernmental level and so on, but more particularly, more importantly perhaps, of a sense of esteem and respect. To what extent has that been challenged, if you like, in the post-Brexit era, and is there a way in which these things can be improved or fixed, or is a sort of culture of mutual suspicion our guaranteed and permanent future?
I mean, it's In terms of relationships between the Scottish Government, I think I would add the Welsh Government into this too, and their combined relationship with the UK Government is really poor. There is very little trust as far as I can see. There has been a recent change in the machinery that might help that, but I think it will involve, I suppose, building in some elements of that sort of idea. There's a phrase that you hear ministers, certainly in Scotland, talk about a lot in terms of parity of esteem. And what they are referring to there is where they are responsible for agriculture, let's say, or education, or public health, as we saw it there in the context of COVID. These are areas that are devolved and it's their responsibility. And when they are engaging with the UK Government on these issues, the UK Government is acting for England alone, and in those areas, they ought to have parity of esteem. So it's partly about status and recognition, but I think it's more than that. I think it's about voice, influence, power, co-decision making, and that is really difficult in the context of a United Kingdom where one territory is so overwhelmingly large. Can you imagine the scenario where you build in to decision-making forums co-decision as equals in the context of intergovernmental relations? Well, there are some difficult democratic issues that emerge from that. If you're looking at a nation of 5.5 million, a nation of less than that, I've forgotten the population of Wales, carbon, and a significantly larger nation of England on the same footing. I mean, there are some difficult democratic issues emerge there if you are to build in more co-decision and common decision-making. We don't really have that. Sometimes there's a call for it, but we don't really have it, and maybe there are some advantages to enhancing the devolved authority over areas for which they have responsibility. When it comes to the shared powered aspects of any federal system, then that becomes a rather more problematic. But on the other hand, if you look at some of the features that are often talked about, it appears in Labour manifestos, it appears in Lib Dem manifestos at every election, about a chamber of the nations and regions. Get rid of the House of Lords, replace it with a chamber of nations and regions. That will do nothing to go to the points where I was talking about a voice and recognition of nationhood. Because I do think that recognising the plurinational character of the United Kingdom is, from a Scottish and Welsh perspective, extremely important.
Yeah, I mean, one of the things obviously we've seen in the COVID era in particular, and I'd ask you all perhaps for your thoughts on this and so on, is a demonstration of Westminster's limited authority on lots of matters. The fact that Boris Johnson is simultaneously Prime Minister of the United Kingdom, but also on lots of matters only Prime Minister of England. And it's not always clear that he knows which hat he's wearing at any given point, perhaps. But to what extent has some of the things that have become apparent, you know, with public health and other matters and so on, changed people's understanding of the United Kingdom and how it actually exists in the last couple of years? Or has that happened at all? And if it has, what implications might stem from that?
Well, I mean, the sort of slightly odd competitive public health policies that were pursued during the pandemic, intriguingly, probably haven't led the four nations of the UK to a particularly different place at the end of it than if they'd had a single policy. I mean, I'm not a public health expert, but it kind of looks at, and this is true not only of the UK, but other countries in Europe, that they've adopted slightly different policies from time to time and place to place. But in the end, the impact is not as dissimilar as perhaps it felt at the time. That was personal observation, hard to prove that. What I would say is that the slightly pushing against your question, Alex, is that the massive firepower of the UK Treasury, I think, was important during the pandemic, and I'm not sure that that would have been as easy for smaller nations, he said, at a risk of being controversial. I think that the capacity of the UK as a financial institution to act is still very significant. So that's pushing slightly against your question, I think, to be controversial for a second.
Katie, what's your view?
Well, just to pick up on Tony's point there, I mean, certainly unionists would emphasise the importance of the funding from the UK in response to COVID, and the COVID challenge ultimately showed, I'm sorry to repeat a point, the distinctiveness of Northern Ireland in having to be cognizant of what was happening in Britain, the rest parts of Britain, and also was very directly affected by the policies as they were moving in the south as well, in the Republic of Ireland. And in some cases that was managed by the executive fairly well when there was better communication between the British and the Irish. Where there was divergence, then it became more politically as well as practically difficult for the executive. I write on this with Darren Litter actually in the report, to do a plug for our report, and it's, I think it is significant that COVID was a topic that we all had to cover in that constitutional report chapter.
I've got a question here, if I can find it, from Joseph Edgerton's on saying that I'll again throw this out to all of you, about that says the 2024 general election is, as he puts it, unlikely to produce a strong Conservative majority. And then he asks, can the Union survive a hung parliament? To which I would add, can the Union survive another Conservative majority, given where the last 10 years has taken us? What's your views on this?
Well, you can see some very interesting scenarios, can't you, coming out? I mean, if it were not, let's say it was not, if the Conservatives were seen to have lost the election, but Labour didn't quite win it, then you're in one easy step into a Labour plus SNP, Liberal Democrat, others applied perhaps, a confidence and supply government. Now, the conditions for that would, of course, be very interesting to see how they panned out, wouldn't they? So I think it depends on what the configuration would be of the hung parliament if it occurred.
Nicola?
Yeah.
But there's your crystal ball here.
Yeah, I have a fundamental dislike of crystal balls, but I mean, one of the things that I always find really interesting and fascinating, and it's a reflection of the majoritarian political culture in Westminster, is how disastrous from a governing point of view a hung parliament is seen to be, whereas minority government or coalition government is the norm in the devolved legislatures, but it seems to be devastating and ungovernable in the context of Westminster, which has always struck me as a little bit odd. Of course, what would happen at that point, could the Union survive another Conservative majority government? Yes, I think it can. From a Scottish point of view, it would be problematic because I cannot imagine that majority Conservative government securing much support within Scotland. It doesn't have to secure a whole lot of support for it to make it, because the SNP is so dominant, as we saw in the 2017 general election, where the SNP was still really dominant, but because they lost a big chunk of seats, it was seen as a failure. So they don't have to gain too much ground from the SNP for it to be seen as a bit of a success and for it to dent constitutional aspirations. But leaving that aside, my sense of the UK government's strategy towards Scotland, and in particular towards the independence issue, is to wait it out. Because constitutionally, all the authority probably lies with the UK Parliament. I say probably because it's a little bit ambiguous as to whether or not there could be a referendum on independence, and I have no doubt that that will end up in the Supreme Court. But even if the Supreme Court was to judge in favour of Scottish Parliament legislation, however it was phrased, it is within the gift of the UK Parliament to alter the devolution settlement, to make it reserved if they want to. My sense is that the Conservative government wants to wait this out and hope that people get fed up of the Constitution. And a lot of people are quite fed up of the Constitution, but it is still the dominant issue and it polarises all political debate within Scotland, as you will know, Alex.
And of course, in an Irish context, we've only been talking about the Constitution for, 140 years or something. So that perhaps shows the way forward for Scotland. Carwyn, Labour Party's position, we have the Conservative Party is formally, obviously, the Conservative and Unionist Party. But there is a sense or a case can be made, can't there, that actually the most important Unionist party in the United Kingdom, or at least in Scotland, Wales and England, is the Labour Party. Because only it can, if you like, form a government that is everybody's second choice, a government that they can live with, even if they don't much care for it, whereas the Conservative Party is in a different situation in parts of the UK.
Yeah, I think you're right. It's one of the dangers, I think, is that unionism starts to become a particular type of unionism starts to be associated with the Conservative Party. So, for example, increasingly in Wales, if a Union Jack is flying, people assume it must be the British Legion or it's a Conservative order. It's not seen as a flag that necessarily is seen as representative of all the population. I think that's something that's happened in the past 20 or 30 years. And that's something which is why it would be a grave mistake for the Conservative Party to try to rebuild a kind of Victorian unionism based around a flag, quite frankly. And I'm sitting next to Katie, who lives in a place where people are obsessed with flags. But that's not the way to do it. And to try to go backwards, to re-centralise, the UK will not survive that. It just won't survive. People will. There are people who at the moment would not be in favour of independence, would say, well, sod it, frankly, if that's the way they're going to behave, then we may as well be independent. I think that's hugely dangerous. And I think you're right. There is a responsibility on the Labour Party to be the party of progression when it comes to the union, in terms of taking a fresh approach to devolution and the Constitution. I think that's something that we as a party can and are getting to grips with. I think the most, in relation to the question you asked, what happens if there's a Conservative government, for example, or there's a hung parliament, I think the most dangerous scenario is a Conservative government that's elected without any seats in Wales or Scotland, because they could lose all their seats in Wales and Scotland and still have a majority. And I think that's unlikely, very unlikely, but it's a highly dangerous scenario because it makes it very easy to portray a Conservative government in those circumstances as the English government. And I think that's hugely problematic. As I say, I think it's an unlikely scenario. And I'll tell you a story about the obsession with flags. There is a UK government office in Cardiff. It's basically the HMRC, but they don't call it that. And they put in an application for planning permission to put an 8-storey high Union Jack on the side of the building. This created a certain amount of controversy, not least the fact that the building was on a direct route between the Central Railway Station and the Principality Stadium. So people in their thousands would pass it when they were at their most Welsh in identity. It didn't go ahead. I mean, if someone had said to me, we're going to put an 8-storey high Red Dragon in the building, I'd say that's just, that's crazy. We're not going to do that. I think I'm with Tony finally on the numbers. It depends what the numbers look like and who is able to form a government with a majority. If the SNP hold the balance of power, I've no doubt that the SNP will push for another referendum. And probably look for things on top of that, such as UK government neutrality in that referendum. But much of it depends on what the numbers actually look like. If the Labour Party say short of a few seats, then there are options to do deals with other parties. But if the SNP are in the driving seat, then we look then at the situation in the 19th century with Ireland, with Parnell's party in Ireland and what was done then.
Well, that's something to look forward to, isn't it, Katie?
Yes. No, just to say on the general election point, I mean, the general election that would probably be of most significance to the UK Union could potentially be the Irish general election. Given how well Sinn Féin are doing, how close they came to getting a majority last time, and how likely it is that they may well form the next Irish government at around the same time. And so that would very much change the dynamics, not just within Sinn Féin, within nationalism on the island of Ireland, given that we could well potentially have a Sinn Féin First Minister, but also what it would mean for British-Irish relations. If things are difficult at the moment, which they are in British-Irish relations, how much more difficult could they potentially be?
So the lesson is that things can always get worse.
Well, absolutely. We're talking about Northern Ireland.
I mean, is the growth of the Alliance Party, is another question we have here, is the growth of the Alliance Party, does that point to some means by which, if you like, the sort of British-Irish nationalist, unionist, binary sense of identity can at least be, you know, some sort of middle ground can be carved out of that, with perhaps replaced by a more distinct Northern Irish identity, albeit that's within both the United Kingdom and the island of Ireland?
So the important thing is not to conflate like alliance with a Northern Irish identity. So Alliance Party voters come from all backgrounds, those who say they're neither unionist nor nationalist, those who say they're unionist, and indeed those who say they're nationalist. And they did particularly well in 2019, I think partly because they were coming on the back of a sort of a pro-Remain, pro-second referendum sentiment. So this election will be really critical for them. They're doing well in the polls. They're now there in the polling as third party. And they're hoping to take a good number of seats. But this is why it's, in some ways, it's a real test for the Good Friday Agreement, sort of this next generation now, because, as I mentioned, that sort of new legislation that we saw coming forward, even whilst the executive hasn't been functioning since the end of February, does show the potential there. And in some ways, people could look to that and say, well, this could work, devolution could work, and actually give us stuff most people, judging by the polls, most people care about. And yet there is also the potential, you know, when we're seeing now already at this early stage of the election campaign, the polarisation and the very negative discourses and aggressive discourses, etc. You could just see people being turned off voting altogether. So it's a real challenge, I think, for the Alliance Party now to give people confidence that you know, to come out and vote in the first instance, and devolution is worth working for. But as I say, the risk is it would have a low voter turnout, and then the hard lines kind of continue to be very dominant.
There's an excellent question here, which I'm not actually going to ask you to answer, but it just amuses me. It says, could a federal UK include Southern Ireland? Which I suppose is a thing that to every new problem, there's a very old answer. But you know, to what extent, one of the problems it seems to be for the UK and so on is and Carmen touched on this earlier, Northern Ireland has its particular issues with this, so does Scotland, so does England, perhaps increasingly. And so, you know, what is the British nation now? It obviously exists alongside and sometimes on top of Englishness, Scottishness, Welshness, Irishness. But, you know, if one was to go in search of the British nation, where would one find it?
Well, in a number of institutions, I suspect, some of which, you know, have been outside earlier on, and the NHS, and which exists in different forms in 4 parts of the United Kingdom. It is still called, I think, the NHS everywhere, and that's a very powerful identity. So I think in institutions and in, you know, we all know from the polling that people in, certainly Great Britain, so carefully, generally have very similar attitudes to, you know, social issues, business, you name it. They're very similar attitudes to a whole range of things. So I think there's a great deal of, I mean, people in these islands generally have very, very similar views on many issues, certainly in England, Wales and Scotland, a bit different in Northern Ireland. So, you know, I think in a sense there is the long common history, which is, you know, it is what it is, and it undoubtedly is a real thing. And then in the armed forces, of course, you know, currently yet again on display. So, I mean, I think it's like everything else to do with the British Constitution, a bit random, but there we are. You know, that's why we're here at this event, in part.
And I think what it means to be British looks very different depending on where you stand and where on these islands you stand. And that's always been the case. I think it's more the case now. There was some really interesting research done by colleagues in Edinburgh and Cardiff on Brexit preferences. And in England, those who define themselves as British looked more like those in Scotland and Wales who define themselves as Scottish and Welsh in relation to Brexit issues. I think the problem comes when you feel the need to try to define it, to try to put a flag on it, and that's when nations tend to feel most threatened, is when they feel the need to say who we are, and inevitably you then exclude people who don't feel that. The UK, historically, has been comparatively unusual in being perfectly comfortable with being a union of distinctive nations. You often hear this phrase, the four nations, which to me mean England, Scotland, Wales and Britain. Nationhood in Northern Ireland is rather more complex. That's not what's referred to by the four nations, but there has been a British nation that people are comfortable with alongside being part of a Scottish nation, a Welsh nation and so on. But they are fewer in number now than, say, 50 years ago.
So the mention of the NHS is really interesting because I think, so we see from the Northern Ireland Life and Times survey that the health service is the one thing that that many nationalists think they would be loath to lose. Also we see the provision of the health service as being the primary concern of people across the board up to DUP and Traditional Unionist Voice at the moment. So including Sinn Féin voters, it's health service that matters and the functioning of that. It is at the moment the NHS, which is very telling. For the DUP and TUV, it's the protocol, together with the union. So that's this is a bigger question around how that about public-private. I mean, what do we like about the NHS? You know, is it just the fact that it's free, or is it something else, something collectively that stands for something? And perhaps we saw a little bit of that during COVID, but that's something that would be worth keeping an eye on, and particularly it'll be interesting after this next Assembly election if we see the inability of the executive to be formed and the ministers who would continue on in shadow not being able to properly make decisions, if that would have then an effect on provision of health, provision, etc. We really do have a challenge for the question of what, what it is to be part of a functioning democracy or not. Yeah.
I mean, Carmen, I wanted to come back to something you said earlier and so on when you were talking about the rise, at least as a theoretical or notional matter, of people being open to at least the idea of independence for Wales. To what extent is that being pulled by the experience of devolution, which demands, in a certain sense, difference to justify it? And to what extent is it perhaps also being pushed by a sense of England asserting itself, particularly with regard to Brexit and other matters, and by a fresh awareness, if you like, of the asymmetrical nature and reality of the current constitutional arrangement?
I don't think it is driven by constitutional arrangements. I think it's certainly in the past 20 years, it's just been a trend that I think would have happened in any event. And I don't think it's a question of, well, devolution has led to difference. The difference is already there. It's just that the difference wasn't able to be expressed in a way that perhaps was the case in the past. I mean, I didn't speak English at home. None of my family spoke English. My family were from a village where everybody spoke Welsh. And so there was that level of difference anyway. You know, I always felt for a long time that the Britishness of the 1970s had no place for people who didn't speak English as a first language, that somehow we weren't allowed in. And that was because if you look at the old style Britishness, it was very English speaking, inevitably, because it is the majority language by far. Whenever English football teams played, they waved the Union Jack. There was a synonymity between England and Britain. And people constantly use the two words to mean the same thing. That has changed. And I think one of the major questions is not, what is the British nation? I don't think we need to go looking for something that is there. And I think, Nicholas is absolutely right. People wear identities likely. They have different identities. Most people in Wales would probably say, if you ask them, what's your nationality, they'd say Welsh. If you ask them if they were also British, most of them would say, yes, we are. We don't have to make that choice. Why should we? The only part of the UK where that doesn't happen is Northern Ireland, where what does your passport say? Is it an Irish passport or is it a British passport? And that determines your identity in Northern Ireland. Not always, but quite often. And I think it's a mistake to think that somehow we can go back to those days when the identities of Wales and Scotland could be ignored and subsumed into a sort of English/British identity that was seen as one and the same thing. That certainly caused resentment. And a lot of people now who grew up at that time, they will tell you, well, God Save the Queen is the English anthem. They play it at for English football and rugby teams. That's it. It's not particularly British because it's also the English anthem. And the big challenge in some ways is to be able to separate out British identity from English identity in that sense, so that all identities, including my own, which is a non-English speaking identity largely, can feel part of the UK.
I mean, that's, as you say, the UK has actually been a multicultural and indeed multinational entity for much longer than many people perhaps in England. Well, the original Britons, of course. But we see that in England now as well. The difference between English identity and British identity, and England being, when we talk of multicultural Britain, and so we really mean multicultural England, does that open a sort of path to a more relaxed kind of future for the Union, in which you can dip in and out of different identities? In one sense, the UK Union is a genuinely liberal place in as much as it has an awful lot of time and space for people who wish to see it destroyed. And that makes it relatively unusual if you compare, the UK with Spain's attitude to nationalist movements and so on. Is there a way within that of finding a way forward that recognises both institutionally the requirements of the devolved nations and satisfies English aspirations as well? Or is that all just sort of airy-fairy nonsense?
Well, if we knew what English aspirations were, if I just part that part of the excellent question. I mean, I think Corwin's right. The soft identities, you can indeed call yourself Scottish or Welsh or British or English or any mixture of these, and you can actually have several. Actually, you can be Welsh and English and British if you want to be, and nobody really minds. I think that's quite helpful. What I would say that is going on, which is a bit of a curiosity, which I hadn't really thought about to articulate till now today, is that, interesting, the levelling up agenda, which I referred to, which is in addition to reaching into Scotland and Wales and Northern Ireland from Whitehall, has sort of triggered within England a slightly sort of degree of competition between the southeast and the north. And it was always there, but there are some funding streams now which are only available for places outside London. Think about that. So there are, even within England, there is sort of there's a slight sort of challenge created by levelling up, which pits bits of England against each other. And that, of course, is because it's so centralised. All funding for things like combined authorities and mayors, and all levelling up funding is bidding for grants against other places, which is itself inherently terribly destructive. So I think that the broader issue of how England, it continues, and just on the question of the flags, I mean, since devolution, there's no question. You do see more St. George's flags, English flags, than you used to before. No question about that. And that sort of overlap between Union flag, Union Jack, and Englishness, I think, is a bit more detached than it was before 1999.
Yep. Nicola and Katie?
Yeah, I mean, on the identity issue, one of the big challenges I see is that outside of Northern Ireland, there is no place in GB to give institutional expression to those who feel European. And I'm not pretending for a minute that there was a strong, deeply felt sense of European identity in Scotland. I think it was there. The bigger issue around Brexit was the fact that this was a decision that was taken despite the fact that the clear majority preference within Scotland was for that not to be the case. So the Brexit issue is not so much the European identity aspect, it's the not being able to allow the expression of Scotland's voice as a nation in terms of its national preference. And that, yes, we're talking about 2016, but that is important, I think, to everything that has happened since then. It's important to that idea of Scotland as a nation that aspires to make choices, whatever they might be, within the United Kingdom. And I think Brexit and the EU dimension is one of the major challenges in finding ways within the United Kingdom that will generate consensus in the way that this state is governed. And I think unless you have a softening of the relationship between the UK and the European Union that can allow those sorts of institutional ties, perhaps in different ways in different parts of the United Kingdom, then I think I see it as really difficult to identify a kind of consensus arrangement in the near future, anyway.
No, just on the question of passports, I mean, one impact of Brexit, of course, has been to draw forth all these people with Irish roots in Great Britain and, of course, in Northern Ireland as well. And there was the famous tweet by Ian Paisley Jr. holding his Irish passport on his way off to Washington for St. Patrick's Day celebrations. But yet we have a situation in which Doug Beattie, as the leader of the Ulster Unionist Party, gets enormous stick simply for saying that he is Irish as well as British. So it's sort of this...
Whereas everybody here would consider him Irish immediately,
well,
whether he wants to be or not.
Yeah, that's a good point, actually. Yeah, which sort of explains quite a lot of where unionists are coming from in their sense of needing to defend the union, not just from Irish nationalists, but from certain attitudes in Great Britain.
Well, there are lots of Scottish Tories and unionists and so on who would have a lot of sympathy with that view as well, I think. Yeah. I mean, we're coming towards the end of our time, and I know we've sort of ranged quite a long way away from the question of a federal UK in terms of its sort of constitutional architecture. But I think that's partly because I think you all think that it would be, in some ways, quite a desirable thing, but that none of you actually see a way in which it can be delivered. Is that a fair summary? And can it be, and suddenly then it also then requires, I think you've all said, a written constitution, which is obviously the subject for the next panel and is a whole different kettle of worms. So to bring us back to the sort of starting points on, does the UK require fundamental reform to, not just in terms of being governed better, but for it to actually continue to exist in, say, 20 years' time? And to what extent, if at all, is that reform possible or likely? And what sort of shape would it take? So, a couple of minutes from each of you on that, perhaps, and that'll wrap us up nicely. Tony, you...
Well, I mean, given we've ended up here, I'm absolutely sure that even without a written constitution, we could get a long way towards a much more federal version of the United Kingdom, because everything is so flexible and malleable. I do think it would create a big role for a Supreme Court, or a sort of UK constitutional court. But given that we know that we can endlessly move the UK constitutional arrangements around in various ways, I absolutely accept a written constitution would be terribly difficult to achieve and would take a very long time to do it. So if we can't do that, could we get a quasi or nearly federal version of the United Kingdom? And I think the answer is yes. I think we could. And we could certainly do it better than we've done it so far.
So that's quite optimistic. Nicola?
So I find it difficult. I don't see it as my place to advocate for any particular constitutional arrangement over another one. We surprisingly perhaps haven't said anything about independence, perhaps because ultimately, if you're saying the UK may not survive, one of its biggest challenges in relation to the prospect of independence for Scotland. And that's not a neat solution either, because although it's clearly a live issue, the independence movement has clearly been re-energised by Brexit, and for all of the reasons that we talked about, it's really complicated now, much more so than it was the last time that decision was taken. So there is no guarantee that even if you get to the point of having a referendum that it succeeds. And there's all sorts of reasons to think that would be practically very difficult and politically very difficult to do. But it doesn't go back to the point I made at the very beginning. In a sense, whether it's devolution as we have it now or slightly tweaked, or whether it's something that looks a bit like federalism, or even whether it's independence, there has to be a continuing relationships and some sort of institutional expression for that, because none of these constitutional arrangements change geography. Imagine COVID happened in the context of Scottish independence. Of course they would continue to talk and agree some things together, probably. In some ways independence would demand more coordination between the administrations than is the case just now, as Katie and I looked at this in relation to the border issue in the context of independence. So my general point, I suppose, would be that constitutions, however you configure them, are not going to be a magic solution, a magic bullet, a magic wand to fix the problems that are inherent in the way that people work together, the way that they engage with each other.
So there's, first assume a unicorn, and then everything can be fixed. Katie?
I agree with everything that Nicola just said. I mean, just to clarify a point I made at the very beginning, so according to the Good Friday Belfast Agreement, that a border poll question would be either Northern Ireland join United Ireland or remain in the UK. There isn't a kind of, would you like Devo Max kind of thing. There's nothing like that, which means ultimately we're always going to be trying to, whether it's the context of within the UK or the context of United Ireland, having to manage the existence of Britishness and the existence of Irishness, of unionism and nationalism, whatever forms they take in these two scenarios. So we're going to continue to need that flexibility, as Nicola was saying, and good ways of working together, not just within the UK, but also Britain and Ireland. And at the moment, to slightly contradict Tony, just to add some interest at the very end, I don't see us going in I see us going in the opposite direction at the moment towards anything about federalism. I think things are regressing in some ways as a much more simplistic understanding of the union and what it takes to keep it together. I think all the comments have sort of shown just quite how futile that is longer term if you want to preserve the union.
Is that the problem, Carwyn, that just, that the fundamental problem is that the people running the United Kingdom don't actually understand the United Kingdom?
Yes.
Well,
and I'll explain why. I think what we have at the moment is workable for decades, frankly, but you do need a UK government that is both sympathetic and understanding. I spent 18 years in government. I sat down with a number of Secretary of States for Northern Ireland from 2010 onwards, after the election in 2010, and was constantly surprised about how little they understood of Northern Ireland. It was astonishing. And this permeated the Brexit debate. I kept on saying to people, if the UK leaves the EU, we will have a land border with the EU. And it just blanked when you told them that. Or said, well, of course, Ireland will leave at the same time as the UK, because Ireland's well known for following the UK's lead in that respect. I think there's a total lack of understanding of Northern Ireland, but not just Northern Ireland, but of devolution and what it means within the current UK government. There's even less sympathy. The intergovernmental machinery that we have could work very effectively, but it doesn't. We have the Joint Ministerial Council, which meets quarterly. We have one plenary. In the old days, when I was on it, we had one plenary every year. Basically, everyone went there to shout and Whitehall ministers. That's all it was at the end of the day. And I'll tell you a story, just to illustrate this point. A finance quad, where the finance ministers from all the UK governments used to meet quite regularly. Inevitably, a UK minister would turn up and it would be a different minister from the previous meeting. So all these different people would turn up not knowing what had happened in previous meetings, and the whole thing would fall apart. And my successor, Mark Drakeford, told me the story when he was finance minister that he went to Whitehall to be faced with a UK minister chairing the meeting who had no idea what had gone on in the previous meeting. This sparked a lively debate. Mark was very strong in saying how unacceptable this was. Mike Russell, who was then the SNP's finance minister, was even stronger, saying that this all amounted to disrespect and a lack of credibility on the part of the UK government. Martina Muller, who was then the finance minister in Northern Ireland, went even further. He described it as a betrayal and started thumping the table. And this was all under item 1 on the agenda. Welcome. And it could be so much better. It could be a forum where people can agree. And I'll give you an example of this can work. David Liddington and I, post-Brexit, agreed that powers would come back to the devolved institutions where they would have done that naturally. But there were some powers that needed a UK-wide agreement. Agricultural subsidies, the operation of the internal single market of the UK, the way fisheries operate in the UK. And we agreed they would sit in a cupboard, they'd stay as they are, and sit in a cupboard, and we would take them out at such time as we were confident there would be agreement across the UK as to how they would operate. Everybody had a stake in how that would operate. It's been ditched completely. The UK government has just taken it over. So the Subsidy Control Bill, for example, means that, let's start with the Internal Market Act. That's the rules that govern the internal market of the UK decided entirely in Whitehall. And this avoids the problem, or doesn't recognise the problem, of the UK government being the English government at the same time. The Subsidy Control Bill is worse, because that gives, for the first time ever, Whitehall ministers the ability to direct ministers in devolved governments. That's never happened before, but it's there, Clause 55 of the Subsidy Control Bill. That's the road to perdition. There is, however, a better path. It was still there, frankly, until Boris Johnson became Prime Minister. It was, I worked with Theresa May's government. We got agreements. The entire system rests on there being a UK government that understands and is sympathetic and treats with respect the devolved administrations. We don't have that at the moment. If that continues, long term, the union will be in trouble. However, if the government changes, I'd be more optimistic. But then I'm not perhaps the most objective observer.
Thank you very much. I just thank Tony, Nicola, Katie and Carwyn for that. I think this is a subject to which people may return in the future, possibly for several years to come, whether there's a new referendum in Scotland or developments on the island of Ireland or not. The United Kingdom will remain a messy, unusual and disputed entity, which should at least keep us all in work for quite some time to come. Thank you all very much.
Welcome back, everyone. I've been roped in to chair this panel because Jill Rutter is at home with COVID, so we wish her very well. She can't join, I'm sure she's joining us online. So welcome to this final sort of cross-person panel before we go into our keynote, where we are talking about the Constitution and the issue of whether or not it should be codified and what that means in practice anyway. We've been talking all day about some of the constitutional issues, some of the concerns that some have about executive overreach, some of the issues around the composite nature of the UK and how that is reflected in our constitutional arrangements. And perhaps the process of codification of the Constitution might help to address some of those issues, or not, and to think about some of these issues, reflect on some of these issues. I'm joined by an excellent panel. To my left, Kate O'Regan, who is the inaugural director of the Bonavero, that's wrong, isn't it? Okay, you're doing well. Bonavero Institute of Human Rights in the Faculty of Law at Oxford University, and a former judge of the South African Constitutional Court. Jeff King, Professor of Law at UCL since 2016, also a visiting professor at the Faculty of Law in Oxford as well. Nick Barber, a Professor of Constitutional Law and Theory at the Faculty of Law in the University of Oxford. Oxford, very well represented here today, as is Edinburgh University. And finally, to my colleague, Stephen Tierney, who's Professor of Constitutional Theory in the Law School at the University of Edinburgh and was the founding director of the Edinburgh Centre for Constitutional Law. So, I think we will start with Jeff. And to codify or not to codify, is that the question?
Thank you very much, Nicola. I think it is one of the questions, and the answer is that it would make sense to codify the UK Constitution. At the moment, there are a number of what we could call major construction sites of a constitutional nature in the Constitution. The view that convention or political usage has settled the principles that govern these areas is not tenable. These are not minor areas. The parliamentary sovereignty itself is being questioned in the courts, guarantees of the rule of law, the future of the union, the process of constitutional change, the role of the upper house in the legislative process, as well as in scrutinizing government. These are all areas where there are fundamental elements of uncertainty. So I start with the first of three reasons in favor of a written constitution, and I think it is to provide clarity on some of the principles that govern or should govern these areas. Now, some say it's nonsense that a written constitution would do that, but I'm happy to demonstrate with examples because we're lucky in having an actual draft written constitution having been put before a parliamentary select committee, and we could look at what that constitution would have prescribed before the Brexit process happened. And you'll see that some of the great issues that were debated would have been resolved quite quickly under that constitution. The second argument in favor of a written constitution is we would have, finally, a formal process of constitutional change. At the moment, constitutional change happens like any other legislative change, if that. English votes for English laws came and went without any legislative intervention. I think that's mad, mostly for democratic reasons. Constitutions are fundamental, and they should be given that status and treated that way at a political level. We should be aiming for cross-party agreement on constitutional matters, because the primordial function of a constitution is to secure cross-community agreement on fair process for political decision-making. Lastly, I think formalizing the Constitution, engaging in the exercise, can give greater protection to some constitutional fundamentals. Most constitutions in Europe, we should recognize, can actually be amended with something as simple as an act of the legislature or an election or a referendum or some combination of the above. So I'm not talking about deep entrenchment. I'm against deep entrenchment for the UK constitutional order. But I think that the way in which the devolution arrangements, the principles were casually put aside for the UK Internal Market Act, would not happen if a constitutional amendment were required to put that bill through. And I think more currently that the process of reforming the Bill of Rights, the Human Rights Act, could not happen under a written constitution, even if the amending formula was a simple majority, because you'd have to trigger a constitutional amendment process. And I think the case for rearranging the Human Rights Act would become, its weakness would lead to the death of that kind of casual reform of constitutional fundamentals. Those are just, that's my opening view on 3 reasons: clarity, a process for constitutional change, and giving greater protection to some fundamentals without going all the way to a super amendment procedure for a supermajority procedure for amendment.
Nick, I'm going to come to you in just a minute, but just for clarification,
Yeah.
What would codifying the Constitution mean for the doctrine of parliamentary sovereignty? Would it codify it, or would it do away with it?
In my view, it would, in my proposal, which I've written in an article, parliamentary sovereignty would remain, except that a law would be only insofar as Parliament would be able to amend the Constitution through a simple majority procedure. But it would be a constitutional bill process. In other words, there would be nothing supermajoritarian. But a law that is inconsistent with the Constitution could be struck down for that reason. It's just that it could be passed again through a simple majority procedure.
Okay. Do you agree?
With Jeff?
Yes, with the broader question of codifying the Constitution.
I think Jeff and I are at two points at extreme ends of a spectrum. So Jeff thinks that codifying the United Kingdom Constitution would be a great idea. And Jeff is the author of an excellent article in Current Legal Problems, which I recommend to you all, where he provides us with a structure whereby a written constitution could be produced, and also provides us with a strong argument as to why we would want to produce a written constitution. And I disagree with both of Jeff's claims. So this question, should the United Kingdom have a written constitution? It sounds like an exam question, doesn't it? It often is an exam question. I've set it as an exam question. And like all good exam questions, you should start by challenging the question. The question itself needs to be challenged. Why are you asking this? What sort of answer are you hoping to get? Because I think often when people argue for a written constitution or the codification of the constitution, they aren't really interested in the question of a written constitution at all. What they're interested in is constitutional reform. So this is a proxy question for questions like, should we reform the House of Lords? Should we have a new voting system? Should the Human Rights Act be made, should be strong form judicial review be attached to the Human Rights Act? Should we become a federal state? All of these are good and important questions of constitutional reform. But you should ask yourselves, do they necessarily require the creation of a written constitution? Sometimes I think the answer is no. We can reform the House of Lords. We should reform the House of Lords without introducing a written constitution. We can reform the voting system. We probably should reform the voting system without a written constitution. Do we need a new Bill of Rights? Maybe yes, maybe no, but you don't need a written constitution to implement it. So all of these are interesting and important questions. They don't necessitate a written constitution. And the hazard of putting them into that bundle of a written constitution is that it's bundling. You bundle together all of these different issues of constitutional reform into a single document, and then you put it to the people in a referendum and they have to take it or leave it. Whereas in fact, each of those issues should be treated separately, each treated on its own merits. Now, the great strength of Jeff's proposal is Jeff does provide a distinct argument for a written constitution. And Jeff's argument is grounded in democracy. Jeff says the important decisions in the state should be taken by the people. The laws should be produced by the people. And the Constitution, for Jeff, is the most important set of decisions and laws in the state. And Jeff argues that every 20 years we should have a constitutional convention to author a new written constitution because of the value of democracy. This is a good argument for a written constitution in the sense that it's coherent. It explains why you need that specific instrument, a written constitution. But I think it only identifies one of the tasks that constitutions can perform, articulating popular beliefs. It fails to recognise that constitutions also provide stability, that enables effective government, and also provides, they play an integrative function. They allow different people with different views and different ideas about the state to see their state reflected in the constitution. So I'm against a written constitution for the United Kingdom, firstly, because it would introduce instability into our system. We would have a period of debate and uncertainty about the constitution. We would have winners, we would have losers in the system. But secondly, and I think even more importantly, because it forces us to reach conclusions about issues we don't necessarily have to decide at the moment. Should we be a monarchy or a republic? Should we be a federation or a unitary state? Are rights more important than democracy, or is democracy more important than rights? All of those different ways of conceptualising the United Kingdom Constitution can be seen in its current structures, because those structures are broad, are vague, and are susceptible to different interpretations. If you produce a written constitution, you risk pinning that down. You risk creating winners and losers. You risk people failing now to identify with the United Kingdom as a state because their vision of the state isn't one of the ones that the Convention has adopted. And you might think, well, Nick, we're not all that worried about that. Those are issues we can address. But just think about the costs involved in this process. The devolution settlement would have to be completely reopened. We would have to start afresh if we had a constitutional convention to reauthor the constitution. Now, I don't know if anybody here is from Northern Ireland or studies Northern Ireland, but I understand it was quite tricky to work out a constitutional structure for Northern Ireland in the first place. Imagine if the consociational structure underpinning Northern Ireland's legislature was thrown open and questioned, and was still perhaps was re-evaluated from the United Kingdom, the English perspective. Well, I've got lots more to say, but I will stop there.
On your last point, I'll move over to Stephen now. Would you have to reopen the devolution arrangements, or would you be giving them sort of greater constitutional standing, I suppose, than just a simple law of Parliament?
It seems to me, Nicola, that the issue of codification really does bring up the territorial nature of the Constitution, and that the uncodified Constitution has served the territorial nature of the Constitution in a particular way, and that the process of codification could stretch it to breaking point. It seems to me a Constitution performs two functions, a legal function and a popular function. So as a legal order, clearly it transforms political power into lawful authority. So it's a form of alchemy. It's alchemy insofar as it takes political power and gives it the legitimacy of legal authority. But that's a heavy task, and it requires broad shoulders. It requires a lot of legitimacy it gives legitimacy to a political system, but it also requires that the Constitution itself derives a lot of legitimacy. It seems to me further that constitutions, because they are essentially functional, derive that legitimacy from the particular people whom they serve. And it really depends upon them reflecting the will and the identity of the people whose lives they order. It also follows from that the process of transforming a political system through a constitution and through constitutional change must also take place in a vernacular way to reflect the nature of the society in which that constitution is being born or through which it's being changed. So constitutional change is actually a massive issue. To take an example, from Canada in 1982. In 1982, Canada repatriated the Constitution back from the United Kingdom. This in itself, and Jeff knows much more about this than I do, but the substance of it was not actually controversial. The substance of what was going to be in the post-1982 Constitution was not controversial. What was really controversial was the amending formula. What was going to be in the Constitution in terms of how it would change into the future, because how it would change into the future called into question the we of who would be involved in that process of change. And I think this is the crucial thing about a constitution and a process of constitutional change. It's not just about creating a new legal order. It's a declaratory moment. It's a declaratory moment when that moment of legitimacy comes to the fore, where you don't just get a new set of rules. You have authors of those rules saying we are a collective we who author this new system. Now, in the United Kingdom, we've left constitutional change to the Crown and Parliament and Convention. Partly that's happenstance, as a consequence of no revolution for 300 years. But I think it's also a recognition of our particular societal pluralism. It seems to me that there is this ongoing reflexivity in our constitutional system that has left the we question to one side. It has largely avoided the declaratory moment. If you look at Northern Ireland in 1998, when the Belfast Agreement went to a referendum, again, it largely parked the identity issue of Britishness and Irishness. I argued in an article that the people who voted in the 1998 referendum in Northern Ireland did so as a public rather than as a people. They agreed to come together for that precise moment to agree on a peace deal. They left thicker, bigger questions of identity and national identity to the side. So when I say that the uncodified constitution has served us well, this is not an appeal to nostalgia, to non-rational arguments for a Burkean perfectionism. Far less is that a claim to the genius of British constitution making, that constitutions are for less civilised people who need them, we don't. Quite the opposite. It's precisely because of the messy and complex societal particularity of the United Kingdom that we've not confronted this grand constitutional moment. So the British Constitution is unarticulated, contested, and constantly changing. But I think that reflects the fact that our sense of self, or of selves, are also those things. So it seems to me that an uncodified constitution facilitates the very fact that the pluralism, that the identity you would need to, the common agreement on an identity you would need to form a written constitution is simply not there. And to try and search for it, we could push the whole system to breaking point.
But, Stephen, is the logical conclusion of what you're saying there that perhaps even with hindsight we may well have pushed the thing to breaking point by going beyond what you're suggesting there and leaving it to the Crown and Parliament, but increasingly big constitutional changes are preceded by a popular vote. So we have seen increased use of referenda and all the complexities that entails when you have the plurality within the country. So are you suggesting there that we shouldn't have put the issue of Brexit to the people, but left it to Parliament?
That's a very good question, Nicola. I think referendums are problematic from that perspective, because a referendum presupposes the pre-declaration of the we who are voting. So you can do that without bringing up the thick question, as Northern Ireland did in 1998. But when it came to the Brexit referendum, and that's why there were statements, for example, by Nicola Sturgeon, that a referendum in these situations should have been a pluralistic exercise. And it's interesting that in federal systems that have referendums, certainly in Australia, a referendum does require a double majority. Not simply a national majority, but a majority of the states. So yeah, a referendum within that system is intensely difficult.
Kate, it's not just the amending formula, the way you change a constitution that brings in the issue of the people, but actually the making of the constitution too. And you have some salutary insights, I think, from the experience in Southern Africa to share.
Yes, thanks, Nicola. And so speaking as an outsider and somebody who watched a codified constitution being made firstly in South Africa over a sort of 6-year period, it was a long, slow, complex political process. I can say that both the making of a constitution and a codified constitution can be extraordinarily salutary in very difficult circumstances. A lot of what Jeff says about identifying constitutional fundamentals, finding ways to go forward as a polity, have been the South African experience. You could say that at times it frays at the edges, but I think all democratic environments are contested environments. That's the project of democracies, is to take our contestation and make it public and engage with it in public spheres. So the fact that there's contestation in South Africa doesn't bother me that much, because I think that's part of what having built a democracy is about. So in the South African experience, I think codification has been very, very positive. But I think what's important to realize there is the very specific circumstances that led to codification in 1990. South Africa was effectively in a state of civil war. There was an oligarchical, racist apartheid government in power. And when they decided that they were going to enter into negotiations with the liberation movements, there was a strong realization that what we had as a constitutional system was going to have to be really rethought. And I think for both sides, it was a case of saying, we cannot continue as we are. We have to change. We are being compelled into this process. And being compelled that way into the process, willingly, I think, on both sides, led to what was, in fact, a very robust constitutional debate and has produced, I think, a pretty robust constitutional framework. The question is whether, in the absence of such crisis and kind of deep disruption in a society, one can have the same positive process. And that, at the end of the day, is not a legal question, it's a political question. In some senses, I tend to agree with Stephen that what one does need to realize is that it is a disruptive process. The South African constitutional making process broke down quite dramatically several times along the way, and it looked as if we might well return to the state of effective civil war and impasse that we had been in 1990. But each time, fortunately, the leaders got back together again and restarted the process. Those disruptions in the process, however, should make one realize that these conversations are very deep-seated and are inevitably somewhat disruptive. If, however, you can build the political will across a polity, and that would be both the constituent parts of the United Kingdom, but also across the array of political debate, then it could indeed be a constructive process. It seems to me to be that's a question for the UK to answer. If one doesn't have that, and there have been other constitutional codification processes in Southern Africa in the last 20 years, where there hasn't been that sense that there's been a coming together, a joint political will, as it were, to build a new constitutional framework, then they are not as successful. So that happened in Zambia, that's happened to some extent in Zimbabwe. Pretty good constitutional texts, but without the sort of unified sense of this is the document about which we are all going to work to build our constitutional framework. In the absence of that shared political will is a real threat, I think, to a process of codification.
Thank you. Jeff, I'm going to come back to you because you've been invoked in the others' contributions, and I'm sure you would like a right to respond. But we're also getting lots of questions in through Slido, so just a reminder to everybody, you can use the Slido thing. I can't tell you how to do it, I'm sure you know by now, to pose your questions, and I will try and bring in as many of those as I can. The most popular one of which, though, is without public appetite and demand for a written constitution, the political parties are very unlikely to commit to delivering one. Why should the public care?
Well, they should care whether the fundamental laws of the country they live in can be changed at the whim of a political party that has just over 30% of the popular vote behind it. If that's not the case, then I don't think that person's citizenship duties are being exercised properly. They might take the view reasonably that it would be a disaster for the kinds of reasons that Nick and Stephen have pointed out. But I think to say there's no appetite, who cares? To ignore the fundamental question of principle and of practice. I mean, let's not pretend that everything is okay in these areas. As I said, there are many construction sites for the Constitution right now. The system of public law was nearly reformed. The process of the Bill of Rights was nearly reformed. House of Lords reform was shelved. We had a very chaotic process of Brexit that would have been less so in a different polity. And the case for nationalism in Scotland has been fortified through this procedure. And we seem to be, meandering towards the breakup of the Union.
But isn't that a case for electoral reform?
So I'm glad you raised that, because Nick said, why not just do this piecemeal? And I do address this in my article. The fundamental problem with piecemeal reform in this constitutional system that we have is that you need to get one of the two parties, and probably both, to agree to reforming something that gives them tons of power. And they're not going to do that. Nick said, why don't we just change the voting system? Well, the Liberal Democrats tried to get a referendum on proportional representation, and they couldn't get it. So they got a referendum on the alternative vote instead. Fixed-term Parliaments Act was grudgingly accepted by the Conservative Party, which decided to get rid of it shortly after another term in office. The House of Lords Reform Bill in 2012 was killed off through a backbench revolt in the Conservative Party. So, and why do these things happen? Because why would, in a system in which two parties share in virtual absolute power, political power, why would they want to change something? You need a system that gives the choice of how the structure is organized, that takes that veto trump card out of the hands of both of the major political parties.
suppose one could argue that Liberal Democrats might have driven a harder bargain in coalition negotiations, but we'll leave that one for now. Well, question from Professor Bogdanor, who is pointing out that of other democracies without constitutions, the population of New Zealand is half that of Greater London, and Israel is developing one. What makes the UK so unique?
Well, this is a very interesting argument from Professor Bogdanor. It's the argument that says that everybody else has done something, so we should do it too. And I think one of the worries about that argument is that it isn't actually the case that everybody else has done it. So if you look around the world, it's true that there are only 3 countries that lack a written constitution, the United Kingdom, Israel and New Zealand. But lots of the countries that have a written constitution with the capital C may as well not bother with it. If you go and have a look at the constitution of North Korea, a constitution with the capital C, it is a marvellous work of fiction. If you read that constitution, you would think the North Korean people were the luckiest people in the world because their constitution is so liberal and full of rights and democracy. In fact, of course, the North Korean constitution is just a sham. It's just something that's put there to fool the gullible who might come across it on the internet. So it isn't the case that most countries in the world, or all the countries in the world apart from those 3, have a written constitution that is effective. It's the case that they have a document that has got the capital C at the top of it and a set of rules underneath it. Every constitution with a small c, that is the assemblage of rules that animate the state, every country has one of those. And the gap between the written constitution with the capital C and a constitution with a small c can in itself be problematic. Maybe North Korea would be better off if it didn't have a constitution with a capital C, because at least people could actually see the rules that govern the state. Now, I also wanted to respond, if I may, to that question that was put to Jeff about people not being all that interested in a written constitution. And I think the people are right. I side with the people on this one. People don't care about the lack of a written constitution because they realise that there are bigger and more important problems facing the state. If you think about the challenges facing the United Kingdom at the moment, the question of whether or not we should have a written constitution is right the way down the list. And I'm going to say something now that's really controversial, so I want you all to brace yourselves. The United Kingdom constitution is a terrific success. It's really successful. It's worked incredibly well. Now, I suspect all of you in this room, because you're interested in constitutional reform, I can see you all leaping up and storming the stage. But reflect. Think to yourself, what other constitutions are better and more successful than the United Kingdom's? I'm not saying the United Kingdom's constitution is perfect, but I am saying that if you lined up every constitution that's ever been in the history of mankind, the United Kingdom constitution, in terms of producing stable, effective, decent, democratic government that tolerates and respects people's rights, comes very high indeed on that list. So I think people aren't worried about the written constitution because, in contrast to Kate's example drawn from South Africa, there is no pressing need for us to adopt it, and the constitution we already have is successful. And of course, people's lack of interest in a written constitution would carry over to the process of producing that constitution if they were forced, compelled into one of Jeff's conventions to author that constitutional document. Perhaps a large percentage of people in that convention wouldn't want to be there, wouldn't be interested in the outcome of the convention. And what consequence would that then have for the product of that process? So we should trust the people that they're right about this issue. We should be cautious about forcing them to address questions they don't want to address, and perhaps we should turn our attention to areas of the United Kingdom Constitution that do desperately need reform, like the House of Lords, or like the federal question that Stephen is raising, which we should be focusing perhaps more tightly on than this broad question of a written constitution.
Okay. Stephen?
Yeah. To me, it's not so much, the codification versus non-codification issue, but how well the Constitution works. So, quite often you'll go abroad and people will say, what do you do? And it's, well, I'm a constitutional lawyer. And they say, what, from the UK? What do you do all day? You don't have a constitution. And then we say, well, we just haven't written it down. And they say, well, is it all in songs and stories? Or, and you know, the point is that the Constitution is essentially functional. And the issue really is our Constitution performing the task of constraining political power the way it ought to? And Jeff and I serve together as legal advisors to the Constitution Committee, and we agree on many of the functional flaws of the Constitution. We maybe come to solutions in a different way, but what I really like about the way Jeff presents his argument is that it's very nuanced, and it's very much shaped around the system we have, rather than some ideal system invented on a blank sheet of paper. So I think there are a lot of flaws that we do identify. For example, the exercise of prerogative powers. And we've seen fundamental issues arise in the nature of not simply the the prorogation issue, but dissolution through the Fixed Term Parliaments Act, but also huge issues now in terms of how executive powers have been marshalled in favour of the government. Now, we've heard panels earlier about this in terms of Brexit and COVID possibly being outlier situations. And maybe they are, we just can't tell yet. We can't tell if things will settle down, but we've seen massive increase in Henry VIII powers, in a lack of pre-legislative scrutiny, in the extensive use of draft affirmative procedure in bills, last-minute amendments coming forward, fast-tracking now for major bills rather than minor bills, the lack of sunset clauses in relation to the powers that are included, the use of guidance instead of delegated powers, which has no parliamentary scrutiny. And my suggestion is that a lot of these can be resolved by some of the things we heard in the previous panel about better parliamentary procedures, and in particular in the House of Commons not leaving constitutional scrutiny to the House of Lords. The fact that so many, as we heard, so many amendments come forward at report stage in the Lords, in a House that is often doesn't feel itself legitimate to deal with issues. So when it came to English votes for English laws, the House of Lords felt itself largely unable to speak. So I think a strong Constitution Committee within the Commons, not just simply PAC Act, but one that scrutinises bills properly from a constitutional perspective, something similar to the Secondary Legislation Committee. So so my point is that I agree largely with Jeff's diagnosis about a lot of the problems. We would come to different solutions, but I think the common ground is considerable in our diagnosis.
I know that you wanted to come back, Jeff.
Well, I wanted to just address something Nick had said, but also make a comment on the devolution question, because that came up earlier, and it's really the most difficult issue and the biggest challenge for anyone who, as I do, wants to advocate a written constitution. On the question of whether the people care about having a written constitution, there's polling on this question. And the answer is yes, they do. A majority, at least in the various polls I've seen, said they would like to have a written constitution. As Philip Norton has pointed out, that doesn't mean they agree on how to go about getting it. So it's not like that fact eliminates most of the hard questions that were being discussed. But people, there's a strong vote in favor of this, or a strong appetite for it. The Constituent Assembly, the Constitutional Convention that I proposed, and this is not far off other proposals, would be partly elected. Party members would stand in a closed list PR system, so they would have to be put up by their parties effectively to participate in it. And there would be a process of sortition for the direct appointment of citizens, basically. It's like jury duty. You don't have to do it. There will be large queues of people that would be very happy to write the Constitution for the country. I don't think finding willing participants in the exercise will be difficult. Getting the parties on side to do it in the first place is another story. If that can't be done, the whole thing folds. But I think if one party were minded to do it, they could hold a referendum on the question, and that would generate a strong force that a party opposed to the process would have to reckon with. Now, as for the devolved arrangements, I suspect, and I really defer to Stephen. Nick's written a wonderful book as well, talking about the territorial constitution of the UK as part of the constitution of the UK in a very deep way. I suspect politically, the way this would play out, even in the Constituent Assembly that I've just indicated, is that the default process going in would have to be that either we would freeze the current arrangements and give them constitutional status, as Nicola was asking about, or to ratchet up the guarantees that are offered to the devolved authorities. I think we should dispense with the Sewell Convention and replace it with a strict allocation of competence that can be adjusted through amendment. Now, I don't just think that that is an ideal scenario. I think there are many complexities I haven't mentioned. I think this is exactly what would happen, and why do I say that? Any party that would seek to diminish the powers of the devolved assemblies, parliaments, or governments would be creating a political time bomb for the entire process of adopting a written constitution. And in the assembly that I'm talking about, which is 2/3 party members, the political sophistication of the membership is such that they will know that. And why would they participate in an exercise that has a poison pill right in it? So I think people would know that you can't adopt a position that will destroy the whole project, and they would reason in light of that. Now, you might say that's an article of faith, but I think it's political judgment that makes me think that that would be the case. It would be a time bomb to diminish the powers of the devolved legislatures. And there's a lot in principle and constitutional theory that would support actually making it stronger than it currently is.
I'm going to come back to the devolution question in a moment, but Kate, what would your suggestion be in terms of bringing the people into the process of constitution making? We had a question here that was in response to something that you were saying earlier, Nick, which was saying, isn't Professor Barber's assertion that we don't need a written constitution because it would require the resolution of difficult problems rather the point? And is the process of constitution making, particularly if you open it out, a way of resolving difficult issues? Is that the experience of Southern Africa?
Well, I think it can be. The thing is that it's not a dead cert. So that if you got to the sense where people thought this does matter, there are issues here we need to do, and I think it's right to look, for example, at the devolved powers as one of the key issues, but also the question of the relationship between the executive and parliament is another one, and that's not peculiar to the UK. That's a problem that's occurring in a range of democracies around the world. If people began to realize that that was an issue that people needed to talk about and think about, a well-managed process, much the way in which Jeff has outlined it, but I think also with a guarantee that there will be proper consultation across the society in quite deep ways, could be a very constructive process in building a common sense of what it means to be the United Kingdom and how power is exercised within it. That, of course, does require real open-minded and fair commitment to the project. But if that were to happen, I think it can be so. If one looks again at the South African process, there were thousands and thousands of processes of consultation. And it meant actually that lots of ordinary people became involved in understanding, how the system worked, which certainly for the first generation post-constitution making was extremely healthy. People had really engaged with the project. But it does need a serious driving force to get there, and a commitment not to let centrifugality take over. We've got to make this work. There's got to be an important frame of mind.
Stephen, I'm going to come back to you here, partly to respond to Jeff's observations and suggestions around the devolution issue, but also, clearly issues like the Sewell Convention are being challenged within the current context. Jess Sargent from the Institute for Government is asking whether there are ways other than the process of codifying the Constitution, which might raise other issues in the process. Are there other ways to address those sorts of challenges to devolution and to perhaps make it clearer and give more protection to devolution?
It is a difficult one, and things haven't been great. We saw that. We heard Carwyn Jones talk about the Internal Market Bill. Another thing we're noticing coming through in bills, and to my mind it's happening too often to be an accident, is that the government is providing for delegated powers to be used in devolved areas. Of course, secondary legislation doesn't fall subject to the Sewell Convention. So is that a way of circumventing the Sewell Convention? It is at least by accident. One hopes it's not by design. But if it is simply by accident, that's not great either. The problem with codifying a strict demarcation of powers, I think, well, there's several problems. One is it would be very asymmetrical across the 3 different settlements. It would also, in effect, give a veto power for those areas that are clearly devolved competence in the areas where the UK currently wants to legislate. And Nicola, in the earlier session, raised the point that you would then be subjecting a very, very big part of the country to effective ransom by small parts of the country. You might want that, but it's an issue. So it seems to me that the Sewell Convention is there to manage the fact that our system is very asymmetrical, both societally and in terms of powers, and that it takes account of the fact that with a very big country with only 3 small areas devolved, there are times when the UK just has to do stuff. But it should try and do stuff whenever it can with consent. I think the EU withdrawal bill was actually a pretty good example of that. When Clause 11 was initially published, which was basically everything goes back to London till we've got time to sort things out. And by that point, everything in the withdrawal bill was all about retained EU law and the complexity of dealing with... Devolution was completely sidelined. Wales and Scotland erupted in anger, reasonably, and Clause 11 was completely rewritten so that most of the powers actually went to the devolved regions with, as Carwyn Jones was saying, some things left in the cupboard to sort out later. He didn't like how those things in the cupboard were later dealt with. But it seemed to me that that approach was a much more consensual, constructive approach, and that is the way in which our political constitution can function properly according to principles of respect and so on. So I think there are ways forward within the current system. I think the House of Lords Constitution Committee recent report, which uses terms respect and dignity in terms of the way the union ought to function, are there. It requires political will. But frankly, no constitution works without political will. And I don't think codification would do the trick if the political will isn't there.
But surely you need some sort of process, because it seems to me quite a long way from the EU Withdrawal Act process. We've had a whole series of things now where it's become quite easy, it seems, to set aside the Sewell Convention.
The difficulty with the Sewell Convention is that it's a one-sided agreement in a sense, because the Sewell Convention says the UK normally won't legislate without consent. That doesn't take into account that consent can be unreasonably withheld. And if we were to codify the Sewell Convention, it would be codified presumably as a much stronger reciprocal agreement, whereby consent would... So on the EU withdrawal bill, Wales consented, Scotland didn't. I'm not saying who was being reasonable there and who was unreasonable. People have different views on these matters. But if we are talking about trying to codify what is a very delicate relationship in terms of political views, what we would end up with is perhaps the Canadian model of Section 91 and Section 92, where you try and list everything. What that leads to are 2 legal questions. So your courts are suddenly going to be clogged with, does a devolution issue even arise? If so, what is it? And then where does competence fall? So we would have to be prepared to completely transform our, in my view, effectively federal arrangement into one which is very heavily juridified. I think Jeff's aware that that could happen. He builds in protections, I guess, and he'll talk about them. But I think that could be a consequence. That's not something I would be in favour of.
Let me come back to on that, because we have a question also from John Newham about perhaps one of the consequences of having a codified constitution being empowerment of the judiciary, and how do we overcome that? I think from what you were saying about simple majorities in Parliament still operating would help to address that, although I dare say it would raise some other issues too.
Yes, I just wanted to say I tended, certainly when we worked together on the committee, I always followed Stephen on any question related to devolution, not out of deference, but out of pure respect. So I take very seriously all of those points, Stephen. The only one I would question is whether having a strict allocation of competences would lead to the courts being clogged with cases. When I did my law degree in Canada, we were looking at cases on those questions from 80 years previous. So they settled. I also think that the courts don't have much of an appetite for that kind of litigation here. It could have arisen under the devolution statutes, and it really hasn't. But on the other points, I see the case that you've made. And this segues nicely into the question that you'd received about juridification of the Constitution. So I think that whether or not a Constitution leads to juridification has most to do with the approach the courts take to what kinds of questions they want to be adjudicating. There are many countries that have written constitutions where the courts are more deferential on political questions than they are in the United Kingdom currently. So all of the Scandinavian countries, the Netherlands, it's an open question about the Supreme Court of Ireland. I don't know if it could be described that way, but so a written constitution doesn't necessarily lead to juridification, and as we've seen under the devolution statutes, it hasn't led to the juridification of devolution, the law that applies in that context yet. I think it's likely that a Bill of Rights would be enforced just as it currently is under the Human Rights Act, although with a British Bill of Rights, it's possible the courts would be more timid than they currently are because they don't get nudged along by the European Court of Human Rights on a regular basis. It's a complex question about the relationship between a national Bill of Rights and the European Convention. In most countries in the system, the question never arises because the national bills of rights tend to be stronger rather than weaker. But that would be a question to be resolved. Ultimately, if people are not happy with the decision of a court, then a bill can be brought forward and passed by a majority on my proposal to change that law and to move it back. So prisoner voting might be an example. And given the nature of rights litigation and the, let's face it, unpopular position of many of the claimants that take these cases, getting a bill like that through the Parliament is not politically impossible. It's changing the Constitution or making something apply notwithstanding the Constitution is a big step. So there is a disincentive for it. But if we get the kind of case law you're getting in the United States, I have very little doubt that the UK Parliament would just reverse a court decision like that if it happened.
I have a question that's just open to any of you. It's the most popular question so far. Paul Evans is asking, is there a middle way? A corpus of statutes recognised as basic law and requiring strengthened parliamentary or extra-parliamentary procedures to amend? That seems to me very much a question for a distinguished group of lawyers present.
Nick.
Stephen? Oh, Nick?
I mean, my view is that, you know, there's not a hard line between a codified and an uncodified constitution. And we saw that in the constitutional statutes doctrine and things that emerge. The influence of the European Communities Act over 45 years in terms of constraining what Parliament could do. You know, the Fixed Term Parliaments Act, which began to introduce the possibility of supermajority, at least not in the lawmaking sense, but at least in a parliamentary procedural sense. The Northern Ireland Act, Section 1, which binds the executive to hold a referendum under certain conditions. The European Union Act of 2011, which sought to bind, you know, and we've seen it, and it hasn't even played out yet in terms of what the new trade agreement with the EU, when translated into domestic law, seeks to, ironically, bind not just the government, but possibly Parliament in terms of its future scope for action. So it does seem to me that we are moved towards a slowly more crystallised approach to a distinction between ordinary and constitutional norms. We may have sleptwalked into it, or whatever the word is, but it seems to me that it is more a process of accretion, and we are moving in that direction. So I don't necessarily see it as a category distinction.
Nick?
Oh, it's a very good question, and I agree with what Stephen was saying. I might even go further and say we probably already have reached that stage of having a special set of statutes that's more difficult than ordinary statutes to amend. The idea of constitutional statutes is now an established feature of the law, and the doctrine of implied repeal, it seems, doesn't operate against constitutional statutes in the way that it operates against ordinary statutes. So it's a little bit harder for Parliament to alter a constitutional statute like the Scotland Act than it is for Parliament to alter an ordinary statute. We might even very hesitantly, peering into the future, polishing up our crystal ball, you could see that area of law strengthening. If Boris Johnson tomorrow decided he wanted to repeal the Scotland Act without a referendum, without the agreement of the Scottish Parliament, I think it would be at least worth a go to take a case to the Supreme Court to argue the United Kingdom Parliament can't, even by express repeal, remove the Scotland Act without either the agreement of the Scottish Parliament or a referendum of the Scottish people. There are threads in recent case or in recent jurisprudence that you could draw on to manufacture an argument. You could say the Scotland Act is a special statute. You could say that repealing it was to undermine the democratic fabric of the United Kingdom. You could point to some Supreme Court cases where the judges have suggested that they might be willing to exercise review over Parliament statutes where they unsettle democratic structures. You could point to Jackson, you could point to AXA. So I wouldn't want to stake my house on the Supreme Court striking down an Act of Parliament that repealed the Scotland Act, but equally I'd be certainly willing to give it a run in the Supreme Court, and it might work.
Interesting experiment that would be, but as a humble political scientist, I wouldn't recommend it. Kate?
Yes, I mean, I think it's a very interesting question. I think one of the things is we shouldn't draw this very hard line between codification and non-codification. I mean, really what's been happening in the United Kingdom, it seems to me, over the last 30 years, there's a whole series of processes of constitutional amendment, some of which are in statute or legislation, some of which are in convention, some of which are enormously creative and imaginative. Take, for example, Section 4 of the Human Rights Act. This was a really, I think, smart way of addressing the parliamentary sovereignty versus entrenching human rights, which, despite the often kind of dissatisfaction with it, does seem to have worked extremely well, and Parliament has found it successful. So I think that what we should realise is that this drafting is a very ingenious and creative exercise, and I have little doubt that there will be ways to address, to build to continue this process, as it were, of constitutional development, which may move more close to a written constitution, maybe without the detailed process that Jeff is talking about, but in response to the changing character of this polity over time. So I think there's a lot of ingenuity that could be exercised here to produce something which feels more like a constitution, but which is very much rooted in British parliamentary practice, British constitutional experience, and successful.
And British pragmatism and muddling through.
Yes, that too.
I'm a little bit skeptical of... it is true that the line between the codified constitution and the uncodified norms at the core of the UK constitution, it shouldn't be overdone. In reality, the importance of a codified constitution is the status that it has amongst elected politicians and institutions. The fact that, nevertheless, I'm skeptical that we should not see any difference, or we should de-emphasize the very important difference that codification would make. So the idea that we would be able conceivably to take a case to the Supreme Court to challenge the repeal of the Scotland Act as somehow unconstitutional, next to the alternative of it being in a constitution and there being no question of anything like that being remotely possible, gives an illustration of the very real differences between the two. Same thing with the Human Rights Act. I've said this a number of times, but you can't just disapply the Human Rights Act if it is written into your constitution like a Bill of Rights. When the Internal Market Bill was going through Parliament, there was a proposal made at a very, very late stage of the process to disapply the application of Section 6 of the Human Rights Act, which means that the proposal was that delegated legislation adopted under that act relating to the Northern Ireland Protocol could be subject to a declaration of incompatibility but not struck down. Now that is a fundamental constitutional change, okay? And this was introduced at the report stage, very late at night. They were planning to effectively amend and disapply the Bill of Rights at that stage. Now, I think that shows just how easily the existing norms can be displaced certainly in a crisis, but sometimes even in business as usual. Retrospective legislation is another area that when we were working on the committee, it happens all the time. And it's done casually, it's not even mentioned in the explanatory notes. And when you raise it as an issue, the response of the government is, well, it makes sense, doesn't it? And that's about how deep the issue runs. So I think that there is a difference, that codifying gives a status to these norms that makes it harder to put them aside, even if they can ultimately be put aside through a majoritarian process.
We have a question here and an observation, really, that we've been talking about the Constitution all day, and nobody has really talked about the monarchy in that. And the question is, does that suggest that the monarchy is irrelevant to governance and the Constitution of the United Kingdom? And if I can extend that out a bit, at the point at which there is a transition to a new head of state, which will happen, is that potentially a trigger for some of these wider constitutional issues, or do you see it separate, Nick?
Thank you. I mean, I'm always amazed by the fact that we don't talk about the monarchy in United Kingdom constitutional scholarship. Well, we do, but we start to talk about it in extreme detail and complexity. And very rarely is the question, should we continue to have a monarchy raised in constitutional discussion? And it is a question that ought to be raised and ought to be discussed. Monarchy is really interesting. So at the start of this discussion, we were talking about the way in which you can have different stories inside a constitution and the way that can be a strength. And one of the great strengths of the United Kingdom Constitution is, I think, that, as Bagehot pointed out, it manages to be a republic and a monarchy simultaneously. So if you're a Republican, you focus on the creation of citizenship. We've all been designated as citizens. You focus on the Equalities Act. You focus on the House of Commons. You focus on elections and votes. If you're a monarchist, on the other hand, you focus on the Queen and the Crown and Buckingham Palace and all that sort of thing. This is a really good example, I think, of accommodation within a constitution as a way of avoiding constitutional disagreement. You have these two stories running alongside each other. But make no mistake, these are two profoundly conflicting stories. So the idea of the republic idea of citizenship is the idea that everybody in the state is equal. And it's grounded in a notion of the essential moral equality of people. The idea of monarchy, on the other hand, is grounded in the idea that one person is special, and special by virtue of birth. And I think the only way in which monarchy can make any sense is if we've got a religious idea in the background that God has picked somebody out. So I think we ought to be addressing monarchy. We ought to be thinking about the tensions it has with citizenship, but perhaps we should be a little slow to rush to become a republic, because monarchy provides a story of the United Kingdom Constitution that is attractive to many people and leads them to identify with the Constitution, maybe for bad reasons. And that's a terrific asset, because it persuades people to accept the decisions of our constitutional structures because they see it as part of a monarchical structure.
Yes, I agree with Nick that it's a very important topic for constitutional lawyers to talk about. And I also think, as he has illustrated, that it just shows the complexity of trying to codify the Constitution in a way that would not be divisive, because you could see that this could create an enormously divided society between the people who say we are first and foremost citizens of a republic and others who'd say otherwise. That said, however, it is surprising how many written constitutions accommodate precisely that sort of ambiguity within them. It doesn't mean that simply because you're writing down a constitution that you will actually eliminate all forms of ambiguity. And I'll just give an example. In the South African Constitution, we accommodate the system of traditional leadership. That is, traditional African customary forms of leadership is recognized in the Constitution. This is a constitution which says its founding value is democracy, and there is that exact ambiguity there within the Constitution. And that is worked out in a whole range of ways, both within parts of our society where traditional leaders have authority, within courts, and within Parliament, where Parliament seeks to legislate to regulate traditional leaders. So I don't think we should think simply because there is contradiction and conflict that automatically means you can't have a written constitution, but obviously it would have to be dealt with in a delicate manner, recognizing that here you are dealing with something over which there is disagreement and in which perhaps, as it were, managed ambiguity needs to be retained.
Stephen?
Yeah, I mean, Baja also talked about the Constitution having the dignified and efficient dimensions, and it seems to me that the dignified bit translates into what I was calling the popular bit of the Constitution, the symbolic part. And again, if we came to the process of drafting a codified Constitution, the monarchy would arise, because to what extent does the monarch as head of state symbolise a focal point of identity for the country? Well, it does for many, but it would be a particular problem in Northern Ireland, for example, in terms of drafting a new constitution in that respect. And actually, the political constitution has been quite good at managing that. So the Church of Scotland Act, I think in 1921, expressly provides the Queen is not the head of the Church of Scotland. So the political constitution has managed the sort of dignified part in subtle ways. I think what's very important is that we move away from the monarchy being involved in the efficient part. And we thought we largely had with the fixed term parliament. But we've seen recent examples, I think, of dangerous discussions. So there was the prorogation case. Should the Queen have been put in that situation? Could she have refused prorogation? Some talk about refusing royal assent. Bonkers views being put forward in that respect. And now potentially the Queen being brought back into dissolution discussions with the repeal of... So I think those things, you know, we could call it codification or otherwise, but I think those are things that should be removed beyond the role of the monarch.
Sorry, do you want to come back on that point, and then I'm going to come to Jeff? But yes.
Oh, just a very brief point. Constitutional monarchy is a particular form of a constitutional... I think it's a time-limited form. So sooner or later it goes wrong, because the monarchy is meant to stand apart from politics, and that sounds like a really interesting, easy job to undertake. And the Queen has been fantastic at doing that. She's performed her role in an exemplary fashion. But it's actually a really difficult task to remain politically neutral whilst you're appointed to your office by right of birth and live in a mansion and wear a crown. So sooner or later in a constitutional monarchy, somebody comes along who lacks the skill to execute that role. And one day we're going to have to address this. Sooner or later we're going to have somebody who's by right of succession the monarch, but isn't temperamentally suited to undertaking that role.
And might that trigger wider constitutional issues?
I'm not sure that would be the trigger point. I mean, first of all, there's no problem to have the monarchy written into a written constitution. That is the case in many countries. The actual political position of the monarchy in this constitution reflects much of the balanced constitution, actually. The coronation oath is very interesting to have a look at. It reflects this relationship that has evolved between the Crown and Parliament. And functionally, the monarchy takes the PM off a pedestal in a certain way. It provides a certain degree of humility to the post of Prime Minister, the office of Prime Minister, which I think is important. So it's a slightly difficult question. I would probably myself prefer to not live under a monarchy. I would. But in this process, I think that it should be discussed, but it won't go anywhere for two reasons. First, republicanism is just not popular in the country, as far as I'm aware. And the complexities are quite significant, especially for the Commonwealth, but also for the established church, and then the way in which the Crown serves as the vehicle for the execution of so many functions in the Constitution. And the combination of that unpopularity and that complexity, I think, would sink the whole project.
One of the challenges, and we've touched upon it in various contributions of any sort of codification of the Constitution, is how you change it. And from the Canadian perspective, this has been deeply problematic. How would you, in the context of the UK, propose an amending formula for the Constitution that would most likely, if not overcome the issue of winners and losers, which is inevitable, but at least perhaps get losers' consent?
I think that a formula which is that there would be a constitutional bill put before Parliament through a special parliamentary procedure, which if passed by a simple majority, would thereafter be put to a referendum. That this procedure is appropriate, it's not supermajoritarian, and it would have to be taken very seriously, so amendments wouldn't be done lightly. And I think that constitutional referendums, despite their lack of popularity now, are appropriate and defensible, and I commend Stephen Tierney's work on this. I don't know if you've changed your mind on constitutional referendums, Stephen, but I think there is a role for them in the Constitution.
But on a UK-wide ballot, or one that has and requires majorities in different parts of the UK?
I think that the amendment of the devolved portions of portions of the Constitution dealing with devolved legislatures and territories would need its own bespoke procedure, probably at the very least with concurrent majorities, in any case, probably with a veto right in that, of the people in that territory.
Okay. Stephen?
What I was interested in, Jeff, do you don't mind if I ask Jeff a question?
Of course, go ahead.
It's not so much in terms of how the Constitution would change, like, but how the codified Constitution would come about in the first place. Because I think you see a role for a kind of constitutional convention. Would that be fair?
Yeah.
Could you maybe, I think people would be interested in...
So I think that in that process, the UK government and Parliament would need to be consulted, but should not have a veto power over the process, because both are dominated by single parties, and I've already explained why I think that's a problem. It would probably follow then that the devolved governments and assemblies, parliaments, in the two cases of Wales and Scotland, would also be consulted, but would not have a veto right. And so I think this is where Stephen would take me to task. I think that the citizens of all parts of the UK should elect from the parties in those areas, as I said, on a closed list proportional representation basis, so the parties could put forward their luminaries for election, and that the 2/3 of the assembly would be composed in that fashion, 1/3 through sortition.
Yeah, interesting.
But that does go back to the issues that you were raising, Stephen, about who are the we, and the inevitable asymmetries of the UK make that quite difficult to generate consensus, don't they?
That's my sense, you know, and I think there are, I mean, look, this is no secret, there are political forces in the UK now who wouldn't want to make it work.
Indeed.
Yeah.
You know, and they're powerful forces. And were there to be a referendum on this new UK constitution, others might well use that as a vehicle to put forward referendums on something else. You know, and it's like, a nice constitution, but not for us. Thank you. You know, so that would be a possibility.
Yeah.
I'm also interested in the convention process. I mean, I think this is so. Some, you know, the Australian model when they had the convention on a republic used the parties plus popular election. So they used a mix of civil society plus political parties, and it seemed to me that was a more realistic approach than the Canadian approach to electoral reform, which went down just citizens' assembly route.
Absolutely.
Which risks so much elite capture. And also then, in my experience of the Canadian system, when it came to the referendum, it was very hard to move from that micro process of a little citizens to get buy-in from the public.
Exactly.
So that's another big issue, how you get the public who are going to vote in the referendum to take an interest in this. Yeah.
Indeed, and I think it would have to be through political leadership, and I think that would be absent if the parties didn't. But I think the case for the parties having a predominant role in the process is not only for political buy-in, but also because politicians have expertise in the art of the possible. And it's important that that actually predominates. The key, I think, is that the formula is such that neither in this constitution, the Conservative Party or the Labour Party can dominate the process.
Well, one of the values of the citizens' assembly type approach is the learning part of that and the deliberation that goes with that too. And that's a positive, isn't it?
Indeed.
There are experiences from Southern Africa with citizen buy-in and civil society buy-in?
Yeah, but one comment first on citizens' assemblies, which we didn't use at all, is that I think very multi-issue kind of problems put to citizens' assemblies are much more difficult than more limited ones, because clearly the array of things that have been talked about are very difficult. And it's the same problem with the referendum very often. And one has seen that in some jurisdictions where a constitutional Bill of Rights, for example, was put to a referendum in Zambia and failed. probably because of dissatisfaction with just small parts of the Bill of Rights. And this can lead itself to kind of a political kind of dog in the manger attitude, which doesn't necessarily mean that people don't broadly support it, but there's one or two elements of it which have become very controversial. So I think multi-issues before citizens' assemblies can be very, very difficult. In the South African experience, and outside of Zambia, generally in the Southern African experience, there are relatively little use of referenda. It's generally through either forms of citizens, conventions, not with sortition. I think Jeff's idea of sortition, in other words, having sort of, as it were, kind of jury service for a portion of it, where people are identified, it's a little bit like mixing a citizens' assembly into the convention, and will give a kind of vox pop element to it, which might be very valuable, and also make ordinary people feel somewhat connected to the process. And we have seen that in citizens' assemblies, for example, in Ireland, where ordinary people watched the process and actually began to trust in the process. And there's really interesting data that came out of the abortion referendum, which suggested that people who were uncertain about how to vote in the referendum were influenced by the way in which the Citizens' Assembly had concluded and actually voted in the same way. So I think that can happen with the use of sortition in the process. As I say, I think I am more cautious about referenda. They're clearly a legitimizing exercises, but it doesn't seem to me that they're necessary legitimizing exercises. I think they can at times become particularly in multi-issue things, very, very difficult and problematic in divided environments.
I'm going to come to you in a minute, Nick, on the spot, but I want to bring Stephen back in on that particular point
referendum.
There on referendums, because we saw in 2014 the experience of quite a deliberative process combined with a referendum that did seem to inform, and you did a lot of work on that.
Yeah, I think I would agree with Jeff on this, and maybe not so much with you, Kate. Precisely, I think a referendum in a very, very contested polity is very difficult because you have to get the self to agree to vote. But the self can vote on a contingent basis. It needn't agree we're all British or we're all, in the Northern Ireland example. But you can agree to vote for an issue that elites have got together and agreed on, contingently, parking your identity, and maybe not forever. So the two sides voted for the Belfast Agreement. It didn't mean they were relinquishing long-term claims to reunification. But for that moment and for that time, they were agreeing. And I think it lent a legitimacy. Northern Ireland hasn't been great since 1998, but I think it would have been a heck of a lot worse if there hadn't been a cross-province referendum in which clearly a majority of, and that wasn't a part of the official numbers, but clearly a majority of both communities, in very different proportions, voted for it. So my sense is very much with Jeff that a referendum might be very hard to hold. If you do it badly, it can be disastrous. If it's seen that one side wins, and it can polarize like Bosnia. But for something as big as this, I think it's the only way to legitimize something.
Nick, Kate was saying that referendums or citizens' assemblies are quite difficult vehicles for something like a constitutional change or a codified constitution, which is a multitude of things, and that resonates with the point that you were making earlier about how it's better to deal with things in a piecemeal fashion rather than all at once. And we have a really interesting question here by someone who remains anonymous, saying, agreeing with you that it would be better to take on the big questions piecemeal, but how do you get the pressure to make that happen through a constitution? How does it happen unless you initiate a process? And you're right about your earlier point about a lot of this is really about people wanting constitutional change. I remember as a student, I'm sure my age here, but it was all the Charter 88 things, and it was all about, in the name of a written constitution, wanting change. But how do you get to that point if you don't have an exercise like this?
That's a good question. Can I first say, we've all been discussing Jeff's paper during this panel, and I think it's worth saying, I think, Jeff, your paper is available on open access, isn't it? And it's extremely well written and clear. So it's
Thank you.
Jeff King, is it the democratic case for a written constitution?
Yes.
So I disagree with every single line of that article.
Excellent.
But it's an excellent paper, and I would strongly recommend you read it if you're interested in the question of a written constitution. Now, we've seen a number of problems, I think, with a written constitution coming forwards, both in terms of how it's produced and what it contains. And I think this bundling worry is a real one. If we review the entirety of the Constitution in one go, we treat House of Lords reforms, voting, devolution, federalism, Human Rights Act, all of a bundle, and then we present it to people in a referendum, and they have to either take it or leave it. And I think that is problematic, and for the reasons Kate gives, it can sometimes mean that good, sensible constitutional reform proposals are lost because of a few outlying things that draw the attention. How do we galvanise people's enthusiasm? How do we make people care about constitutional reform? Well, firstly, I don't think we should be too worried if they don't care about constitutional reform. Maybe they don't care about constitutional reform because they don't think it's the most important thing the government should be doing. Jeff told you about an opinion poll earlier on which asked people, do you think we should have a written constitution or not? And Jeff tells us the answer was yes. But perhaps a more significant poll would have been one where people had to list the things they thought were important. Reforming treating the deficits in the NHS, for example, inflation, house prices, the public sector, the crisis in the public sector. And if we had a list of issues of importance, where they put a written constitution on that list, and I bet it would be right at the bottom, even if you managed to scrape into the top 10 or the top 20. And that's because this isn't what the state should be focusing its attention on. There are other issues that are more pressing. And creating a written constitution would suck in an enormous amount of political energy and political time and would distract us from these other issues. Now, having said all of that, and having argued against Jeff's proposal, and having pushed you against written constitution, there is one area where I think there's a good argument to be made for the creation of a written constitution, and that's in the area that Stephen is an expert in, federalism. So I think if you think that we need to move towards a federal settlement for the United Kingdom, maybe we would need to have something very like a written constitution to make that possible. And I was, as it were, defending the popular apathy about the question of a written constitution a moment ago. There is one area in which I think the popular apathy is seriously misplaced, and that is the question of the English. And I don't know if Vernon Bogdanor is still listening to this, but this is an issue Vernon has written about at great length. So the lack of devolution to England is a time bomb waiting to explode in the devolution settlement. The West Lothian question is one that people radically underestimate. I'm sure you all know what the West Lothian question...
No, it's just I'm conscious of time.
Ooh.
And that could open a whole other can of worms. So we have come to the end of our time, and there is a keynote waiting. So sorry to cut you off there in your prime. There was what I take to be a rhetorical question there at the end about perhaps the antipathy to a written constitution was because of the role of constitutional lawyers, like those distinguished in interpreting the constitutional arrangements, although I think regardless there would be a critical role for constitutional lawyers anyway, and I am absolutely grateful to have them playing that role. So if everyone can thank the panel in the usual fashion, thank you very much.
Thank you, that's great fun.
of introduction. Her biography is a biography of firsts. The first woman from her school, Richmond High School, to go to Cambridge. Do you not get into Oxford?
I was on the waiting list to go to
Okay.
Oxford.
There we go. Confirms all my prejudices, I like that. The first woman appointed to the Law Commission. In 2004, she became the first and only woman law lord, the first woman deputy president of the Supreme Court, and then the first woman president of the Supreme Court. After the prorogation decision in September 2019, she was dubbed by some the Beyoncé of the legal world, which I think is a good thing, and had a double-page spread in Vogue, it says here. Congratulations. Lady Hale hails from Leeds, which, as you know, is a small suburb of Wakefield. Now, interesting, I mean, we have this group from Batley High School here today, and actually I want to start with them because they're a group of young women from a sort of very disadvantaged background, and I just wondered, I don't know if you said this to them or not, but what would you say to a group of people like that about how you achieve your goals and ambitions regardless of where you're coming from?
Well, I was more or less asked that question, and it's one I'm often asked, but by various different groups. And I start by saying, find something that you enjoy doing. Because it's really, really important as a young person to find something that really enthuses you, that you like and enjoy, because that enables you to put up with the boring bits, you know, and there are boring bits in the law, but most of it is great, good fun. And if you enjoy it, well, then you will work hard at it. And if you work hard at it, you'll be the best you possibly can at it. But the reverse is also true. If you don't enjoy it, you won't work hard, and then you won't be the best you possibly can at it, and it'll be a... So there's a virtuous circle and there's a vicious circle. I didn't put it in quite those same terms, but that's more or less what I say.
Okay. I mean, it's unusual in this country, isn't it, for judges to write memoirs, and sort of even less common is the fact, I think there's a children's book about your life. What is it about your story, you think, that fascinates people so much?
Well, I don't know the answer to that. The children's book was the idea of a child of the woman who is chair of the Legal Action Group. And she had seen the book about Ruth Bader Ginsburg's life. And she apparently said to her mother, well, don't we have anybody in this country about whom a similar book could be written? It was a picture storybook. And mother thought, oh, yes, well, possibly we do. I'll better go and ask Brenda what she thinks of the idea. And so it was a money-spinning exercise for the Legal Action Group, which is a cause very dear to my heart. And so, of course, I encouraged them to go ahead with it. And they got a brilliant author and a brilliant illustrator to do it. And it is a really lovely book. And I have read it to several groups of primary school children, and they've all enjoyed it a lot.
Wow.
So
sort of the ultimate accolade in a way, isn't it?
It's wonderful. It's absolutely wonderful because it's not really about me. It's about a little girl from my hometown who goes with her class on a visit to London, and as well as going to the Eye and various other things, they come to the Supreme Court and they visit the Supreme Court. And of course, I walk into the cafe and we talk about the sorts of cases I do and the sorts of things that I believe in.
Actually, I don't know if you've read it, but Fiona Hill, who worked in the Trump White House, has written a memoir.
I know who Fiona Hill is, yes.
But it's well worth... I mean, actually, we've got an event with Fiona Hill coming up, so let me flag that for those of you who are interested. But her memoir is very interesting because she talks a lot about growing up in the North East, in a working-class family.
Well, she comes from Bishop Auckland.
But in your book, you mentioned the fact that you have a strong attack of imposter syndrome when you first sat as an assistant recorder. And I mean... Many in my profession, many academics, whether secretly or less secretly, suffer from exactly the same thing. And how do you overcome imposter syndrome?
Well, it struck me at various times in my life. You know, when I first went to the high school, when I first went to Cambridge, when I went to the Law Commission, I think possibly the most. We didn't call it imposter syndrome then, but you know exactly what it is. It is, what am I doing here? Can I really cope? To which I think my answer has always been, well, I wouldn't be here if somebody didn't think I could cope, because that's why I'm here. So it's my job to prove them right. And if I can't prove them right, well, then they were the ones who made the mistake.
I might try that myself, actually.
Just, I mean, let's turn to the judiciary now and to legal matters. And on your retirement, one of your colleagues described you as a feminist, frank and fearless. Have attitudes towards women in the judiciary changed during your lifetime? And if so, how? And how far is there still to go?
Well, the numbers of women in the judiciary, of course, have changed quite dramatically, because the first woman High Court judge was appointed while I was an undergraduate. And I was only the 10th by 1994. So you can see that things have changed very dramatically in terms of numbers. As far as attitudes towards women in the judiciary, that's much harder to gauge, because I think that all women, when they start breaking into a male-dominated profession, have got to decide what style they're going to take. And the first two women High Court judges couldn't have been more different. The first one, Elizabeth Lane, looked and behaved and sounded as much like a man as she possibly could. Mm-hmm. Whereas the second was Rose Halbron. And Rose Halbron, nobody could ever be in any doubt, even if she was all dolled up in judicial robes, that she was a woman, and indeed a very beautiful woman with a very beautiful speaking voice, and she made no secret of her femininity. And I think that first women have often got to choose which of those styles they adopt. And there are risks with both of them, because obviously trying to behave and look and sound like the men is denying your femininity, and it's also not giving the message to the world that women can do it as well as men. But if you do let your femininity show, you can be accused of trading on it and being flirtatious, when actually all you're doing is being you and friendly. So both of these have got dangers, but you do, on the whole, I think, have to adopt. And I have always tried to be quite clear that I'm a woman. And indeed, my successor in my valedictory said that something was a symbol of swashbuckling womanhood. So I reckon swashbuckling womanhood is even better than being Beyonce.
Well, that's a pretty good testament, it has to be said. But I mean, so this is all linked to the question of the diversity of the judiciary. Does it matter that the judiciary sort of looks and feels a bit like the population over which it presides?
Yes.
Why?
For that reason. Because the judiciary preside over the courts. And the courts are or should be there for everyone. People should feel that the courts are their courts and that they're there to get justice for everyone. And they're not just staffed by a small elite group of people, beings from another planet, which it often used to feel like. And so for democratic legitimacy, I think it's very important that the courts are as diverse as it's possible to be, obviously, consistently, with getting people who know a bit of law and have judicial qualities. You know,
And what would you suggest is the best way to get more women into the judiciary or get more people from BAME backgrounds? Because there's a problem statistically in both areas, isn't
well, women, it's hugely better than it was. I mean, absolutely hugely better. We're now up to 39% of the courts judiciary, 50% of the tribunals judiciary, though that includes a lot of fee-paid part-timers, so it a bit skews things. Probably over-represents women in a way. And in the High Court and above, it's only 29%.
Right.
So it's not as good as it should be, but my goodness, it is so much better than it was 20 years ago. And progress is being made. And the major progress has been recognising that there was a problem, not just thinking, oh, well, it'll all sort itself out in due course. Having the Judicial Appointments Commission independently, having a proper applications and recruitment processes, not the old tap on the shoulder. I mean, I did very well out of the old tap on the shoulder, thank you very much, but it wasn't right. And having proper merit-based assessment processes is the right way to do it. And it has resulted in there being more women. And the minority ethnic situation is pretty good in tribunals.
Okay.
In the tribunals, I was told by the then senior president of tribunals, so we're talking probably about 3 years ago, that the proportion of women and of ethnic minorities in the tribunals judiciary roughly mirrored the proportions in the working population of the appropriate age group, comparable age group, which I thought was a pretty good achievement. It's obviously going a lot more slowly in the what we call the uniform branch. Yeah. It's the robes wearing courts, yeah. There is obviously a way to go. But of course, one of the difficulties with ethnic minority lawyers is that they're not all the same. There are many different ethnic minorities, and the barriers to advancement that each of them face are very different. So we can't just lump it all together and say it's a BAME problem. I think it's more subtle than that. And of course, the same is true of socioeconomic background, which is another dimension.
But would you favour a system of sort of more aggressive sort of positive discrimination?
I don't favour positive discrimination in the sense of you've got two candidates and one is better than the other, but you pick the less good one because they come from a disadvantaged group. I don't favour that because I don't think it does that person any good, and it doesn't do the rest of us any good. But what I do favour is all sorts of ways of trying to bring on people from less well-represented groups and recognise the merits that they do have and recognise potential. And so you have to find ways of assessing potential, which is much harder to do than assessing current achievement. But they're working on it, and I think they recognise that it is necessary to try and fish in different pools from the ones they've been fishing in. So there are all sorts of things that you can do to improve matters without going to that length of favouring somebody who's less well qualified or over somebody who is better qualified.
Okay, now over the last decade or so, we've seen a whole load of changes to the legal system, one of which is financial. The MOJ's budget is about 25% lower in real terms, I think, than it was in 2010. What's been the implication of that for our legal system, do you think?
Well, all sorts of things. If anybody's been anywhere near a court recently, you might have noticed how dilapidated they are.
I've never been in a court.
Well, you are to be congratulated. Yeah.
Surprisingly, that might seem.
Yeah. No. No, you look like a respectable person to me. You might have been called for jury service. And then, I mean, my daughter's partner was called for jury service quite recently down at Southwark Crown Court, and she said the whole place was really a complete disgrace to a justice system that is self-respecting. So, you know, it's the whole court estate, the infrastructure. Too many courts have closed, so that the whole idea of local justice, where I come from in North Yorkshire, do you know, I come from Richmond in North Yorkshire. We used to have a magistrates' court in Richmond, and then they closed that, and everybody had to go to Northallerton, and then they closed that, and now I think they expect everybody to go to Harrogate. There is no way you can rationally get from Richmond to Harrogate by public transport. It's just... So local justice has suffered. Court sitting days have suffered. So the backlog that was well established in the criminal justice system before COVID made it even worse. And that was through cutting down on court sitting days. Of course, the lack of access to public funding for legal services, the people who need it, the whole LASPO, large areas of particularly civil and family law being taken out of the scope of any sort of public funding. I mean, I can understand trying to restrict people going to court, but what is much more difficult to understand is restricting the first help and advice that everybody needs if they have a legal problem, which can usually nip the problem in the bud by sensible letter writing, phone calling, negotiation, and so on. So that's, I could go on.
Well, just to pick on a couple of...
You could get onto the prisons and the probation service, you know.
Just to pick on a couple of things. I mean, firstly, we've seen quite a few innovations because of COVID, not least things happening online. Do you think that might be a way forward to sort of addressing some of the problems. You talked about distance that
Yes,
people have to travel.
yeah.
I mean, do you think some of those innovations should be held on to going forward?
Oh yes, there's no doubt that there are quite a lot of things that we used to do in person and didn't need to be done in person. But on the other hand, we've got to hang on to doing in person those things that do need to be done in person.
Yeah.
I don't myself think that it's acceptable for a mother to be deprived of her children over the phone.
Mm-hmm.
And that has been happening. I think contested witness actions where somebody is trying to get at the truth, or indeed contested family actions where you're trying to get at the family dynamics, you really need to be in the room or reasonably closely in the room for the judge actually to be able to work out what's really going on. But on the other hand, a degree of separation is good in domestic violence cases, for example.
Mm-hmm.
So there are ways in which the technology can be usefully and creatively deployed, but there are some red lines, I think.
Yeah, so it's not all or nothing.
No, it's not all or nothing. It shouldn't be all or nothing. And the other thing, of course, that would be wonderful if we could do is digitise court processes to a greater extent than has already been done, so that a litigant in person, can go on a website and sort of type in, this is my problem, and be told, well, this is what you need to do, and you fill in this form here, and then tick these various boxes, and then it leads you on to the next thing and tells you what documents you've got to file, and when the other side says something, it tells you what you do in response. I mean, that is not beyond the wit of person. It's just very expensive to set it up. But we could do an awful lot of that, and it would save huge amounts of the costs of the justice system.
Yeah, it would save money down the line, wouldn't it?
Yeah, it would.
Definitely.
But it would cost a lot to do it in the first place.
Yeah. You touched on legal aid as another aspect that has been a sort of victim of the sort of cuts that the legal system have seen. Are there tweaks that can be made to improve access to justice? And what would you like to see changed?
Well, I think, and I do think that every Secretary of State for Justice, since the major cuts happened, has been trying their best to claw a bit back for the system. But I think the most important thing is to try and find some way of getting people in initial civil and family problems access to help and advice and help. As I say, writing the odd letter, or email, of course, lifting the phone, talking through, well, why are the rent arrears? It's because the housing benefit hasn't come through or hasn't been properly calculated. Can we sort that out? And can we stave the landlord off for us while we sort that out? That sort of thing. With family problems, sitting down and working out what people really want, telling them what the court's going to be interested in. Mm-hmm. So there's no point in going to court to fight over that because the court's not going to be interested. Let's see what you say about the things the court is going to be interested in, and then we'll talk to the other side and see if we can hammer something out. Okay. That's what family lawyers used to do all the time. They didn't take cases to court unless they absolutely had to. What they did was sort things out. And it's getting back to a way of enabling both parties to have the help that they need to sort things out.
Now, criminal barristers, of course, have voted to go on strike.
You mean barristers in the criminal justice system?
That's exactly what I meant, yes. Me and lawyers. Those people you just mentioned have voted to go on. So what's your feeling about that? Do you think they should? Are you supportive?
I think I'd rather dodge that question. Because, I mean, the one area where there still is some legal aid is in the criminal justice system, because the government knows they've got to supply that. That's part of their international commitments to supply that. But, of course, that doesn't mean to say that they've got to supply it at any particular price.
Right.
And so there are bound to be disputes about the price that's paid. And there isn't a lot of doubt that it's very difficult to sustain a criminal justice practice if you're in the general standard run of criminal cases. I mean, there are certain highly paid cases, certain big money cases where people can make a lot of money, but your ordinary barrister practicing in criminal law is going to find it very hard to make ends meet.
Yeah. Okay.
And so I have sympathy for their cause. Whether going on strike is the right way to advance it, that's what I don't want to comment on.
Okay, that's fair enough. That wasn't really a dodge, that was an answer, so that's fair enough. Now, obviously, when it comes to sort of big questions of constitutional law, we've seen a sort of unprecedented period over the last 5 or 6 years of sort of, in some cases, what looked like open warfare against judges, the enemies of the people headlines and things like that. Have you been surprised by some of the ferocity of the attacks on the judiciary, and whose job is it to stand up for judges? Was it your job when you were at the Supreme Court? I mean, who speaks for the judges?
Oh, well, the member of the government who has a statutory duty to uphold the rule of law and the independence of the judiciary is the Lord Chancellor and Secretary of State for Justice. And by and large, they've been pretty good at it, by and large. There was a script that could so easily have been written after the famous Daily Mail headline.
Yeah, so that was Miller 1.
Enemies of the people. And it goes something like this. We have a free press in this country. You are entitled to do what you've done. It's not against the law. But it's my task, as the member of the government who is sworn to uphold the rule of law and the independence of the judiciary, to tell you that you are wrong. These are not enemies of the people. These are judges who have sworn a judicial oath to uphold the law, and that's what they have been doing. And if by any chance they have reached the wrong result, well, then the Supreme Court can put them right. Really simple, not difficult to do, because it accepts that we have a free press and freedom of expression, but it says what they have said is not accurate. It's unfortunate that didn't happen, but it was all right. It did sort itself out by the time it came to us. I was really quite impressed. You know, the press are very, very clever. The Miller 1 case was 11 judges, and it was 8-3.
Yeah.
Now, we didn't disagree about the principle, which is that the government can't change the law. Only Parliament can change the law. The disagreement was whether the European Communities Act, 1972, contained in its own wording the seeds of its own destruction. And there was a perfectly respectable argument that it did. It just didn't make sense to 8 of us that this is what Parliament was doing when it introduced a whole new source of law into English law and so on. So what, of course, the Daily Mail did was that it had same-size portraits of the 3 dissentients with the headline, Champions of the People. Wasn't that clever?
Do you think things are qualitatively different now? I mean, I remember under New Labour governments, ministers talking about unelected judges as if this somehow affected their standing.
Well, I think that, I mean, things did get really febrile during the whole Brexit debate, and so feelings were heightened. Even though the judges weren't deciding on Brexit, that wasn't what we were deciding at all. But people didn't see it in that way. And I think the other thing that's happened, which wasn't the case in the olden days, is social media. And most of the judges I know don't do social media at all, but of course politicians have to. And so it's tricky. We don't know what's going on in the Tritosphere, really, and that's probably just as well, because we have to get on with the job that we're sworn to do. But so I think those 2 things, one is temporary, that's largely gone now, but the other is permanent, have sort of upped the ante in terms of possibly attacks on the judiciary. But it's happened before. We have to carry on doing the job.
I mean, it's interesting what you say about Twitter, because I wonder sometimes whether actually part of the response to the problem is if judges became more accessible, better known, you know, under you, the Supreme Court rose as a sort of in prominence as an institution. I wonder whether actually sort of lifting that veil of secrecy a little bit would help.
Well, I don't think we're secret.
No,
Come on.
But just communicating.
We're not
sort of
getting
more...
on to family courts here, but let's... well, the Supreme Court does tweet. It does have a Twitter feed. It's just the individual judges don't.
Yeah.
And I think that's probably wise, one way or another. I'm all in favour of as much transparency as we can possibly do. The Supreme Court has been filmed since its outset. We were exempt from the ban on filming in court from the outset. We were set up with cameras in each of the courtrooms, and very soon, as soon as we could, we live streamed our proceedings. And sometimes, of course, in a high-profile case, it's also televised, but mostly live streamed. And you can now go back and look at all of our really boring hearings. Because, of course, most legal argument is, unless you know the documents, you know the case, you know the people, is pretty tedious. But I still think it's important that it's out there, the public can watch, they can see. I would like us to be able to publish the core documents in the case, but there are kind of data protection issues there and cost issues there, which have so far made that difficult to do. But really, I think they should be out there as well, so that people can follow the case from the written arguments as well as from what they're seeing on the screen. So I'm all in favour of as much of that as possible, and I think it's had a beneficial effect. I actually think the televising of both the Miller cases did have a beneficial effect, because people could see that we were arguing about serious constitutional issues. We were not arguing the pros and cons of Brexit. We were arguing about what the role of Parliament was and what the role of the government was in both cases.
I mean, do you think citizens understand the law and the role of the law and the place of the law sufficiently well? I mean, some people suggest that actually what's missing here is a better educated population. You should do civics. People should be taught this sort of thing more systematically at school. Do you think they've got a point?
Absolutely certain they've got a point. I think in most other countries, the people do learn in school the basics of their constitution, what the functions of government are, who does what, and what the relationship between them is, and what the fundamental principles are. I think most people do learn that in school, but it doesn't seem to happen in our own schools, and I think it definitely should.
Okay, there are some people also who've suggested that one way to get around this problem for those who see the judiciary as somehow illegitimate is to have greater political say in the appointment of judges. What's your feeling about that?
Well, it's really interesting, isn't it? Because until the Judicial Appointments Commission took over, the appointment of judges was the responsibility of the Lord Chancellor. In other words, it was solely in the hands of a politician. But it has not been thought that the judicial appointments were actually made on political grounds since the Second World War. I got my first 2 judicial appointments from a Conservative Lord Chancellor, and my next 2 from Labour Lord Chancellors, and then the final 2 on a merit-based application process, not the tip on the shoulder.
Okay.
So, I think that demonstrates that the system, even in the days when it was done by the Lord Chancellor, was not motivated by party political considerations, which I think is really, really important that it mustn't be. And it's a rather secondary consideration as to who does it. But I do think that the independent merit-based system that we currently has improved the diversity of the judiciary. And there is a genuine issue as to whether the role of the Lord Chancellor has now been too diminished. Most of my former colleagues would be horrified to hear me say that, because they are much more comfortable in a system which is completely divorced from politics than in one which had really any political involvement, particularly now the Lord Chancellor is a member of the House of Commons and a much more active politician and not a senior lawyer. But I do think there is a bit of a problem of, or possibly a problem, and I think the UCL Constitution Unit has highlighted this, of a sort of lack of political buy-in to the justice system, because there's no longer that link. To which I tentatively suggested some time ago, to much horror, that, well, why don't we expand the 5-person commissions who recommend the appointment of Supreme Court justices by 2, a senior politician, both from the government and from Her Majesty's loyal opposition, so that it wasn't party political, but you actually had some parliamentary buy-in to the process.
Okay, the political scientist in me wonders that at a time when politics is as polarised as it is now, whether your experience that you had with both Tories and Labour would be the same now, because I mean we live in, you don't have to answer this, but we live in an era when
we don't know, do we? No, we don't.
When, you know, the government's interested in museum boards.
Well, that's why I say that even reintroducing that bipartisan element of political buy-in, it is very controversial amongst all the judiciary, who are much more comfortable with the present setup.
Now, one of the things the previous panel today talked about was whether or not we need or should have a written constitution. And I just wonder, purely from the perspective of the judiciary, whether the role of the judiciary would be made easier if we had that kind of written text.
Well, I think the answer to that is almost certainly no.
Okay.
In most places where there is a written constitution, the judges have the power to strike down unconstitutional legislation. That's a feature of written constitutions. In fact, I can't instantly think of one where that isn't a feature of written constitutions, although I did listen to some of the discussion and it doesn't have to be. But I don't think the judges in this country want to be able to strike down provisions in acts of the UK Parliament. I think they're perfectly comfortable with the balance that we have between the sovereignty of Parliament and the rule of law at present. That's what I think. So, and the second aspect of this is that we are familiar with written constitutions in the Judicial Committee of the Privy Council, of course, where we still have jurisdiction over a couple of dozen countries which do have written constitutions, and so we have experience in trying to interpret them. And the really difficult demarcation questions that arise don't necessarily get answered by any written constitution. There are always gaps. They don't answer every problem. I don't know a written constitution that would actually have answered Miller 1 or Miller 2 in so many words. It would have to be written into, you know, how does the power of the executive interact with the power of the legislature, and what is the balance between. And although they tend to say there shall be a legislature which shall do this, and there shall be an executive which shall do that, they wouldn't answer those really difficult demarcation questions. So I don't think it would make life any easier. No.
When it came to Miller 2, did you realise at the time that you were sort of making political history that this would lead to the sort of reaction that it did lead to?
Well, we knew there was an intense public interest.
Well, there's a crowd outside.
Yes. Yeah. Well, there's a crowd inside, and a crowd outside, and a crowd outside. So yes, of course, it was intensely interesting. I think you have to get on with the job without thinking about what the reaction may or may not be to what you decide. And so you have to be largely oblivious of that.
And was it helpful that Miller 2 was a unanimous decision?
I think so.
I mean, as compared to the experience of Miller 1.
Yes. Well, I understood entirely where the minority in Miller 1 were coming from. But no, I do think that it was a very good thing that we were unanimous in Miller 2. After all, everybody knew what the argument was, because we'd got a case from England saying one thing, and we got a case from Scotland saying the opposite. They couldn't both be right. So we had to choose between them.
Yeah.
And so everybody was fully aware of what the argument was. I mean, we agreed with Scotland in the result, though not exactly the same reasoning, but quite close to it. It was a case that we didn't have any choice over. We did actually have to decide it. That's one of the things about judging. You know, you got to decide.
Now, I mean, one of the outcomes of the 2019 election was that we got a government that seems to be committed to reform in some ways of our judicial system. So one way
change?
is, replacing the Human Rights Act, for instance, is something we expect to be in the next Queen's speech. What do you think that might mean? What is your sense of that?
Well, I've read the consultation paper and I have responded to it. So I'm not sure I want to do anything other than express what I put in the consultation paper, which is we've got a Human Rights Act which works perfectly well at present, and there are possibly one or two comparatively minor changes that might be made, which were recommended by the independent Human Rights Act review, which did a very thorough job of consultation and thinking and workshopping things, came out with some recommendations which I think make complete sense. Okay, do that. But replacing a whole Act of Parliament with a new one is a recipe for decades of litigation. It's also quite an unnecessary litigation because the government has said we're staying in the European Convention on Human Rights, which means that they've got to allow individual petition to the European Court of Human Rights in Strasbourg, and they've got to abide by the decisions of the European Court of Human Rights. So why replace what we've got at the moment, which is consistent with our international obligations, doesn't seem to have done a lot of harm, with something that could risk actually causing more trouble than it's worth.
And when it comes to judicial review, do you see any potential advantages for the judiciary under the sort of government's plans to reform judicial review?
Well, under the current bill, they are suggesting, as I understand it, and I haven't looked at the most recent version of the bill, so there may be things in there that I haven't got hold of yet. They're suggesting that it should be possible to have prospective quashing orders or to delay the effect of a quashing order. Now, I think we all think that's very sensible. Doesn't mean to say you haven't got to use those powers, but there sometimes are cases where you've found that something is unlawful, but it would be extremely inconvenient for everybody if instantly everything that had been done under it had to be undone. And so there will be circumstances in which that is a useful addition to the things that the courts can do.
Okay. Well, you were absolutely right when we talked beforehand, as I got through about a quarter of my questions in the time.
Sorry, have I been answering too long?
No, not at all. You've been very pithy. We just had too many questions. But time has caught up with us. It is now past, and I know it's been a very, very long day. So on behalf of all of us, Lady Hill, I just want to thank you so much for taking the time to do this. It was absolutely fascinating. And to all of you, thank you so much for being here today. As ever, if you've got suggestions about things we could be doing, events you'd like us to put on, reports you'd like us to put out, just get in touch and tell us. And I very much hope we will see you at our next event, which is, this is the memory thing again, in April sometime. There we go. As on the screen, I can't even turn that far, so there we go. I very much hope we will see you all.
Unlocked with Fiona Hill.
Yes, and Unlocked with Fiona Hill.
Yeah.
But for now, thank you all very, very much indeed. Thank you.